Thank you for being here for day 2 of our Joint Corrections and Juvenile Justice Committee meeting. We are going to start today with an overview on criminal record expungements and associated costs. So we're going to start off with a presentation by Jillian Block. Jillian, thank you for being here today.
Yes, thank you, Madam Chair.
Try that.
I think we're good. Okay. Good morning. No, I'm not on.
It's not sounding on.
Now it's on.
There we
Good
go.
morning, and thank you. As Madam Chair said, my name is Jillian Block. I am with Legislative Research. I'm here this morning to give you a quick overview on the expungement process in Kansas, its neighboring states, and the associated costs with this. If you're looking at the virtual testimony, you'll find it under number 12, Jillian, spelled with a J, Block. And you might find that helpful as there are embedded hyperlinks that can take you to various statutes and some resources that we found. So the overall expungement process is similar in all 5 states. After waiting a certain amount of time that varies by both the offense and the state, a person may petition to get their criminal record expunged. It is at the discretion of the judge themselves, and they might take some things into account, such as the citizenship of the person, if they have any other convictions outstanding, if they have any outstanding fines, similar qualities as that. And there are 2 kind of major deviances from this process. In Nebraska, they actually do not have expungement statutes, but rather you can petition to get an order or a conviction set aside. In practice, what that means is that when someone does a criminal background check on you, you see both the conviction itself as well as the order to set aside. So as opposed to an expungement, which is where it gets sealed altogether. The second one is that Colorado has a clean slate law that passed this year, and that will automatically expunge certain convictions that are older than the, when you can apply for it in the first place. And so that passed this year. Underneath, you'll see that there is a table that goes over the accessibility of the websites explaining how to get your record expunged or set aside, whether there are explicit instructions on the website itself, whether there is a petition that you can fill in the blanks for, how much the fee is, and then whether there is a fee waiver on the website that you can also fill out. And then on the backside, there's some more detailed descriptions about all of those things, but I'll give you a minute to view over that testimony, and then I will happily stand for any questions.
So committee, were you able to find their document? No. Okay. Okay, so go to the committee website. All right. So if you go under kansaslegislature.org and click on committees, and committees, you'll want to click on joint committees. And when you're on joint committees, then you'll want to click on corrections and juvenile justice oversight. Now, once you're there, you're going to see meeting day, on-call time, right under that. So do you see the headline for the Joint Committee on Corrections? If you click on agendas and minutes, you'll see all of the different documents. And hers is attachment number 12. Okay. That's okay. So why don't you go ahead and talk to us a little bit about the $900 or the $195 fee?
Mm-hmm. So the under the asterisks, you can see that it's written out, but Senate Bill 20 in 2019 amended the statute so that the Kansas Supreme Court was able to add $19 to the original fee, which is $176. That $19 that they added is to cover non-judicial personnel, and then that will expire on June 30th of 2025, and at that point it'll go back down to the $176.
Yes, Representative Hoffman.
Thank you, Madam Chair. Now, if I remember rightly, this year we gave the judiciary, SGF, So is this one of the fees that they were relying on instead of that SGF?
That is a great question, and I can look into it and get back to you, but I'm not sure off the top of my head.
Because if that's the case, then it should, I thought it should be going away quicker than that.
Sorry.
Yeah.
I can say that this was passed in 19, and so this was a couple years ago, and so
Okay.
there might have been an additional thing that I will happily look into for you.
Okay, Revisor Thompson.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. And it dates back previous to 19 as well. It's an ongoing surcharge that's been renewed multiple times. It's just that judicial branch, non-judicial personnel. So it's not the judges, it's the non-judicial personnel.
Right, but we gave them that. But I don't remember if we deleted the different fees or if those fees were going to, we were just letting them go. I'm not sure, I can't remember.
Representative Owens, and then we'll go to Representative Carlin.
Thank you, Madam Chair. I think, if I recall correctly, all we did was we now fund them from the general fund. We didn't do anything specific with fees. Those fees now just flow into the general fund instead of to the judiciary. So it basically makes it easier for us to phase those fees out without an effect on the judicial branch. Yep. Thank you.
Representative Carlin.
Thank you. I'm glad that question came up because I thought we did away with it entirely. My question is, this is just the state collects this amount of money.
Yes.
And I worked with the young lady who paid like a lot more than that to get an expungement in Johnson County. And is the county still able to set their own fee on that, on top of the state?
Give me a chance to fact check myself, but if I recall correctly, yes, there's usually an asterisk that each county may add additional fees as necessary to cover their own costs.
So we haven't done anything to fix that yet at this point. That was, I think, I believe when I looked into that with that young lady, it was like 2008 that we had established that, that these counties could add to that charge. So I would like some information on that. Thank you very much, Madam Chair.
Could you share with us a little bit, how familiar are you with Colorado's Clean Slate initiative and with their motion to waive fees?
Yeah, so I did some pretty surface level research, so I'll happily share with you what I know. What typically was coming up when I was looking into clean slate laws or any kind of automatic expungements was that where would the infrastructure to make that happen occur? And Colorado was able to pass that because they had a lot of expungements occur when they legalized marijuana as well. And so that infrastructure already existed and allowed them to do so. Their form waiver that they have is, I believe, an affidavit to have their fee waived, as opposed to Missouri and Kansas that are affidavits to proceed as a poor person, or it's a phrase like that. And there, in Colorado, their fee waiver is linked in their directions. So when you're looking how to get your expungement, there's a link you can click right there. I will say, you didn't ask this specifically, but that is not there on Kansas's page.
Yes, in Missouri it says to proceed as a poor person, which I think is poorly worded. Representative Heiberger.
Yeah, thanks. In Kansas, you can file what's called a poverty affidavit with your application, and if you qualify, you can have the fees waived. And most courts are pretty liberal about doing that. My last one I'm still working on because I drafted the poverty affidavit for the applicant, and he had trouble finding a notary that he could access for free when he wasn't working. So.
Okay, obstacles. Committee, any other questions? Seeing none, thank you so much.
Thank you, Madam Chair.
Next, we have Ann Sagan, Advisory Committee Member on Criminal Law, Kansas Judicial Council. Ann, thank you for being here today.
Thank you for having me. Good morning. I am a member of the Judicial Council Criminal Law Advisory Committee. I'm also the Director of Special Projects at the State Public Defender here in Kansas. Prior to that, I was an attorney with the Federal Public Defender for the District of Kansas, and before that, I was a State Public Defender here in the Shawnee County office. And today, I'm providing testimony just on behalf of the Judicial Council only to give you a little background on the Judicial Council's recommendations regarding expungement, fines and fees, and increasing access to expungement here in Kansas. The study request was brought to the Judicial Council by Kansas Legal Services in 2019, and we completed the study in 2020. At the time of the request, Kansas Legal Services identified the primary reason that individuals who apply for expungement are not eligible is due to fines that they owe. And as an example, they stated that in Wichita in 2018, they did an expungement clinic that had over 800 people reviewed for expungements, and more than 600 of those were ineligible simply because of owing fines and fees on their underlying cases. The fact is that 85% of Kansans who are facing felony charges are eligible for appointed counsel because they are indigent. This means that the vast majority of people with criminal convictions in Kansas live in poverty. Outstanding fines, fees, and restitution impose a nearly insurmountable barrier for those who live in poverty to get an expungement. And under the current law, petitioners are required to have paid off fines, fees, and restitution before they're granted an expungement. And in fact, the waiting period to even become eligible to get an expungement doesn't start until all fines, fees, and restitution have already been paid. This makes it really difficult and frequently impossible for Kansans in poverty to obtain an expungement. And this also creates a cycle where people who are unable to get an expungement are therefore unable to move up out of low-paying jobs and obtain housing because they still have certain convictions that could be expungible on their criminal record, and they are never able to make enough money to actually pay off those fines and fees and obtain the expungement. This creates a two-tiered system of expungement in Kansas, where those who have enough money to pay off the fines and fees can get an expungement, but those who do not have enough money to do that cannot. So the Judicial Council Criminal Law Advisory Committee, which has representation from law enforcement, prosecutors, KBI, the Kansas Attorney General, defense attorneys, and the judiciary and others, agreed that this is a problem that should be fixed and agreed upon a proposed recommendation to bring to you all. This proposal has four main parts. The first recommendation is to amend the statute to allow the expungement waiting period to begin before the petitioner has paid off all of their fines, fees, and restitution for the case. For different types of offenses under the current law, and this would remain the same, there is a waiting period before you can even be eligible to apply for an expungement, such as 3 years or 5 years for different types of offenses. All of these wait times don't start until the person has, quote, satisfied the sentence. Judges interpret satisfied the sentence to mean that the individual has, in addition to serving any prison or probation time that was ordered, also paid off all of their fines, fees, and restitution in the case. So the Judicial Council recommends adding the following language to the expungement statute to say, for the purposes of this section, that's the expungement statute section, the determination of when the person satisfied the sentence imposed excludes the payment of costs, fees, fines, and restitution. The proposal would eliminate the requirement that individuals have completed payment on their fines, fees, and restitution before the clock can begin on their expungement eligibility, and this would increase access to expungement for adults in Kansas who live in poverty. The second recommendation by the Judicial Council is to prohibit the denial of expungement due to the inability to pay outstanding fine, fees, and restitution. And the goal here is to reduce the financial hurdles to expungement for people in poverty and to increase access to expungement. Of note, the committee does not recommend completely eliminating the requirement to pay fines, fees, and restitution altogether. It simply eliminates the ability of the court to deny an expungement solely where the person is unable to pay those costs due to poverty. Also, the proposed language specifically states that, quote, an unwillingness rather than an inability to pay can be used as a factor in denying the expungement. This highlights that the exception is only to be used in those situations where a person is actually unable to pay off their fines and fees because of their poverty. And furthermore, those outstanding fines, fees, and restitution are still subject to collections after expungement or civil remedy. That's the third recommendation of the Judicial Council, which is that the expungement does not remove the petitioner's responsibility to pay that outstanding debt. The debt is still collectible. This is clearly stated in the language that we have proposed, which states the petitioner shall continue to be responsible to fully satisfy any outstanding costs, fees, fines, and restitution related to the arrest. And the fourth recommendation of the Judicial Council is that certain people, including debt collectors, are granted access to court documents in the expunged record to facilitate the collection of the outstanding debt. The expungement statute already enumerates a long list of people and agencies that can obtain expunged criminal records under the Kansas expungement law. This would be modified to include collections agents and people who are owed restitution so that they can monitor and collect on outstanding fine, fees, and restitution even after expungement. Why is this amendment to the law necessary? Expungement is an important tool that increases access to jobs and housing. Expungement can help people get out of poverty, and increased access to expungement can therefore improve the lives of Kansans across the state. This proposal takes an important step towards eliminating the disparity in our current expungement system here in Kansas between those who can pay fines and fees and restitution and obtain an expungement and those who can't because of poverty. Thank you. I'm happy to take any questions.
Committee, what questions do we have on that? We'll start with Senator Corson.
Thank you, Madam Chair. So I have a question and also just kind of something that for the committee to think about as we talk about recommendations. My question is sort of what is my understanding of expungement, and I would say the same thing about diversion, is that part of it is to help facilitate future employment for folks. Many times convictions and things can be a barrier to employment for folks. But what I understand happens is that a lot of folks go through the process, and I would say I'm lumping in diversion with expungement, although I know they're different things, but for purposes of kind of my question, I would say diversion and expungement. Folks go through that process, they get a diversion or expungement, but then on employment applications, they're still being asked to list any convictions even if they were expunged or even if they were subject to a diversion. And so that seems like it defeats one of the principal purposes of diversion and expungement in the first place, because folks are still having to list all of those things on employment applications. So I don't know if you could just talk about that a little bit, what you've seen in that context, help us understand that a little bit more, because to me, it seems like we're asking folks to jump through all these hurdles. They do those hurdles, and then they're still, when it comes to employment, still having to ask to list all of those things. And so I just wonder if, we're actually achieving what is one of the principal goals. So
thank you,
Senator.
Thank you. So one of the actual kind of hard legal implications of an expungement in Kansas is that a petitioner is able to legally state on a job application, for example, that asks, have you ever been arrested, convicted, or have a diversion? You can legally say no, and that's in the statute. And some licenses also you can legally say no. I think your question is that perhaps on some of these applications they're saying, have you ever had an expungement? In which case, I don't know if that requires another law or something to not allow people to ask that type of question on a job application. But under the Kansas laws, if you are asked, have you had a conviction or arrest or a diversion, and you've had that expunged, you can legally answer no.
I wonder then if part of the challenge is if that's just not well known, right? Because if just the average layperson who's reading an employment application, if I know I've been arrested, I went through the process, had some sort of a conviction, I got it expunged, I went through all the steps. But if I'm filling out a job application and it asks me, have I been arrested? I think the average layperson would say, I have an obligation to say yes. I mean, that the correct, ethical, honest answer to that is yes. I don't know that people would really know that they have a legal right to answer that question, no. So I wonder if I don't know how to do that, but I wonder if part of it is just folks are not aware that they can answer that no and being considered that a truthful response.
I think you're completely right that a lot of people don't know that. People aren't digging into the expungement statute or even have the access to be able to look at the expungement statute and see that. This is outside of the sort of scope of the Judicial Council study, so I'm not speaking on behalf of the Judicial Council here, but I think that is why some states have attempted to pass ban-the-box legislation and make that question itself not askable. But I don't know that much about that type of legislation, and I'm not here to speak on that. But I agree, people don't know.
Representative Heiberger.
Thank you, Madam Chair. Did the committee look at making any categories of offenses automatic expungements or look at the criteria for expungement?
You know, we did discuss, I'm trying to remember if that was the same, we had a different study at a different time related to automatic expungements, not this particular study or report.
Could you share with us, so if someone fills out a job application, they have a diversion, it would still show up in the background check, wouldn't it?
Right, so unless they've had that diversion expunged, the arrest record, the court records, all of that is still available. What the expungement does is it seals off that record and you are able to answer questions on a job application like I have not had a diversion. That's the effect, the legal effect of the expungement.
I think for a lot of, we're not talking about juveniles quite yet, but for a lot of juveniles, I know that I had several students when I was an advisor for the Student Media Center. We had students fill out applications and they were just like any other employee applying for the college. They filled it out and then they were dinged in the background check. So I think that's an issue as well for minors. They get the diversion, but it's not been expunged. And so I think we do within our system create those obstacles for them. Committee, other questions? Yes, Senator Fauskadell.
Thank you, Madam Chair. So I hear from a lot of my constituents exactly what you just described, that obstacle of seeking gainful employment and housing. And a lot of them will say, of course, they don't have the money to pay the fine. So a lot of them are under the illusion, I'll just wait 7 years. And they feel that it will automatically drop off. Can you comment on that?
No, your fines and fees go to collections. I don't know about any 7-year timeline that I'm aware of.
So talk to us a little bit about fines, fees, and restitution. When you were looking at this and coming up with these recommendations, were you able to quantify what amount fines, fees, and restitutions amount to at this point in time?
I don't know. I don't know sort of the average amount off of the top of my head. I think that restitution obviously is different for every case.
Correct.
Fines and fees, I think usually amount to a couple $100s, but I am not certain about an answer. I don't want to give you a number off the top of my head.
My assumption is restitution is going to be the largest portion of.
It could be, some cases have no restitution,
Right.
but it could be the higher amount.
And the way it's set up right now, it's all or nothing. You've paid it all off. So is there any cap with regard to debt collection?
I don't know the answer to that. I'm sorry.
Okay. Representative Owens.
Thank you, Madam Chair. Can you tell me what authority judges already have to waive fines, fees, and restitution in a case or in a situation?
So in certain, I know, for example, there's a fee that is sometimes imposed for indigent clients for like an attorney's fee, that attorneys frequently ask for that to be waived, knowing that their clients, the reason that they have a public defender is because they can't pay for an attorney. And I've seen judges waive that quite frequently. Other ones of the fines and fees judges are less likely to waive. And I don't have an answer for you in terms of, at the time of sentencing, what the judge's legal obligations are regarding waiver of those fines and fees.
I think that that would be really important to understand, because if our judges already have the authority to waive these fines and fees, but then are choosing not to, I tend to defer to judicial discretion. They generally know their defendants and the people that are in front of them and their circumstances better than most people. And so I'm just curious what legal authority they already have to waive that if they deem it fit. Thank you.
Could I just respond
Sure.
to one point there?
Of course.
There's sort of two different moments that are happening here in the court. So one is at the sentencing. The judge, as you say, may have discretion to waive certain fines and fees. The judge certainly has the discretion to determine the amount of the appropriate restitution. And then there's the second moment at expungement. And that's usually a different judge than the original judge. And what the Judicial Council's recommendation isn't asking for at that second moment of expungement to undo any of those decisions that the sentencing judge made. And in fact, all of those decisions regarding which fines and fees should be paid, which restitution amount is correct, those all stay in place. And the defendant, now the petitioner in an expungement, is still required to pay off those fines and fees and is not relieved of their obligation. All that it means is that if, for one reason only, they can't pay for it because of their poverty, they're still allowed to get an expungement, just the same as somebody else who is meeting all the other benchmarks of expungement. You know, they've rehabilitated themselves. It's not going to be a danger to the community. The appropriate amount of time has passed and they don't have the disqualifying intermediary convictions. All of those benchmarks are still made. The only thing that this particular petitioner can't do is pay off the fines and fees because of poverty, and because of poverty only. They're still allowed to get the expungement. However, they will still be subject to their obligations and responsibilities that the sentencing court imposed from collections and civil actions.
Thank you.
Representative Hoffman.
Thank you, Madam Chair. So if you do that, which I'm not saying we shouldn't, but if you do that, then what kind of a incentive then is there for them to pay them off later? And not, they've already got their expungement, now it just goes to collections, I suppose. So what keeps them from saying, well, I'm just gonna not ever pay them? Again, is there any sort of a penalty that would be implied later?
So the statutory recommendations that the Judicial Council has proposed don't include any sort of extra incentive other than the collections process and the civil remedies that can be levied against the individual for not paying. But I would say that the proposal that the Judicial Council is recommending includes specific language that an unwillingness to pay can be a reason to deny the expungement. So a judge looks at the facts here and can say, I don't think that you're actually indigent. This is an unwillingness, and that can be a reason not to give it. So there is still an incentive there to pay off those fines and fees if possible before going through the expungement process. But I also would say, Representative Hoffman, that the population that this is supposed to improve access to expungement for are not unable to pay because of recalcitrance. It's specifically for those who can't pay because of poverty. And whether that changes in the future, 5 years down the line or not, is probably more likely if they're able to get an expungement now and then get a job so that they can pay it.
Okay, so they would have to fill out something that, at the time of expungement, that showed that they weren't able to pay up, well, maybe the poverty affidavit is what it would be, but that they weren't able to pay at that time.
Right, so there is this poverty affidavit. I'm sure there can also be discussion and back and forth litigation in front of the court as well about what they're able to pay or not. I don't know how that would exactly play out, but certainly judges make determinations like that all the time, even when deciding whether somebody is eligible for appointed counsel.
Okay, all right, thank you.
Senator Foscato.
Thank you, Madam Chair. So your recommendations, do we need all 5 of them to make this possible?
So
Or
I
3 of them?
I think the real meat on the bones here is the recommendation that courts are prohibited from denying expungement due to the inability to pay outstanding fines and fees. That's probably, in my view, the most important piece. But the other pieces were all discussed at length and kind of serve to support that goal, while also safeguarding the kind of protections that Representative Owens was concerned about, continuing to be obligated to pay off the restitution to victims or your court costs, fines, and fees to the court.
Did the advisory committee contemplate or explore what other states are doing with the automatic expungement process?
A separate study by the Judicial Council has explored that. This particular study and committee did not. Oh. Okay. Laura Norgren states that the prior exploration into automatic expungement was just specifically for human trafficking, and she'd be happy to send you the information on that.
Okay. Okay. I'm just curious because it does look as though at least Pew is reporting that about 10 states have adopted or have laws that they're working on toward that automatic expungement. It is interesting, the study by the University of Michigan, 2 law professors found that 90% of those eligible in Michigan, obviously much larger in population than the state of Kansas, but 90% of those eligible for expungement did not even apply. And the 2 reasons were that it's too costly and too complicated for folks to figure out that process. I think we've already figured out it is a complicated process. Okay. Committee, any other questions? Are you going to continue on with regard to juvenile, or are we stopping here?
I can speak briefly on sort of the differences between the proposals. I wasn't on the committee that explored specifically the expungement statute as it intersects with juvenile law. But the differences, if you'll excuse me while I find that page. So the same kind of meaty recommendation that the court is prohibited to deny a juvenile expungement specifically on the basis of inability to pay, that is the same. It's also the same that expungement for juveniles would not alter their responsibility to pay off the fines, fees, and restitution that was originally ordered by the court. One difference in the recommendation from the committee that explored the juvenile issue is that the criminal offenses that the court is permitted to look back on when determining whether somebody is eligible for expungement under the current law is actually more penalizing than it is for an adult, because juveniles, the court can look back on your adult misdemeanor convictions. And so the Judicial Council recommended removing that requirement for juveniles. And then additionally, currently, the court can look back on your entire adult criminal record if they are determining whether you get a juvenile conviction expunged. And so the committee that looked at this issue recommended that the look-back period be reduced to 2 years prior to the application for expungement.
Senator Dahl.
Thank you, Madam Chair. So let's say a juvenile got expunged, and then he gets in trouble when he's not a juvenile any longer. That doesn't follow him. That court would not know that he was expunged earlier, would they?
So if a juvenile gets an offense expunged, I believe that it works the same as an adult expungement where, I can speak in the adult context, a court that is later sentencing you in Kansas actually does look at and consider your expunged convictions. I haven't practiced juvenile law. If there's a difference in that, I apologize, but I can tell you for at least adults, your expunged record in the court is still considered and scored.
I'm not seeing any other questions, so thank you so much for your testimony.
Thank you.
Last up, we have Leslie Moore, Director of Information Services, Kansas Bureau of Investigation. Welcome to the committee.
Good morning. Thank you. As Chair said, I'm Leslie Moore with the Kansas Bureau of Investigation. I'm the Director of the Information Services Division, which is the division that houses the different criminal repositories, the criminal history, offender registration, incident-based reporting, all of the different repositories. You should have received some written testimony from Robert Jacobs. Unfortunately, he's not able to be here today because he's ill, so I'm stepping in on his behalf. I'm here today to talk to you about expungements, wrongful convictions, and the destruction of biological samples. There are two different processes to expunge a criminal history record. One of those is defined in KSA 216614. It's a regular expungement for an adult. I'm only talking about adults here today, not juveniles. Once KBI receives that certified copy of that expungement order, we do go in and seal that criminal history record from the public. There are certain circumstances that are defined in the statute that allow us to share that information with other agencies for employment, for certification, for court purposes, but it's all defined in the statute. KBI also sends the FBI an electronic message for them to immediately purge what the FBI is holding on that individual for that criminal history record. And KBI sends a secure email to all of the arresting agencies that have access to that offense, to prosecutors, Department of Corrections, basically any criminal justice agency that may hold information on that offense. Over in our DNA lab, once that expungement has occurred, that petitioner actually has to go through a second process. They have to go out to the KBI website and find an application to get their DNA purged from the system. Once they fill out that application, they send it into KBI. It goes to our legal counsel at KBI, and they review that application. And they go back and they look at that individual's criminal history record to see if there's any other reason that that person may need to have that, or for KBI to hold on to that biological sample. So they're looking at any other offenses that would fall under that law, 21-2511, that are all of the requirements for the DNA to be submitted over to KBI. If there's any additional offenses on that person's criminal history record that would require DNA to be submitted, then that DNA is not removed from the DNA database. If there's no other offenses, then they do remove that profile from the DNA database, and then they find the actual biological sample and have that destroyed by incineration. Now, we have very few people that actually apply for that process. We range for expungements anywhere from 2,000 to 4,000 a year on the criminal history side, but on the DNA side, we only receive less than 5 a year. So that DNA is being retained because it's not being requested to be removed. The other type of expungement is actually a civil process because the person's been wrongfully convicted of a crime. When KBI receives those types of expungements, we actually purge everything on that case from the criminal history record, from APHIS, where the fingerprints are retained. Everything is actually purged, so that information is no longer available for any purposes at all whatsoever. Over on the DNA side, when we get that, it also comes with a certificate of innocence that also goes to legal counsel. They review that. They also go through that same process where they're reviewing the criminal history record. If there is offenses that would require the DNA to be kept on file, it gets retained. If there's no other offenses on file, then that DNA is automatically purged. There's not another process that the person has to go through to get that DNA purged. Just that one expungement process gets that handled for them. Since 2016, when that process was created, there have been 8 of those submitted to KBI. Of those 8, 4 of the samples have been purged and 4 have been kept because there was additional qualifying offenses for that DNA to be kept. And with that, I will stand for questions.
Senator Dahl.
Thank you, and I apologize that I wanted to get a different answer. I'm sure you can help me on this. Let's say that I had a real bad day when I was 15, but I was able to get it expunged. I apply for a job when I'm 25. Who can see, who knows that I had a bad day when I was 15?
So juvenile expungements and adult expungements are handled differently by the repository, and there's a different answer for the courts than there is for the repository. So for a juvenile expungement at the repository, we are not allowed to show that information. Once it's been expunged, it is no longer viewable by the public, by law enforcement. The only reason we're allowed to release that information is for pre-sentencing purposes when that person goes to court.
So that just the court would know?
So just the court would know.
Okay, can I follow up? So I'm 25 and I had a real bad day, and I'm 45. That would follow me, really, when I'm talking for you, Kyle. I'm just thinking.
So it could follow you,
Okay.
yes, because it is purged from public view, from the general public. However, that statute does allow for the KBI to release that information under certain circumstances. For example, if they're applying to work at the lottery, that information is available to the lottery for them to see that expunged information, for them to make a hiring decision.
What if they were applying to get teacher certification?
If they're applying for teacher certification, we're not allowed to release that to the Department of Education or to schools. So that information would not be provided back to them from the repository. I can't answer on behalf of the courts.
Right. Representative Hoffman.
What about law enforcement, though? If they're investigating that person for another crime, are they able to see that?
They are, yes.
Okay.
Senator Foscato, do you have a question? That's fine. That's why we're here. Yep.
I don't want to hog the mic, Madam
No.
Chair, but thank you so much.
We're glad that Leslie's here today because she's
So,
pinch hitting.
So, a real life situation. So there was a young, well, he's over 30 now. So, a couple of, maybe 3 years ago, with a piece of legislation that Representative Gelfini and I worked on, and Madam Chair, as a matter of fact, former Representative Russ Jennings, in his committee. So there was a pastor in Wichita, and his assistant pastor had stolen a pair of gym shoes when he was 14. But he wanted to be a Wichita, you remember that? And he wanted to be a Wichita policeman. He is now. However, it took a lot of money and a lot of lawyers, and the chairman of the committee, Jennings, at that time, to help do something just special for him. And he is a Wichita police right now, but it was just a major barrier from something he did when he was 14 years old. When you made a statement earlier of saying you give this information to who, and can the employer who's looking at that application, and do you give them, so I'm hiring someone, do I get all that information, or just is there a 5-year or 7-year period that you cut off where you don't get all the information? Me, the employer, that I would receive?
There's different answers depending on who the employer is. If you're going to work for a law enforcement agency, you do get the whole record minus juvenile expungements. We're not allowed to release the juvenile expungements to law enforcement, so they wouldn't see that. The general public, we're not allowed to release any juvenile records for.
Okay.
So if somebody were to make a record check to KBI and all the person had was a juvenile record, we would respond with no record.
Okay. All right. Thank you, Madam Chair.
So has KBI looked or weighed in on if the state were to consider, if the legislature were to consider laws for that automatic expungement on certain crimes? So how would that impact your information systems to do that? And what other systems would be impacted as well?
Sure. So it depends on what you mean by automatic, because there is not an automatic process between the courts and the KBI to make that go away. My understanding of the automatic process is that the courts would automatically look at that record once it hits a certain age and see if the person's eligible, and then expunge that record. Then they would mail that expungement documentation to KBI, and a person is sitting there finding that information in the system and going through and expunging line by line. So it's not really automatic in the whole process. It's automatic on the side of the court. And it's still a very manual process at KBI. KBI also then has to manually notify the FBI so that they can seal that information on the FBI side. And we still have to manually notify all of the other criminal justice agencies in the state to let them know that that expungement exists.
So how, when you are working with individuals that have similar positions in other states, how have other states been able to make that happen? Or in other states, is it just as human dependent in the process as well?
No, I know there are several other states that it's actually an automated process. The court expunges the record and it is electronically sent over to the repository. The repository receives it electronically, expunges the record electronically, and there's no human intervention in that process. It takes a lot of years to get there, to build all of those automated processes for the repository and the courts to get together and agree on all of the programming on that. It's costly. It can happen. It just takes a while to get there.
So that's one of those things that, the legislature is dependent on what our agencies are able to do or unable to do. So is that anything that the KBI has looked at as far as what would it take to move, to make that process automatic and less individual dependent for expungement? Have they looked at, as they pursue system upgrades, how to create that capability, if you will?
Sure. So our criminal history system has been in place since 2002. It is actually, hopefully in the future, going to be replaced, and we will definitely consider all of those types of things when we go to replace that system. But it's not only KBI that has to make those changes, it's also the courts. And I know the courts right now are still in the midst of their upgrade that's been going on for like 5 or 6 years that they've been trying to roll out to the courts. So I feel like I can certainly say they wouldn't be able to work on that process until they get their rollout done throughout the state.
But the rollout, as far as you're familiar with, does not include the ability to automate expungement.
Not at this time, it does not.
And I think that's one of the things that's important for us to consider also as we serve on other committees. So why would we fund new technology processes that don't really move us into where we need to be moving for the future? We are in the 21st century, but it is surprising how little within our state government agency, particularly IS, just is really behind the times. But if we're not requiring that as a part of that RFP process, then we'll always be behind. So I appreciate your willingness to share that information. Because even if we were to say, if we were to legislate, it's one thing to have the policy, but if you don't have the procedure or the technology available with the capability for that procedure, then it kind of defeats the purpose, doesn't it?
It does. It's also two different things.
Right.
One's something for the public to get their record expunged, and one is the actual process of doing the expungement.
Yeah. So as far as you know, has there ever been any contemplation about, some states we know have expungement week, where it's 1 week, all hands on deck, everybody in local communities are ready to help in that process. What would it take to even make that possible?
So we do have that in Kansas. We have seen that in Topeka and Wichita, definitely, where they have expungement weeks.
In those two areas?
In those two areas that I'm aware of. And we will receive hundreds of expungements during that time frame.
Okay. But not state?
I have not
Not
seen it
statewide.
statewide, no.
Okay.
And I have not seen it in smaller communities. I've only seen it in those two larger.
Manhattan
Manhattan
Riley
has
County.
well? Okay.
Yeah, okay. Oh. I see someone that's standing in the audience that says, I know, so if you would come to the mic. What?
I'm Marilyn Harp with Kansas Legal Services, and I know about these because we sponsor them in these areas. So this year, we'll actually do 6 of them in small communities. We've done Manhattan. We have one underway right now in Leavenworth. We are planning one before the end of the year, we hope, in Chanute. We've done Pratt, I believe, this year. But so we've done smaller communities, we've done larger communities. I wish that Leslie's number of hundreds of them from some of these large communities were actually true. It's maybe 100 is the most. Again, you've spoken about fines and fees problems and all that. If I might, I also, because you've been asking about automated expungement, or automated record sealing, which I think is the better term for this, because expungement has connotations that speak maybe not to what really is going on here, which is an automated process that seals criminal records. So last session, the House passed. The Senate, however, never considered a bill that, and I'm looking up the bill number here, 2575, House Bill 2575. It might surprise you to know that if you technically read the law right now, there's no way to expunge not guilties or dismissed cases, because all the language speaks of a waiting period after conviction. And if there's no conviction, there's no, now I'm not saying that courts aren't amenable to doing that, but it's not, under the specific language in Kansas, a not guilty cannot be expunged because there's no conviction. So 2575 was an attempt to do two things: automate the record sealing for not guilties, dismissed cases, and also diversions. You know, one of the things we've lost a bit in this conversation is that in every case, court costs are one of the things that are paid when you when you're found guilty, when a case is filed, you're assessed court costs. And then, in order to seal that, although the process is, you know, I mean, it's not without a problem, but it's a lot simpler than a court case. File a paper, get it approved, send it to the KBI. You're charged another court cost. And so, just for history, I might tell you that when the court first set the cost on those, they set the court cost at $100. And then there was a challenge that they didn't have legislative authority to do that, that the legislative filing fee was $179. And so everyone got $179 at that point, because the courts never, the legislature's never given the court the authority to charge a lower filing fee on expungements, even though people have already paid that. But back to 2575, it made it through the House last year. It never got a hearing in the Senate. It is one of the Judicial Council recommendations that it was a judiciary bill. It came out of a Judicial Council piece of legislation, so a recommendation. So it has the support of a lot of groups, including the prosecutors who sat in on that. So I'm going a long ways from automated expungement.
I was just going to say, let's go back to where we were.
All right, automated expungement. So, but that was an effort at automating a process. So if the court system and the KBI get the process going on not guilties, expungements, and diversions, then the infrastructure is in place and it can be expanded from there. So clearly, so that's why that bill is an answer to that idea.
Okay, so let's get back to expungement days.
Okay.
How are the communities selected to initiate the expungement days? And this is just for individuals that reside in that community?
Because we have, yes, because we have, I should mention that Johnson County was one of the other places now, as I recall. We have to find a willing group of lawyer volunteers and a prosecutor's office that's willing to work with us on one of those days. And so we, a year out, plan and work with the Kansas Bar Association to make those happen. We're right now working on where the 3 communities will be next year. And we know one of them is going to be in Wichita, looking only at drug registry, which I understand you're talking about this afternoon. But that's how those happen. We do outreach and usually have a pretty good response from people when we hold those events, but we haven't held them everywhere yet by any means. There are also forms and things available for people to self-represent, but one of the outcomes of those expungement days has been some research on how well people self-represent, and we know that forms are not the only answer to this problem. They need a lot more hand-holding than that. The simple answer to that is they've gone to court with a lawyer many times and not had a good outcome. They were convicted. So to ask them to go back to court without a lawyer by themselves is tough. But anyway, that's the plan. Probably 3 this year. We had 6, 3 in 2023. We had 6 in 2022 because some had backed up because of COVID, some of our plans.
Thank you very much.
Yep.
Committee, any questions, further questions for Leslie? Yes, Representative Resman.
Thank you, Madam Chair. If someone goes on a crime spree and commits several crimes, do they have to ask for an expungement on each crime, or there's there one umbrella that would expunge all of them at once?
Usually it's by case.
By case? So if somebody's charged with several crimes, they would have to, so it would be $195 for each one then, I guess?
I don't know the costs. That's on the court side. By the time we see an expungement, the person's already gone through the whole court process, and we're just receiving a certified copy of the order.
Okay, thank you.
Could you share a little bit about what happens with the DNA on an expungement?
So on a regular expungement, it's kind of a little bit of a different process. We get the order of expungement and we seal that criminal history, and that's done. Over on the DNA side, when we get an expungement, a regular expungement, that person has to go to the KBI website and find the application to have that DNA reviewed and then purged if it was applicable to be purged.
So talk about reviewed and applicable. I
Yes.
assume you're talking about the same example with the wrongful conviction.
There,
That the reason that 4 of the DNA samples were retained because there were prior or different
correct. So
convictions.
the application gets sent over to our legal counsel. Legal counsel then reviews that person's criminal history record for Kansas only, no other state. They review that criminal history record to see if there's any additional crimes that fall under that 21-2511, that defines what crimes are to be reported under DNA. If there's any of those crimes still on that person's record that have not been sealed, then they will retain that DNA profile and the biological sample. If there is no other crimes on that person's record that require DNA to be submitted, then they do remove that profile from the DNA databank, and then they find the biological sample, and it is destroyed then at that point. Then there's an automatic process at 9 o'clock every night that sends messages up to the FBI to tell the FBI either to purge that information out of the national CODIS database or to add it if it's a new sample.
So a person that receives an expungement, how would they know that they needed to go through that process of a separate application for a DNA expungement? How would they find it? I think we're making it abundantly clear that it is a very convoluted, difficult process. And I think part of the testimony earlier included you're probably going to need an attorney, which is an expense, to help you through the process. And if you're still struggling to pay for fines, fees, and restitution, how are you going to come up with more money to make sure things are cleaned and wiped out? So how are they notified? How do they know that they need to go through a separate process on that DNA?
To be honest, I am not sure how they know that process. I would think that they would have to be told that by their lawyer or by the court, but I am assuming that. I don't know.
Okay. And
I mean, it's completely a different process. They have to go to the KBI website to get the form to request for their DNA to be purged.
And is there a cost for that?
No.
Okay. Okay. Senator Foscato.
Thank you, Madam Chair. So just a clarification on the conversation with you and the chair. So the DNA that you're speaking of, is that for criminal
It is.
expungement? Okay. And then, Madam Chair, I would like to say this, and I know people have heard me talk about the suspended driver's licenses for years, and in our first bill, Marilyn Harp helped with that some years ago, and then I continue to try to address it. But, Madam Chair, in Wichita, I was part of the Amnesty Day, the Expungement Day, and we have it on video where at this one event, I mean, all day, Madam Chair, it was about 600 people that came, and they were showing their willingness to want to get their lives back on track, pay their fines, be productive citizens, to, be gainfully employment, but just that a snowball effect of not being able to pay the first fine, and then it got to this point. And so, Madam Chair, people came at like 9 o'clock in the morning, and some sit there until almost 4 that afternoon, and they finally got their turn. We were able to network with some attorneys who came in that day, and they stayed all day, and they helped people. And Madam Chair, so many of them left with their heads hanging low that they just they needed a certain amount of money, because we were still requiring them to pay a little bit towards their original fine, and they just didn't have it. And so, but it was helpful. It was a sight to see all these people that were in there, and for no other reason, no other crimes, just they couldn't pay that initial fine. But you're speaking of not just traffic violations, or not, you're talking about the covering the record up for what type of criminal crimes, all or certain?
All
Okay.
criminal crimes, right.
Thank you, Madam Chair.
Thank you. So I just want to circle back one more time on the darn DNA expungement. So if there's no fee, why is there a separate process? If the files are going to be expunged, why is it that the DNA does not then automatically become expunged? Because it could, just that request for the file could trigger your attorneys to review the yes or no of the DNA, couldn't it?
I don't know the answer to that. I can find out and get back to you. I don't know if there's nothing in the actual expungement statute that speaks to the DNA, and it's only in the DNA statute. I'm not 100% sure, but I can definitely look into that and get back to you on that.
Committee, I know it sounds like it's a sticky wicket, but we need to know this. We need to know, is this a policy or a procedure within KBI? Or is this something that is either it doesn't specify in statute, or it does specify something in statute? But for us to resolve this, we need to know where this issue lies And is that something that we are wanting to address? It seems interesting to me that you could have a court-ordered expungement of the file, but unless you jumped through a different hoop and you found on the KBI website the way to find for the DNA to be expunged as well, that isn't an automatic process. And so I think we do need to address that. We absolutely are going to be dependent on you, Leslie, to get back with us. Are you able to do that before tomorrow afternoon?
Oh, I can do that as soon as I get back in the office.
Okay, that would be very helpful, because I think we need to, it sounds crazy, but we need to truly make sure we're vetting this process. Representative Hoffman.
Thank you, Madam Chair. And I agree. The only thing that is a little different, I guess, is that the expungement doesn't destroy the record. Now, if they're a wrongful conviction or whatever, the expungement doesn't destroy the records. They're still there. And I think what you're talking, they're sealed, but I think what she's talking about with the DNA, that actually is destroyed.
That's correct, it is.
And so that may be the issue right there, that that's a little different, because then that never can come back. You know, if that person does something else later, then those sealed records, that they can look at that. Well, then they've also got the DNA to also be able to look at, whereas they'd have to go out and get DNA again. I don't know if that could be part of the issue of that, because we're kind of talking, if there's a way for that to be sealed or whatever, I'm not sure. But that, I guess, might be a little bit of an issue.
Well, the DNA sample information is not available to the public where a criminal history record is. So that is a little bit of a different thing there, too.
And no matter what, it triggers that your legal folks review to see if there are priors that would mandate the keeping of that.
Right.
So we hear from our revisor Thompson that he has an answer for us.
Madam Chair, Jason Thompson, Revisor's Office again. Just to help the KBI out, their memo does talk about this as well, so to help them maybe fine-tune their answer, that KSA 21-2511 that we've been talking about that controls the DNA collection and that database, that statute is the one that requires the petition by a person to expunge their sample and their profile record from the DNA database. And I don't remember when we wrote this. It was sometime in the 15 years or so that I've been here, but there was no mechanism for removing those profiles until that time. And at the time, that was the choice, the policy choice that was made, was to require a petition to the KBI, which is now available on their website. It has no fee, et cetera. But there was no conversation that I recall since about linking that to expungement until the recent wrongful conviction conversation, where the legislature chose to link those two processes and say that the wrongful conviction and the certificate of innocence that comes with the overturning of a wrongful conviction, that automatically triggered this review and this potential removal from the DNA database. And so maybe the finer point that you were getting at, if I could assist, was could that be done with expungement as well, with the statutory change? It would obviously be required, at least from my perspective. The statute doesn't allow it right now, but could it? Does that help?
It does help, and I think that's something for us to consider. I'm not saying one way or another. It's something for us to consider. Thank you for that clarification. Committee? Yes, Representative Carlin.
Thank you. I'm not sure where who brought this point up. I think it was from the Judicial Council, but the case I've talked about before in Johnson County, there was no conviction. And until today, I did not realize, and nobody at Johnson County told me anything about anything. I mean, I pried, but I did not realize that language was the issue. And this child had no conviction. She appeared in court. She was arrested. And so it was all, she couldn't get a job. And so what Now, the 2575, did that come out of this committee, or did that come out of House Corrections? Do we know? Judiciary?
Judiciary.
And it went through the Senate Judiciary and failed? Or it didn't get in? Didn't, I thought she said we passed it, I'm sorry. Well,
It died in committee.
it died in committee.
Oh, it got out of committee, died on the
Okay,
floor.
died
Okay.
on the floor. I think that's something that people, it's so difficult. Like you said, we've gotten in the weeds, we've learned so much. And even though I went through a process, just as a layperson, I'm not an attorney, I thought I knew what I was doing. And then we find there's this little word in there, conviction. And we need to fix that. I don't know if there's any other way. If the 2575 would have taken care of that, is that what we've been told today? Okay.
There is another expungement statute where if a person has been arrested or they've been provided a diversion, they can get that expunged. I don't remember what the statute is off the top of my head.
Our reviser has that.
Thank you, Madam Chair. Jason Thompson again. It's 22-2410. That's the arrest expungement. So it's in criminal procedure. 216614 is the conviction expungement. And then there's, of course, a municipal version, 12 dash, I think it's 4516 or something. So there's actually three. And then there's a juvenile one that we talked about. So there's multiple expungement statutes. Yeah.
I appreciate that. Committee, part of the reason that it's important for us to have this discussion, I know that Senator Faustido has brought up repeatedly in other committees that oftentimes when a family is confronted with someone now for the first time being involved in law enforcement or a sink case, they don't know. They don't know the process. They don't know what they don't know. And it is very difficult to figure out and to navigate. As legislators, it's very difficult for us when we're contacted by constituents because it is a very complicated process, I think would be the most accurate. It's very complicated. And it's different depending on what county you're in, which community you're in, because what happens in Johnson isn't the same as Miami or Sedgwick or any other county. And so I think it is important for us to discuss this so that legislative intent is what's actually occurring. And so if we need to contemplate changes with regard to expungement, we need to do that with eyes wide open. Because I do know that we've heard from law enforcement, and I'm glad to see our representative there in the back row. But what we have continued to hear from law enforcement is crime is not going down, it's going up. And the one thing as legislators, we don't want to be considered weak on crime. We want our communities and Kansans to be safe, but also we don't want unintended negative consequences. So we are at a time for a break. We'll take a 11-minute break and we will be back at 10:30 to talk about offender registration. Thank you so much for being here.
Thank you.
So it's not going to be in a paper form? No, it's
Okay, committee, are we working now? There we go. Yep. Okay. So we took our break on Senate time, which means we're 8 minutes late, but let's get started. Okay, so what sometimes occurs is we think we have the answer. We didn't have the answer, but then we found we had the answer. So we are going to circle back just a little bit on expungement, and we have someone that's here from, am I correct? You are here from the Judicial Council? Yes. Okay, so if you would please share your name.
My name's Laura Nordgren. I'm a staff attorney with the Judicial Council.
Okay, so go ahead and share with us what you do have and what is going to get sent to us.
Okay, you had a question about automatic expungement and whether the council had done a study on that, and I apologize, it slipped my mind. We did do it last year, and that was based on a bill that it was 21 House Bill 2226 was the bill that we were asked to study about, and it was a bill proposing an automated type expungement process in Kansas. The council did send that to the same Criminal Law Advisory Committee who studied that, and it recommended against passage of that bill for multiple reasons. That bill was based on the Pennsylvania model of this more automated expungement process, and Pennsylvania is not a member of the compact that Leslie Moore was talking about with the KBI, and there's and Kansas is, and there's rules that come with that, and so that process wasn't compliant with the rules for the compact, and so the committee put that aside, but went ahead and reviewed other states that do have this more automated process for expungement, and they identified two that are members of the compact, just like Kansas, and have some kind of automated thing, and it was Utah and Michigan. The Utah process was reviewed by the FBI and was approved as meeting the rules of the compact. The Michigan, at least at the time of this study, had not yet been reviewed by the FBI, and so the committee chose to focus on the Utah one since the FBI had already cleared it. So this report is going to be sent to you all just as a reference for you all to look at. It has some statutory recommendations, but one of the big things before the committee thought that any type of automatic expungement of convictions could be implemented, there would need to be some kind of feasibility study done of the district court unified case management system. It's technology, the KBI systems, things like that. It's not feasible right now, or like right now with the systems that are currently in place, like you all talked about. And then the second part of the report does talk about the creation of some kind of more automatic expungement and streamlined defendant-initiated expungement petition process, which is what we have, for those non-conviction records, which include acquittal, dismissal with prejudice, or dismissal without prejudice. And that is what Marilyn Harp was talking about, the bill 2575. Is that the bill number last year? And so that bill was based on the Judicial Council recommendations.
Committee, any questions? We understand you don't have a copy of the report yet. It will get to you. That will be helpful for us if tomorrow we are wanting to make recommendations with regard to moving forward on House Bill 2575. As far as a recommendation, is this something that as a joint committee we think should, effort should be made to get it up and out? The other component is it gets back to that notion of until you have that feasibility study. And that takes time and it takes money, but until you have that feasibility study, you're going to continue to have different groups. So you'll have the executive branch and you're going to have the judicial branch. They're going to continue to move in their pathways, not necessarily in a parallel universe. And so if we're wanting those systems to talk and work together, you've got to have that study. And as you are broaching new RFPs, that's something that has to be included for that technical handshake to occur. And so we really have to, it sounds a little bit crazy, but when an agency comes to us for a request in that budgetary process, they're focusing on just what they need. And we as legislators are going to have to continue to work to say, are there other systems that you are going to need to make sure work in conjunction with yours? And we're going to have to work to force that feasibility. And, you know, another group that the IS system has to work with is going to be DCF. So we're going to need those three to essentially be working together in concert if we're wanting to move forward with this. So I appreciate that the light came on. We'll make sure, Lindsay's going to make sure that you receive that email with a copy of that report. And we certainly appreciate the work of the Judicial Council. So when we're trying to do our work, we toss to them so that they can do that deep dive. And so I appreciate that. Thank you very much. Committee, we are going to move on to offender registration. And first up, we have Natalie Scott.
Thank you, Madam Chair. So as the kickoff to your discussion about offender registration, the chair asked us to do just kind of like a summary of the offender registration process in Kansas. You should have a memo from me that goes over the offender registration statutes, and I'm just going to talk about those statutes and what that process looks like. So the Offender Registration Act is in Article 49 of Chapter 22. The first section there, KSA 224902, that provides the definitions that are used throughout the Act. Kansas has 5 different types of offenders that we register. We have sex offenders, violent offenders, and drug offenders. Those are the 3 that you guys kind of talk the most about. But then we also have people who are required to register under an out-of-state law for an out-of-state conviction, and people who are required to register for an offense that's otherwise not required by the Offender Registration Act. And that definition section lists the crimes that fall under those categories of sex offenders, drug offenders, and violent offenders. KSA 224903 provides the criminal penalties for violating the Offender Registration Act. A violation is a failure by the offender to comply with any and all provisions of that act. And a violation is a severity level 6 felony for a first offense, a severity level 5 felony for a second offense, and then a severity level 3 felony for a third or subsequent offense. Aggravated violation is a violation that continues for 180 or more days, and that is a severity level 3 felony. If the violation is only a failure to pay the required $20 registration fee, then that violation is a Class A misdemeanor or a severity level 9 felony if 2 or more payments have not been made. And each of those crimes for violation of the act are designated as person or non-person based on the underlying offense for which the offender is required to register. So if you are registering for a drug offense that's a non-person offense, then all those violations would be non-person. If you're registering for a violent offense that is a person crime, then when you violate the act, that felony in and of itself is also a person crime. KSA 224904 provides the list of information that the court is required to provide to an offender who is required to register. So once they inform the offender of the registration requirements, they get that information to take with them. It also provides a list of the duties that have to be fulfilled by the staff at a correctional facility or a registering law enforcement agency or the staff of a treatment facility with respect to registering an offender who is in custody there. The KBI ensures that the offender registration information is entered into the database, that the KBI is required to maintain, and then the Attorney General is required to forward information to the KBI relating to offenders who are declared to be sexually violent predators under that process. The Department of Education is required to notify a school of the KBI database and any website that has offender registration information in that jurisdiction where the school is located. And then likewise, the Secretary of Health and Environment is required to notify licensed child care facilities of that information. KSA 224905 identifies the duties of the offender related to registering. Offenders are required to register within 3 days of coming into a new jurisdiction, and they're required to register where they live, where they work, and where they attend school. They're required to register at those places 4 times a year. So if they live, work, and attend school in 3 different jurisdictions, then 4 times a year, they have to go to each of those 3 jurisdictions and register with the law enforcement agencies there. The offender is required to pay a $20 fee at each place where they're required to register. And the offender is also required to report to the registering law enforcement agency within 3 days of making a change to that information. So if they get a new job or if they move, they have to report that within 3 days to the appropriate law enforcement agency. KSA 224906 provides the time periods for which each type of offender is required to register. Depending on the offense committed, adults are required to register for 15, 25, or the rest of the offender's lifetime. That statute also provides the length of time that juveniles are required to register. So offenders who are 14 or older and are adjudicated for a sexually violent crime that's not either an off-grid or a severity level 1 felony, they can either be required to register until they're 18 or 5 years after adjudication or release for confinement, whichever is later. They can not be required to register if the court finds substantial and compelling reasons, or they can be required to register, but that registration information is not open to the public and it's only available to law enforcement officers. Offenders who are 14 years of age or older and are adjudicated for a sexually violent crime that isn't off-grid or non-drug severity level 1, they are required to register for the rest of their lifetime. Offenders required to register for an out-of-state conviction are required to register either for the length of time required by Kansas law or the length of time required by that out-of-state law, whichever one is longer. KSA 224907 provides the information that is required for registration. That list of information is collected by the person registering the offender, so the registering law enforcement agency in the jurisdiction. If a DNA sample is required, then the registering law enforcement agency searches the Kansas Criminal Justice Information System to determine if that offender's DNA is already on file. And if it is, then the registering law enforcement agency is not required to take a new sample. But if a DNA sample is taken, then it's forwarded to the KBI. KSA 224908. This section was pretty heavily amended in the last session by Senate Bill 366. So prior to those amendments, an offender who was required to register was not able to ever get any relief from those registration requirements. Once you had a registration, there was no way to appeal to a court to stop those registration requirements. So the changes that were made to this section provided that for a drug offender, they can file a verified petition for relief from registration requirements after the offender has registered for at least 5 years. An offender who's required to register for an out-of-state conviction can't file that petition if the offender would still be required to register under the out-of-state law. Anytime that the offender spends incarcerated or not in substantial compliance with the Offender Registration Act won't count toward that 5-year period that they need to file that petition. The statute provides the information that's required to be in the petition for relief, and the statute also required the Judicial Council to create a form for use under that section to assist offenders with filing that petition. When the petition is filed, the court is required to set a hearing date, and the county or district attorney shall notify any victim of the offense for which the offender is required to register. The court may require the offender to undergo a risk assessment to be performed by a professional agreed to by the parties, and that would be done at the offender's expense. The court shall order relief from registration if the court finds by clear and convincing evidence that the offender hasn't been convicted of a felony other than a violation of the Offender Registration Act within the immediately preceding 5 years. The offender is sufficiently rehabilitated, and the registration is no longer necessary for public safety. If that petition is denied, then the offender can't file another one for 3 years. And if the petition is granted, then the court shall order the offender be removed from the registry and the corresponding website. KSA 224909 provides the registration information that's open to the public and the information that is not open to the public. It also provides the information that's collected that can only be disclosed to law enforcement agencies. The information that is open to the public is required to be available for inspection at the registering law enforcement agency and at the Kansas Bureau of Investigation, and it also has to be on any website that's created by either of those agencies to display that information. KSA 224911 provides that nothing in the act creates a cause of action against the state or state employees as a result of performing their duties in registering those offenders. And then KSA 224913 provides that cities and counties are prohibited from adopting ordinances that establish residency restrictions for offenders. And that prohibition doesn't apply to correctional placement residences. It just applies to the primary personal residence of an offender. And that's kind of an overview of the act. I can take any questions you guys have.
We'll start with Senator Fasquedo.
Thank you, Madam Chair. Natalie, would you restate what you just said about the removal of an offender's name from the registry?
Yeah.
Thank you.
So during last session, you guys passed a bill that created a mechanism for drug offenders, only drug offenders, to be able to get off the offender registry before their allotted time. So before, they would get that 15 years and they would be on the registry for 15 years. So this process, after 5 years, if they've been in compliance with the Offender Registration Act, they can file a petition to have their name removed. And so then there's a court hearing and the prosecutor can provide evidence, the defendant can provide evidence about how they've been rehabilitated. And then at the end of that, if the court finds those 3 things with clear and convincing evidence, then they will order their name be removed from the registry at that time.
Committee, other questions? Representative Carlin.
Thank you, Madam Chair. And Natalie, I just, you read fast, but I heard you say, and I read it here, and under 4905, that offenders are required to register in the jurisdiction where they live, work, or attend school, and they have to register 4 times a year, and you said they have to register at all 3 places? I'm sorry, I don't understand that explanation.
Mm-hmm. So let's say I live in Reno County, but I work in Rice County, and I'm going to school in Sedgwick County. Then I have to register in all 3 of those counties, and I have to do that 4 times a year. There are some certain circumstances where you can do that by a certified letter, but for the most part, those offenders are going into the registering agencies 4 times a year at each of those 3. Now, if I live in Reno County and I work in Reno County and I'm not in school, then I'm just doing it in Reno County, and I have to do it 4 times a year.
That's where I was wondering, when you were going through it the first time, I thought, gosh, that's a lot. But if you do work, if you're present in those places, that makes sense to me. I appreciate that clarification. Thank you. Thank you, Madam Chair.
And talk to us about the fee. So the $20 fee, if they work, go to school, and live in 3 different counties, so it's going to be $60 times
a quarter. Mm-hmm.
4.
So every place that you're required to register, you pay that fee at.
Okay. Any other questions as far as where we are on statutes? Do we have any idea with the one that had just passed, if that's been utilized?
I do not know, but hopefully, yeah, maybe some of the Judge Sexton probably has some experience with that.
There we go. Okay. Seeing no further questions, thank you so much. So we will call on the Honorable Ben Sexton, Advisory Committee Member on Sex Offenses and Registration, Kansas Judicial Council. Thank you so much for being with us today, Ben.
Oh, you're very welcome. Do I need to touch anything here? We good? I know that I could be a much better judge if you would just let me borrow Natalie Scott, and if I had her sitting beside me throughout the day, there'd be a lot less reversals and remands. Thank you very much for having us here today to address the issues involving the Kansas Registry. Before I start, I listened to your information in regards to expungement just that you had before our hearing. And I brought it up to Senator Baumgartner. They're in Lyon County. They have an individual down there that's donated a sizable sum of money, and for the sole purpose of expungement. And they pay everything, my understanding from talking to Ty Wheeler, who's involved with the services down there, indigent services, and also to the judges, and it's worked out very well. So what you need to find is just that individual in every county to donate a sizable sum of money, and your worries will be over. Well, Senator Baumgartner, Representative Owens, and senators and representatives, I come today as a chair of an advisory committee created by the Kansas Judicial Council back in 2018, fall of 2018. And it was born out of requests made by Representative Blinch for studies under the Sex Offenses and Kansas Offender Registration Act, Representative Russ Jennings, who also had an inquiry, who served on this advisory committee for 2 years, and eventually we had inquiries from Representative Heiberger, so all worked on this. This is the full report, and I would encourage you to read that full report. Normally when you file your testimony, you're going to start reading at the front. I would encourage you to not start at the front. I would encourage you to flip to the back page of that testimony to see the individuals that were on this advisory committee. It was one of the most wonderful experiences of my career. Every walk of life in the legal system's there. You have the mental health providers, you have the prosecutors, you have the legislators, we have defense counsel, law enforcement, all around the table. And that report is available on the Kansas Judicial website, www.kansasjudicialcouncil.org, under the reports and studies tab. When we started, the advisory committee started out and we talked about, well, is this Kansas Offender Registration Act? Is it a civil? Is it a criminal? You know, what type of animal is this? And what we decided was listen, we all agreed that we're going to check politics at the door, emotion at the door, and we want it evidence-based. When we come across the street, which we were instructed by Representative Jennings, when you come across the street, you need to have evidence-based. You need to show how you've reached these conclusions. So we want to talk about 5 different matters here today, and there's one expert that we brought, and it's certainly not me. Mr. Seth Westcott's going to address you in regards to the recommendation to repeal the juvenile registration, the sex offender for juveniles. I want to talk to you about 4 other matters, and one of them involves expanding the exit mechanism. In 2022, you've just discussed, as Ms. Scott stated, Representative Owens had a House bill that had the drug registry, had exit mechanism that was encompassed in Senate Bill 366. It became law, I think, on May 12th of 2022. And it gave the drug offenders the ability to exit off the registry after a period of 5 years. That exit mechanism, that's one of the things we recommended out of that committee back in 2020. That exit mechanism for the advisory committee is critical. One, it gives incentive to the individuals to comply, and that's what you want. You want people to comply. So why not tell them, if you do well at this, you may get off. Here's the exit ramp off this. 2, and critical from my position, not all drug offenders, not all sex offenders, not all violent offenders are created equal. It gives the judge the ability to make an independent determination involving that individual at that space and time. And 3, that it's evidence-based. So what we're asking is that you expand it to include sex offenders and violent offenders. Same situation. If you're on for 15 years, you could petition after 5 years. If you're on for 25 years, you can petition after 10 years. And if you're on for lifetime, you can petition after 25 years. These numbers weren't just pulled out of the air. Dr. Flesher, who served on this committee, and Mr. Westcott was not on that committee to begin with. Dr. Flesher brought him to one of our meetings. And after spending a day with Mr. Westcott, I leaned across the table to Ms. Molson and I said, can we get him? And she says, yes, you can. So he was on for the rest of the time with us. What they explained to us is sex offenders, and not before they're caught, because you don't know how many times those individuals offend before they're caught. But once they're caught, once they're in the system, the recidivism rate is 8% in sex offenders. An individual that is compliant for 5 years, with your drug registry, compliant for 5 years, that recidivism rate drops to 4%. An individual that's compliant for 10 years, that recidivism rate drops to no more than the public at large. So it is evidence-based. Now, it does note relief for sexual violent predators is not available on our recommendation. I also, as Ms. Scott instructed you, if you're required to register out state, that is also not available. The process, and it's interesting that in the drug registry, that it says the victims are notified. I can imagine some scenarios, but generally the drug registry is a victimless crime. There's not a victim alleged in the complaint. But it's in there, and it's in there for a reason, because we had it, we recommended it, because the victim would be notified in a violent, which you're certainly going to have victims, and sex offenders, you're certainly going to have victims, would be notified, prosecutors notified. The Judicial Council would create and adapt a petition for those individuals. And if it's lifetime, and this will be extremely important in both violent offenders and sex offenders, if it's a lifetime registration, it's a mandatory risk assessment ordered by the judge and discretionary in all other cases. The burden is clear and convincing. It rolls off the tongue easy, but it means something. The only other burden higher than clear and convincing is beyond a reasonable doubt, a criminal case. So it's a substantial burden. They have to be felony free for a period of 5 to 10 years. Their behavior and treatment history must illustrate that they've been sufficiently rehabilitated. And then the magic one that you could probably start and end with, the registration is no longer necessary to promote public safety. Now, I would give you an analogy, and I haven't had an original idea in my life. I've stolen an idea from Lyon County. They have a 50% rule. And on some of the criminal cases in Lyon County, what they do is at the time of sentencing, they say, listen, I'm going to set your case, and you set it 50% down the road to halfway through their probation. I'm going to look at your case at that time. Nothing bad can happen to you. But if at that time you have met with your probation officer, no meetings missed, you have paid all your fees, you've done your treatment, you're doing well, I'm going to terminate your probation halfway through. Now, that doesn't sound like a lot, but I do mine right before my sentencing docket, and that's powerful. When an individual knows that if they go in and they work that probation hard and they can get off, they like it. And who else likes it is my court services and community corrections officers. You have 23,812 people on your registry in the state of Kansas. You can't tell me that's functional. That's bloated, and that's unusable. What happens in the 50% reduction on those probation is we're getting people out of probation that take time of court services and community corrections to watch. And those people don't need that time. And it frees up that court services and community corrections officer to spend time on the people that do need it. The same will happen in the registry. If you get the people off, and you talk about the drug registry, I think there's been 13 petitions that we're aware of filed. And this is not me. This is Ms. Brooklyn Graves from the KBI, who was kind enough to give this to us. One of them was filed before the time limit. 2.5 years had passed and it was denied. The other ones, I think, were all granted that we know of. Now, I contacted 3 of those jurisdictions and talked to judges in 2 of them, and I talked to court staff in another. One of the hearings lasted an hour, okay? And I thought, well, all right. The other hearings were hardly any time at all, and that's what I would expect. Person came in, filed the petition, the prosecutor looked at it, much like an expungement. I've been on the bench for 22 years. I have yet to have an expungement hearing. Prosecutor looked at it, they agreed, signed an order, submitted it. And that's what it had. Each of those judges said it went that quickly. So I would certainly encourage you to expand the exit mechanism for the registry. The second item I want to talk about is reducing penalties. When we first started Kansas Offender Registration Act in early 90s, Class A misdemeanor and private only available to law enforcement. Now, as Ms. Scott has informed you, you have a level 6 felony on a first violation, level 5 felony on a second violation, and a level 3 felony on a third or subsequent violation, or if you are an aggravated habitual out of compliance for a period of 180 days. Person or non-person depends on the crime. If your underlying is a drug felony, you're probably non-person. But if it's sexual offender or a violent offender, those are person felonies. Now, they already have one person felony on their record. Now, because they don't register, just register, you're tagging another personal felony. What that does to their criminal history is large, okay? And what happens is it's not just large, but it's long time in KDOC and bed space being taken up. It also presents the possibility of being ordered to register on a misdemeanor, sexual battery, not registering, and ending up with a level 6 person felony. That just doesn't sound right in that situation. If you fail to pay, as Ms. Scott informed you, Class A misdemeanor, if you have 2 or more pending, it's a level 9, depending, person, non-person, on the underlying sentence. In 2019, there was 442 people in prison solely on Kansas Offender Registration Act violations. That doesn't sound like a number that slaps you in the face.
Say that again for us.
In 2019, there was 442 individuals in KDOC solely for Kansas Offender Registration Act violation. Now, that number doesn't slap you in the face. It doesn't sound like a large number, 442. But it is a 65% increase over the previous 5 years. And it makes sense. The larger this registry gets, the more offenders you're going to have offend, and the more time you're going to have in KDOC. What we are recommending is kind of to turn back the clock a little bit. Make a first offense a Class B misdemeanor. Make a second offense a Class A misdemeanor. Make a third offense a level 8, all non-person felonies, non-person misdemeanors. What that does is it gives the judge some flexibility. So if you have an individual that violates the Kansas Offender Registration Act, you want them to register. So if that individual has a job, family, has a support staff, but just a ne'er-do-well on registering, what you can do on those misdemeanors, you can say, okay, now, we're not going to pump you up your criminal history and give you a felony, person felony. What we're going to do is we're going to put you in jail for 15 consecutive weekends when you don't work, and you're going to let you stay out, let him keep his job, let him keep the family going, and not take up bed space in KDOC. Also, we would ask that you would amend the presumptive prison only and make it allow only for aggravated violations. The aggravated violations, we would ask that you would extend from 180 days to 1 year out of compliance, and the violation terms 90 days instead of 30 days. Right now, they're required to register every 90 days. But if they're every 30 days, if they don't register, it's a different violation. It's a different felony, if you will. So we're asking that take out the 30 days, make it 90 days. That's the term they have to register. That makes sense. And failure to pay, simply a Class C misdemeanor. Single point registration, which a representative talked about earlier and kind of paved my way, did the hard work. Right now, and it's not unusual where we are, we're asking that it be a single point registration, not multi-county. That is cumbersome. I think this would be less burdensome, and the committee thought it'd be less burdensome on law enforcement and the individual. So right now, where I live, it's not unusual to have a person that lives in Dickinson County, work in Gary County, and go to college in Riley County. And they're registering in all those 3 counties 4 times a year. Makes much more sense to make them register where they live, make that information on the form that they have to divulge, they have to give up, where they're going to school, right? Where they're working. KBI can disseminate that information to the law enforcement in those counties, and you alleviate those the other $20 in each of those jurisdictions, and you take off the ability to violate that in those jurisdictions. The last matter I want to talk about is what was born out of the State v. Owens, and I'm sure it was a different Owens. In 2018, there was a Court of Appeals case that ruled that you can't have a sex offender, you can't hold them criminally liable for non-payment of a fee if you don't have a mechanism for them to be determined indigent or manifest hardship on them. And so that's what we've recommended. And we think this can be very simple. It happens a lot right now in pro se domestic cases, where I see it the most. When a pro se domestic case comes in, they'll file an affidavit, say, I don't have the money for filing fee. They submit the affidavit. I can look at how much money they make, what their bills are, and I can either say, listen, I'm going to waive the fee entirely. I'm going to make you pay it. We're going to look at this again at the end of the case, or I'm going to defer your payment. This would be the same way here, because when a person is found indigent in a criminal court, that lasts for 3 years. After that 3 years, there's no mechanism to determine that person indigent. $20 doesn't sound like a lot, but by and large, these people don't have 2 nickels to rub together. And again, incentive. You want them to register. So they simply would file an affidavit with the court where they register, where they live, asking that the hardship. Now that judge can either say, that's fine, we're not going to make you pay it this time, but next 90 days you got to pay it. He or she can also make that, make that manifest hardship last no more than 3 years. But it gives that individual and fills the request from the Court of Appeals. It gives that individual the ability for the manifest hardship. With that, I'm going to turn it over to Mr. Seth Westcott here, who did the first sex offender juvenile assessment in the state of Kansas under the contract. I'm going to turn it over to him, and I'll be happy to come up and stand for questions when he is completed. Is that okay, Madam Chair?
It's more than fine. Thank you so much,
You're very
Judge.
welcome.
Welcome to the committee, Seth.
Thank you, Madam Chair. Members of the committee, I appreciate the opportunity to come back and speak before you again. For those I haven't met, I'm Seth Westcott. I'm a licensed master's level psychologist in practice in Shawnee, Kansas. And as Judge Sexton mentioned, I was on the advisory committee for the registration reform. My position on that committee was to provide a clinical lens, a therapeutic lens to which we could view these issues. I have dedicated my professional career to the evaluation and treatment of individuals convicted of sexual offenses. I am a clinical member of the Association for the Treatment and Prevention of Sexual Abuse, ATSA, which is an international organization comprised of thousands of members across over 20 countries. I'm the co-chair of the Public Policy Committee for ATSA, and while it is important to know that many countries throughout the world have registries, the United States is the only country in the world that publicly registers adolescents for sexual crimes. In 2019, the ATSA Public Policy Committee embarked on a year-long plus project to understand registration laws, how they were formed, how they've evolved, and how they have been taken so far off track that their original intent and purpose has been lost. We enlisted the expertise of the leading researchers in the field, the most learned professionals. And in 2020, we published a series of documents related to registration reform, and it included a series of recommendations. Among them, the need to establish an exit mechanism for adults on the registry and an end to all juvenile and youthful registration. Now, that was a big step for our organization, an international organization making such a bold move. I remember some of the discussions on our committee, and there were some that believed that it was too far a limb to go out on for our committee, that we risked alienating stakeholders if we took such a strong stance. We were ultimately led to make that recommendation because the research led us there. When we stood back and took an objective look at the research, there was just no way to continue to justify the endorsement of such a misguided policy. At the same time the ATSA Public Policy Committee was doing its work, the Advisory Committee for the Judicial Council was embarked on a similar mission to look at registration and recommend statutory reforms. As Judge Sexton mentioned, that committee was comprised of legislators from both sides of the aisle, defense attorneys, a prosecutor, so you can imagine the lively discussions and spirited debate we had. Fortunately, we were led by a highly skilled judge that was able to moderate and guide us through as chair. Some of those same discussions we had in the ATSA committee were also had within the advisory committee. We didn't know how far out on a limb we should go with some of these changes because, let's be honest, some things aren't politically viable. We know this. We live in the real world. But the reality is, when we took an objective look at that data, the advisory committee came to the exact same conclusions and made the exact same recommendations. The remainder of my testimony will be focused on how we got to those recommendations, and I'll cover 3 important points. First, adolescents who commit sexual crimes are low risk. Second, these youth have underlying mental health concerns that trump any kind of legal concerns they may be having. And third, registration of youth is just bad public policy. Beginning with risk, most people believe that individuals who commit sexual crimes are higher risk. In fact, the words frightening and high are often thrown around to describe the recidivism estimates. The public believes that individuals who commit sexual crimes reoffend at a rate at about 75%. As Judge Sexton mentioned, adults, it's less than 8%. Department of Justice statistics puts the 9-year rearrest rate at 7.7% for individuals convicted of sexual crimes as adults. For adolescents, it's even less. My colleague Michael Caldwell published a meta-analysis that looked at 106 studies that included over 33,000 adolescents convicted of sexual crime and found that the average recidivism rate across all studies was 4.92%. And if you look at just studies over the last 20 years, the recidivism is 2.75%. 97% of youth who commit a sexual crime don't commit another one. These youth desist from further criminal sexual behavior because they don't have long-term sexual deviance. Their issues are more likely driven by underlying mental health issues, which brings me to the second point. Children and adolescents who commit sexual crimes usually have mental health conditions which could inhibit impulse control, healthy decision-making, and empathy. Many come from abject conditions, have been exposed to violence, witnessed physical or sexual abuse, or have had adverse childhood experiences, or ACEs, which we know lead to problematic behavior. Youth who commit sexual crimes have higher rates of autism spectrum disorder and lower IQs. These youth are more likely to act out against someone they know, not because of long-lasting sexual deviance, but because they are unable to handle emerging sexuality in healthy ways. They haven't had enough education on things like consent, boundaries, and healthy sexuality. They need supportive environments where they can grow protective factors that keep them on a path toward healthy behaviors. Registration is an impediment, a roadblock on that path. Registration has social, emotional, and psychological consequences that far outlast any risk that the individual may have. Research has found that children and adolescents who are on the registry have increased shame, stigma, isolation, social difficulties, educational difficulties, as opposed to those who are not on the registry. These are all factors that are associated with an increased risk of recidivism for adults. Youth on the registry face adverse consequences such as difficulties in educational settings and ongoing harassment. And I wish I could say that these were ethereal concepts, but I happen to know firsthand about some individuals that are on the registry that have had to change schools, had to drop out of schools, had to be homeschooled simply because of the harassment that they faced on an ongoing process. Reducing access to pro-social activities leads them toward a path that we don't want them to be. We need to increase their opportunities for success. So finally, registration of youth is just bad public policy. And remember, registry was never supposed to apply to youth. It was originally intended as a law enforcement only tool for adults. Patty Wetterling, in her initial intent for registry, sought to make this a law enforcement tool that was only applicable to adults. Following the death of Megan Kanka, the registries expanded to include a public-facing provision. Then came the Adam Walsh Act, and for the first time, it required registration of adolescents. Registration is sold as a way to protect the public, but we know that this is not reality. We know this because it was predicated on the assumption, the myth of stranger danger, that we need to protect our kids from those that they are unaware of because some stranger may hurt them. The reality is the overwhelming majority of victims are known to the offenders. Children and adolescents who commit sexual crimes typically do so against family members or acquaintances. Victims that are strangers account for only 2.5% of all adolescent sex offenses. 2.5%. So when we talk about using registration as a means to protect the public, who exactly are we protecting them from? There have been numerous studies on the unintended consequences of registration. Youth on the registry are 4 times more likely to attempt suicide. They are 5 times as likely to be approached by an adult for sex, and they are twice as likely to be the victim of hands-on sexual offending. We know that there is no discernible difference between a public registry and a private registry regarding the adverse consequences and the unintended consequences that can apply to adolescents on the registry. So the idea that a private registry may somehow solve the issue is just simply not supported through research. I've told you guys about some numbers, and I'd like to tell you about a couple of very quick stories about kids that are subject to the registry in our state. 15-year-old girl and another 15-year-old girl in the bathroom at a school. They're in adjoining stalls and they are changing for a school dance. Then one of the girls takes out her phone and reaches over the top of the stall and starts recording the other girl as she's changing. And the girl looks up, sees her, ooh, stop, quit it, and she does. And they both start laughing about it and kind of laugh it off. But the girl doesn't delete the video from her phone. And a few days later, a boy at school swipes her phone, starts going through the camera roll, finds that video, and texts it to himself, and then sends it everywhere. The girl who took the video, charged with sexual exploitation of a child, subject to 25 years registration. 13-year-old boy, 14-year-old girl are sitting in class. He's in the 7th grade, she's in the 8th grade, and they're texting. She says, "Do you want to go have sex?" He says, "Sure." They make arrangements to meet in the 8th grade girl's bathroom. They walk out, school resource officers walking by, says, "What have you guys been doing?" And they decide to tell the truth. 13-year-old boy, 14-year-old girl, both charged with rape. He's subject to lifetime registration at 13. These are not out of the norm. These are our kids. They go to our schools. They play on our soccer teams. These are our kids. We've talked, I believe this is our 3rd time now appearing on this issue, and it's been several years since we started this journey, and it's a long journey. I was at a conference recently, and I heard the great Michael Cito speak about a number of topics, including public policy, and he reminded us that public policy work is hard work, and it takes a long time to affect change. He said public policy is like pushing a rock uphill, and the rock is square and doesn't want to look soft on crime. And he was right. My hope is that you'll agree that this is a rock worth pushing. So thank you, Madam Chair. I'll stand for your questions.
Committee, let's go ahead and have our judge come to the mic also. Both of you just stay up there and let's hear our questions. We'll start with Representative Heiberger.
Thank you, Madam Chair. This is for Judge Sexton. You hit on this in your testimony, but could you talk a little more about how some of the penalties for failure to register are a lot more severe than the underlying offenses?
Well,
Please step to the mic.
Yes, I'm sorry.
That's okay.
In Kansas, I tell people that all the time, I should know. In Kansas, you have the ability, sexual battery is a misdemeanor. You have the ability, and there's a lot of other ones too. There are lower level felonies also that you have to register for. But a violation of those is a level 6 person felony. That's significant because those are all presumptive prison boxes on a level 6. Second violation, level 5 person felony. Third violation, subsequent level 3. Those are significant because if you come in with the worst case scenario, the sexual battery, class A misdemeanor, 1 year in jail, $2,500 fine, and you don't register, now you're looking at a level 6 person felony. What it does to the criminal history and the bed space at KDOC, you're seeing happen with the individuals I stated. So very often they're either equal to or higher, possibly.
Senator Dahl.
Thank you, Madam Chair. Because social media, telephones, all that has become so prevalent, you know, you were giving us statistics. Have the statistics seems that they would have to have grown because it's more prevalent. I think it's always been going on. I don't know, but that would be my assumption. But now with social media and such, so have those statistics in the last 10 years, 15 years have gone dramatically up, or where are we at on this?
It's an excellent question, and yes, they've exploded. The number of adolescents that are committing sexual crimes with an underlying use of technology has grown exponentially over the past few years. And we are seeing an increase in the amount of youth who are being charged with crimes, being adjudicated for crimes that started out over Snapchat, started out over other kinds of social media.
Follow up.
Thank you, Madam Chair. In your professional opinion, do you think there has been an increase or just it's been exposed? Because obviously it's been going on forever.
It's excellent. I don't have the numbers on the amount of people that have been arrested year to year. I would say in my clinical experience, it has increased because of the use of social media. We have not been able, this is the first generation that's grown up with social media. This is the first generation that has had the ability to walk around with this kind of technology and communication in their back pocket, and it has caused increasingly difficulties. The biggest difficulty is that the law hasn't caught up with the behavior. In the state of Kansas, the legal age of consent is 16, and so 2 high school sophomores over the age of consent can have sex with each other legally, but if they videotape it, then it becomes a crime. If they send it to somewhere, it becomes an even bigger crime. Kids don't know that. They don't realize those things. So they are getting caught for those types of behaviors which didn't exist, those kinds of situations which didn't exist 10 years ago.
Other questions? Representative Hoy.
Thank you, Madam Chair. You had mentioned that having this public registry for juveniles increases the likelihood that these individuals would be solicited by others. And so do you have any more information or data and provide a little more background on how that could be placing these young individuals in danger?
Yes, excellent question, Representative. And our colleague in Florida, Jill Levinson, who does this research consistently, has suggested that one of the issues that placing children on a public registry does is allow for them to become more vulnerable, which is making them more susceptible to individuals that may prey on that vulnerability. They have increased shame, isolation, stigma, and decreased hopelessness decreased hope for the future. Those kinds of emotional attributes are sometimes enticing to individuals who may want to prey on them.
Representative Owens.
Thank you, Madam Chair. And
I just want to make sure I heard this correctly. And you said we're the only state in the nation that puts juveniles on a sex offender registry.
We're the only nation in the world who publicly registers juveniles.
Okay, the only nation. Are we the only state?
No, there
Okay.
are others. There are 17 states and DC, I believe, that do not register adolescents. Of the states that neighbor Kansas, Nebraska is the only state that does not register adolescents, and that is because they have deemed that those individuals are adjudicated and not convicted, and therefore do not qualify for registration. I would also note that the state of Colorado last year, their state Supreme Court ruled that lifetime mandatory registration for adolescents constituted cruel and unusual punishment, and so that has been repealed. So things are starting to change nationwide.
Thank you.
Talk to us a little bit about, you mentioned the 442 that were in Department of Corrections in 2019 for registry violations. So the only reason they were in prison is because they hadn't kept up with the Q3 months register.
Correct.
It's not that they committed a crime.
Now, you can actually, if you have an individual that's lifetime and they can actually, they're going to be on post-release supervision period forever. Also, that's important to keep in mind because we are keeping track of those individuals with post-release supervision. But their case can actually be concluded, their time concluded. And so the violation creates another felony. So that's how that happens.
Okay, and I think the Department of Corrections tomorrow can share with us. We know there's a cost associated, a daily cost for the individuals being incarcerated.
I used to tell individuals, and when you have a tough sentencing and people are wondering why you're giving someone probation over putting them in prison, and this data is probably like 10 years old or something, but I've been told recently it's like $90-some a day to keep somebody in prison every day. Treatment is about $7 to $8 a day. And that's why you see a lot of drug courts now involving and trying to invest in the community rather than jails, prisons.
Thank you. Senator Falscadeau.
Thank you, Madam Chair. Honorable Ben Sexton.
Ben's fine.
So, I mean, a real-life situation. The chair scheduled for us to go yesterday to the Shawnee County Drug Court. And so we were able to see tangibly exactly what you just described of that incentive. I'll review your case again. And we saw, Madam Chair, at the end of the gentleman's completion, he got the little coin or just acknowledgement. So I appreciate you sharing that. I was wondering if you had a real life situation to whereas, that person got that second chance. And then Seth, I wanted to ask you, so how do we address ignorance of the law? It's no excuse for the teens that you spoke of. Thank you, Madam Chair.
I could go on and on. We just started a drug court in Dickinson County in March. And there's a reason why we started the 50% review a lot earlier, because that relationship between the judge and the defendant, when that defendant hears good things from the judge, even though that judge stands on a lot of people doing all the hard work, but that relationship is tremendously important. And so at that 50% review, if an individual is not quite there and doesn't have it, but I can look at them and say, you're doing a really good job. You need to keep it up. You're doing just fine. You're becoming a productive member of society. That means something to those people. Drug court's the same way. And the reverse is true. If you look at them and say, I'm so disappointed in you, it crushes them. They want to do well. So it's extreme, that relationship, and that's why we did the 50% review, to get the judges to have more interaction with those defendants in non-drug cases.
Thank you, Senator. I do believe that we need to do a better job of educating our kids. And you'd be surprised at the number of youth that I evaluate, and I ask them where they got their sex education from, and the first answer is always pornography. The second answer is friends at school. And when I ask about things that they may have learned at school, they may have said, well, there was a class one day on that. When I ask about what they've learned at home, it wasn't talked about. So we as parents beginning as parents, need to do a better job of talking about it, having these real-life discussions with our kids. I've got 4 kids, and they range in age from 12 to 17, and they all know the age of consent. They all know what consent means, affirmative consent, boundaries, these things. Unfortunately, not every parent approaches parenting the same way and provides those open and honest discussions. And so ultimately, it is left to the criminal justice system at times, whose responsibility it shouldn't be, to make these calls and to teach our kids.
Madam Chair,
Absolutely.
your answer, your question as to whether or not they've blown up. I've been given talks in middle schools, and I started about, I'd guess 15, 16 years ago, to 6th, 7th, and 8th graders on this subject. And when I initially started having this conversation about sex offenses and what can happen to you down the road, I'd say, who has a cell phone? Well, at the beginning of that, about 15, 16 years ago, I saw a bunch of flip phones come up, but not very many. I haven't given that talk in 5 years, but when I ended it, because of just too much responsibilities, when I asked for cell phones, I'd guess 90, 95% were all smartphones. And I'd look at them and say, we legislate you on smoking, drinking, having sex, driving, voting, but we haven't legislated you. We've just given you the world in that phone. And that is so it has blown up tremendously. I sign inquisition after inquisition after inquisition daily to Snapchat, Facebook, all those things that I have no clue what it is, but I know that there's social media, Twitter, et cetera, asking for all the information off those people's IP addresses.
I think we've all seen examples where someone's life was literally in danger, and it was all being documented on the phones, but no one was stepping in to intervene or to provide assistance. The cell phone, particularly with the video and the camera mechanism, can truly be used as a weapon. So talk to us with regard to what, from a legislative standpoint, proactively, I understand this notion of juveniles being off the registry, but what are other things that can be done? We keep hearing about kids going into foster care because of they're minors and they have been involved in sexual assaults. So what do we do to break that cycle? And one thing we haven't heard about is what is appropriate assessment and treatment for children that have been victims or have committed a sexual assault on another minor?
Thank you, Madam Chair. I'd like to start with the second part of that question, if I can. I have evaluated over 500 individuals in my career that have been accused or adjudicated or convicted of sexual offenses. And the first step is always psychoeducation about sexuality, healthy sexuality, boundaries, consent, what those things mean. Treatment often includes mental health treatment. It doesn't have to include sex offender treatment. We know that these individuals don't reoffend at alarming rates. We know that mental health interventions are more likely to be successful with them than traditional relapse prevention. We need to prevent some sort of reoffending approach. So I would suggest more money into mental health and providing appropriate providers statewide. Access to services can be difficult. One thing that COVID did allow is the provision for telehealth and telemedicine to really take hold. And there are youth that I evaluate in all 4 corners of the state via telemedicine. So that is one thing. The other thing I would suggest is more prevention. Prevention begins everywhere. Prevention begins at home. Prevention begins in the classroom. More education about what healthy sexuality should look like, affirmative consent, boundaries, how we establish those things in the age of technology. How do we establish those kinds of courtship rituals that are now done with emojis over text and over social media? Those kinds of things are paramount to these. I'll let Judge Sexton talk about legislation.
This is scary. You're hitting me in a spot that really is one of my pet peeves. Ask if you have DCF up here sometime. Ask them how many children they have in their custody that they don't have places for. And I'm talking places, I'm talking ask how many, where they spend the night at, and where they spend the night before, and where they spent the night before that, because they're generally going to be 3 different places. The individuals that create those problems that are sex offenders, they don't have any place for them. And nobody wants them because of what they bring to the table, because of the lack of the understanding that Mr. Westcott relayed today. But I came really close. I kept climbing the ladder on contempt citations because I had a kid that I kept getting these notices of change of placement. And so I finally pulled in the powers that be and I said, where's this kid been the last 10 days? 10 different places, 10 different days. Mm-hmm. And then when they got done with the place, they took him into work and they just let him in work, not in school, not getting any treatment, just moving him around because no place. They don't have, and is it PRTF? I'm not good with acronyms. That needs to be invested in. We need more. There are more children that are that have these disease or problems. That has to be expanded because right now we'll have kids like that and they'll say, well, the wait list is 6 months, and somebody can hop them if they consider them more dangerous. So you'll have it's extremely frustrating because the one question I looked at them and said, you know, you're the parents to DCF. And if I had parents come in with me, I would take custody away from those parents. I wouldn't allow parents to have children spending the night someplace different every night. So if I had one piece of legislation, that would be it with juveniles.
Well, the interesting thing is we have a class action lawsuit that mandated zero times per day should any child be spending the night in an office. And yet we know that's not happening.
Correct.
In fact, at our recent committee meeting, it was Cornerstones of Care shared about, oh, it's really nice because we have these bunk beds set up. And to me, it is a recipe for disaster. And that's why we're seeing teens run. But talk to us. So I'm getting a little bit of mixed messages. So share with us, a minor commits a sexual assault. It's someone they know more often than not, or a family member more often than not. So if they're in a foster group home setting, or in a foster home, that's someone that they now know. But what type of services is it that they need to receive so that we don't have repeat sex offenses? Because in a sense, a child that goes into foster care is going to start having the issues that you identified: low self-esteem, doesn't have the family support system, is typically going to be failing in many courses in school. So those are the kinds of kids, at least by the time they're middle school or high school, that are in foster, that exhibit all of those types of things that you talked about. So what type of services do they truly need to receive? And I suspect we don't have 50 or 100 of you, Seth, that can provide those, that have that background.
We don't, but there are some of us out there. The first step is to do an evaluation to determine exactly what is going on, what the individual needs, what the risk issues are. The second step, and it can be done in tandem, is safety. To ensure that there is safety that exists within that foster home, that the individuals that are vulnerable and susceptible to abuse are put in no more danger. We want to do no harm to make sure that they are all safe there. So if there is sexual abuse going on, regardless of motivation or anything, those individuals need to be separated at least for a period of time, move to safer environments. The second step in terms of therapy and intervention is that the therapy, the intervention needs to be matched to the level of clinical need. And that's where the specialization comes in. That's where the mental health experts come in to determine what the mental health issues are. Oftentimes, individuals in these kinds of settings have underlying autism spectrum disorders, learning difficulties, things like that. Throwing them into a setting, a treatment setting where we're just talking about consent and things like that is inadequate. We need to match the level of resources and intervention with the level of mental health need. Let the criminal justice system play out separately if needed, but mental health intervention would be paramount.
Senator Dahl.
Thank you, Madam Chair. In previous life, I taught at an alternate school. Probably 100 kids in that school. That particular school, probably 80% of them were of race. Wasn't a fashion statement either. 40% of those kids were homeless, and I'm not talking about where they're going to sleep that night. They were sleeping. One of them you may have heard of, Victor Ortiz, who fought Floyd Merriweather. He slept in a box on a street in Garden City. We're not even talking about foster care. I recall a student that fell asleep in my class, and I was getting on her. Well, the next class comes in, and he says, "Did Kelly come by your house last night?" And she said, "Yeah, come by about midnight, but Mom wouldn't let her stay there." Another one says, "Yeah, she came by our house at 3. Mom said she could spend the night there, but she couldn't come back." So I have no idea where Kelly slept the next night. Not there. I felt so awful because I was chewing her out for sleeping. How many kids do we have like that are not even in the foster? This is one city, and not a small city at that. How many kids, is there an estimate of how many kids we have like that that's not even in the foster care system that are dealing with that? And of course they're going to go to crime. I mean, they got to eat.
You're absolutely right. And thank you, Senator. You've highlighted the exact root of this issue, which is adverse childhood experiences and mental health abject conditions that these youth experience on a daily basis. It doesn't always translate to inappropriate or problematic sexual behavior. It can translate to other criminal behavior, drugs, violent behaviors, things like that. We know this. So the issue is not long-lasting, pervasive sexual deviance with these kids. The issue is safe environments to begin with, providing them with a safe home to get their needs met in healthy, pro-social ways. And unfortunately, there are so many. I don't even have an estimate of how many there would be.
The job of choice for a lot of these kids were mules. And one kid at lunchtime, he said, "Hey, you want to see where I got shot 3 times?" Because he came up from Mexico. I said, you don't even like it here. What are you doing here? And he goes, my mom made me come. And he showed me his 3 bullet holes that he got shot. But he said, "Mr. Dahl, there's about 7 of us here that were mules, when they were growing up." And that's not even in the foster care. This is America. I don't know. I just had to get that out.
We appreciate that you do. We need to talk about it. Senator Fausto.
Madam Chair, thank you. There's a term that's used in part of my inner city district called the pipeline to prison. And so one situation, Madam Chair, is where there was a domestic violence issue, so police were called. And so the children, when we talk about networking, so when the police show up on the scene for that domestic violence issue, so they don't have a direct telephone number. And I think our wonderful Ed Klump has talked about that networking that we need, Madam Chair, in our child welfare committees. So sometimes they don't have, they tell the perpetrator to leave, perhaps, or they tell the victim go to a shelter, but usually they might take maybe both of them to jail. And then there's the children. So in Wichita, they might go to the children's home if the police officer can't find that family member or that close friend or family friend to take the children. So then, when you mentioned, Seth, when you mentioned that if they're going from a negative scene, and they're put into a group home, you mentioned that to avoid what the chairwoman asked you of that intertwining of, and of, so you mentioned that they needed to be evaluated when? Prior to that night? So the police take them and they go put it, they're in that situation. Where does your evaluation come in? And who's evaluating the children? Are we talking about the police, DCF, or your department?
Evaluation is an ongoing process, and so I would evaluate early, often, consistently with mental health professionals, with qualified mental health professionals that are able to assess and diagnose not only mental health conditions, but issues of trauma. Trauma-informed care is incredibly important with these youth. I would assess and evaluate prior to placement and immediately after being placed, and ongoing assessment prior to release to make sure that release recommendations are appropriate and can be followed.
Representative Hoffman.
Thank you, Madam Chair. Seth, do you have any idea, a number as far as percent of cases that, like what you mentioned, those two, especially the ones with the boy and the girl, what percent of those that are being convicted are cases like that? Do you have any idea? I mean, that's maybe kind of hard to know, but.
Of the cases I've seen, it's an excellent question, Representative. They are in the minority. What I see more likely, or more than anything else, is the 15-year-old boy and the 7-year-old stepsister or niece. And that boy has an autism spectrum disorder. And he is acting out sexually because he's going through puberty, he's going through adolescence, and he's exploring. And he doesn't know how to handle these sexual impulses. And so he is engaging in inappropriate touching, not with malicious intent, not with criminal intent, not to force or harm, but simply as a means to express himself sexually because he doesn't know. He can't express himself sexually with 15-year-olds because he's on the emotional level, the intellectual level of a 7-year-old. And so that is who he acts out against. That is the overwhelming majority of individuals that I see.
So as a follow-up to that, but those are not the individuals that you're seeing on, or are they the individuals that you're seeing on the registry?
They are, because that individual can be charged with aggravated indecent liberties with a child and subject to, is it lifetime registration for that?
So when we talk about the juvenile registry, how many of the kids do we know, how many of the kids, the juveniles that are on the registry, have repeat offenses? Do we know that? In Kansas. Now we're talking about data in Kansas.
I don't have that. I do believe that the KBI will share some data regarding how many also have a concurrent adult offense, and I believe the number translates out to about 26%, but that number does not specify how many are repeat sexual offenses versus later violent offenses or drug offenses, which are also registerable.
Okay.
There are 703 offenders ordered to register as a juvenile in the state of Kansas. 518 are registering only for a juvenile conviction, and the private registry is 327, and the public registry is 376. And part of it ties in, excuse me, I'm sorry, I'm microphone again, right? Part of it ties in to your question. When you put children on the registry, it doesn't just affect the kids. It's the entire family that's affected. And so you may have a situation where it breaks the family up, which is very common, and end up in a child needed care proceeding in order for the family to survive. So it affects more than just the child we're talking about here. It's the whole family dynamic.
Senator Foskett.
Madam Chair, and those listening and here, and maybe you guys can help me on this one. And I think it's important for people to know this exactly, what I just recently dealt with in my district. So I received a phone call from people, I knew them from school, and we're about the same age. And she's a grandmother, but I'm not yet. So anyway, the night before I received this phone call, I'm watching the news. And I see these two young black guys. Their faces are plastered on the plastered. Thank you, on the TV, and they said that they were arrested for sex crimes. And I'm like, oh wow, that's pretty sad. And something else, Madam Chair, that happens, and I've been documenting this for years, is that, and it's just a fact, that when it's a black person, a black male especially, their face, it's like the TV zooms in, and they look more violent and scary, and as opposed to a Caucasian person. Sometimes when I'm looking at it, I don't know if they're the criminal or the attorney. I don't know. So anyway, so the next day I get this call, and the grandmother is telling me, my grandsons were on the news yesterday. Madam Chair, so when these two young men who were just about to graduate high school, they're 17 now, when they were 10 years old, they were playing with their girl cousins who were 7 and 8. And so just exploring, as Seth mentioned, they were 10 years old. So, but then the domestic violence situation happened with the daughter of the grandmother, the two daughters who are now like 15 or 17 now, and they were 7 and 8, if my math is correct. And so, but there was a domestic violence situation in that household. So when the police came and just different questions and so forth, it turned into a DCF sink case for the 14 and 15-year-old girls. And in that intake process, they were just sharing what happened to them over the years when they were 7 and 8 by their 10-year-old twin cousins. However, the media made it like they committed this crime yesterday. Their lives are ruined now, and I'm getting emotional about it because I really couldn't help the family, so I called the district attorney in my area. I'm like, what's wrong? And then finally I got a hold to the DCF worker who, you know, when she made her report, and then she called the police, and the police came and arrested these young men. And so, but they were never charged with anything years ago even. But now they're being, the sex registry that you're speaking of, they're being asked to be put on there for, I mean, how is that even possible? And are those some of the cases that you're seeing that are affecting people's individual and families' lives for generation to come?
Yes, I've actually seen several cases where an individual is adjudicated for an offense that occurred 4 to 5 years prior that was never reported, and that was suddenly reported to someone, an outcry witness, and then the teenager had their lives completely disrupted. Once information is public, there is no control over who has access to it. And one of the difficulties in this job is helping parents understand that they didn't do anything particularly wrong in some cases, and that information that has become public that has had such a detrimental effect on their family is such an unfortunate consequence. The numbers about youth who attempt suicide are not pulled out of the air. Those are real cases. And unfortunately, I happen to know of a 14-year-old who was publicly harassed because of his information regarding his sex offense that came out. And he had an underlying autism spectrum disorder. And there was constant ongoing harassment by school, by peers, by social media, and he took his own life. And he was one of our residents.
Madam Chair and Seth and the Honorable Sexton, so is it something that we can do, Madam Chair, to whereas if DCF encounters a situation like that in the future, or do you have any suggestions of that until that evaluation or that 72 hours or that investigation is done, that entity could not call the media to tell the story? Or is it automatic that if DCF reports something like that, then the police are automatically, or was it that the police were initiated through the domestic violence situation, and then that just snowballed to the media to tell the story before the investigation? How do we prevent that?
I don't know enough about DCF policy to know where their obligations in terms of reporting are, so I wouldn't be able to comment specifically on that.
We go to great lengths to protect children. No-brainer. That should not happen. That information should be kept quiet. I've recently had a request from a journalistic entity that asked that wants access to all the sync cases in a certain county that I'm chief judge on. No, we're not going to do that. There's nothing good can come about that. And she goes, well, I want to shine the light. And I go, well, there's other ways to do that, but I'm not going to exploit children. Can't, never should happen.
Thank you, gentlemen. I know that I'm sorry, was there Representative Carlin?
Thank you, Madam Chair. I just been here a while, starting my 12th term or 11th term, I don't know, starting in January. And I was here when we passed a education policy that requires opt-in for sex education. Does someone on this research or revisers panel know if that's still in effect? I don't remember it ever changing. But now, from that time forward, I assume that the policy for sex education in schools has to be an opt-in by the families. That broke my heart because most families don't pay attention to enough. And like one of you said, parents don't talk about it. My own mother, I remember as a teenager she said, my mother never told me. And that's what I got from my mother. So I learned on the bus going to band parades, what sex is all about from the girls. But the other thing I wanted to mention is a few years back when we were cutting costs about $500 million a year, we had a bill or somehow or other an executive order or a bill to cut the number of children in PRTF care from 500, which had been the standard for years. About 500 average kids would be in PRTF care in Kansas to 200, and they sent 300 kids home. One of those kids was from my district, and when he had been home less than 24 hours, he raped his mother. And so now he's in that category of someone who should have been in protective care and had been doing all right there, went home and it exploded. I don't know how many we have in PRTF care now. I know it's kind of gradually we've increased that. There's been some amendments in the budget or something about that, but do you know? Does one of you know how many are? Okay, there may not, I mean, that limit probably still stands as law, but we have tried to improve that situation a couple of ways, and I don't have the details on that. Maybe somebody can tell us
I
later.
think we'll have legislative research, find out what they can with regard to PRTF. I think that would be helpful. You're welcome. Gentlemen, thank you. We now have Brooklyn Graves, Manager of the Offender Registration Unit for the KBI. Brooklyn, thank you for being here today.
Madam Chair, thank you for having me today. And to the rest of the committee, thank you for giving me the opportunity to share this information with you. For those of you that I haven't met, my name is Brooklyn Graves, and I am the manager of the Offender Registration Unit at the Kansas Bureau of Investigation. First and foremost, I know when this testimony was requested, we were requested to provide information and data analytics on our website itself, the public-facing website. Unfortunately, in working with our IT department, the system just wasn't created to be queried that way, and so I'm unable to provide that information. However, I have prepared a presentation that I can provide an overview of offender registration and other data analytics that were available. In 1993, we can go to the next slide. Yep, sorry. In 1993, the Habitual Sex Offender Act was put into place by the legislature. This required offenders be subject to registration if they were convicted of 2 or more sexually violent crimes. This was a private registry. In 1994, this act was amended and the name was changed to the Kansas Offender Registration Act, which is what we know it to be today. They also changed the requirement from being 2 or more sexually violent crimes to 1 sexually violent crime, and they did make this open for public inspection. In 1996, the Kansas Supreme Court ruled that the public access portion of the act was unconstitutional for crimes committed prior to April 14th of 1994. Fast forwarding to today, per the Kansas Offender Registration Act, we now register 3 types of offenders. We have sex offenders, violent offenders, and drug offenders. As you will see there is a 4th category that I think is important to mention, and this is general offenders. If you look in the Kansas Offender Registration Act, you won't find the term general offender. However, there are some circumstances where judges have ordered registration for offenses that weren't otherwise required for registration. They also determined that they didn't fit in one of those other 3 categories, and so we were forced to create a general offender category to capture these individuals. Individuals that are required to register must report to the sheriff's office where they're living, working, and going to school on a quarterly basis. When they go and complete these registrations, they do have to remit the $20 payment, which I know has been mentioned several times at this point. I would like to mention that the requirement to register in all 3 of those locations is a part of the requirements to be Adam Walsh compliant or SORNA compliant. There may be some circumstances where an offender may have to register more often than quarterly. So for an example, if someone has to register in January, and they go ahead and do so, but then in February, they change schools, change their address, etc., they do then have to go and report that to their sheriff's office within 3 business days. However, if it is outside of those quarterly registration requirements, they do not have to remit that $20 payment. Finally, and this kind of goes without saying after Seth's testimony, but we do require registration for juveniles in the state of Kansas. Some are on the private registry, some are on the public. The registration obligation for juveniles does not change in comparison to adults, so they do still have to register for 4 times a year, so quarterly, and they do still have to remit a $20 payment. However, the duration of registration can differ for those juveniles. This is a list of all of the sex offenses that require registration for adult offenders. This was included in the written testimony that was submitted, so I don't intend to go through all of it. However, I do want to point out the 3 most recent additions to the list of requiring registration. We have internet trading of child pornography. we have breach of privacy, and then aggravated internet trading of child pornography. These 3 were added in the last legislative session. This is a list of all of the violent offenses requiring registration in the state of Kansas for adult offenders. There haven't been any recent additions here. However, I wanted to provide them to you. And finally, these are the 3 offenses that require registration for drug offenders in the state of Kansas. Similar to violent offenses, there haven't been any recent additions. Up until this last legislative session, there has been no way for offenders to get off the registry early. If their offense required a 15-year registration, 25-year registration, they were committed to that time, and there was nothing they could do to get off. However, again, in this last legislative session, they created an exit mechanism for drug offenders that had been compliant for at least 5 years. This 5-year time period could not include any periods of incarceration or noncompliance. If an offender believes that they qualify for such relief, they will then petition in the court of conviction and go through the court proceedings to get that relief.
We have a question, Senator Corson.
A quick question about that. How much judicial discretion is involved in that determination? If somebody has been on there for 5 years, they've been doing everything that they're supposed to be, and then they make that essentially like an application or they petition the court, how much judicial discretion is there of whether or not that they can get off of the registry?
So part of the petition process is to evaluate whether or not that individual is still a threat to society. And so that would be the discretion that I would refer to. However, Judge Sexton may be able to answer that better than I would be able to.
Senator Sexton, or we just made you a senator, Judge. I don't know if that's a compliment or an insult. Sorry.
It all brought you all down a little bit if you do that. It would be up to the judge to determine, so total discretion, but you have to have a finding of clear and convincing evidence as to why that should happen. So same criteria would be on a child needed care case when you're talking about terminating parental rights, that clear and convincing evidence, high bar.
So I guess not to put words in your mouth, but it gets back to what is the judge's mindset? Is that correct? That, you know what, you did this, and so you're going to stay on that list?
Very much so. But it's that way at every tier of the situation, yeah. Prosecutor on up, yeah.
Okay. All right.
Thank you, Madam Chair. So I know, again, that I wasn't able to provide the website data analytics that we were hoping for. However, I do have some other data that I think may be relevant to you all. As you can see, there's been a significant increase in registered offenders over the past few years. Specifically, this shows a 31% increase in registration records over a 6-year period. This shows the number of active records as of November 16th of 2022. We have 11,416 sex offenders, 6,215 violent offenders, 6,153 drug offenders, 661 offenders that were registering as more than one offender type, meaning that they were registering as drug and violent or sex and drug, etc. And then we have 8 general offenders, which I explained earlier. There are 20,553 men on the registry and 2,629 females on the registry. Females account for approximately 11% of all registered offenders in the state of Kansas. This shows the top 10 counties with the most registered offender population. The largest, we have Sedgwick, and then going down from there, we have Wyandotte, Johnson, Shawnee, Reno, Leavenworth, Saline, Douglas, Butler, and Ford. This is the top 10 counties with the most non-compliant offender population, starting with Wyandotte, Sedgwick, Shawnee Johnson, Harvey Leavenworth, Lyon, Celine, Ford, and Montgomery. All of this information, assuming individuals are on the public registry, is again accessible to the public and can be accessed by simply Googling Kansas Offender Registry, or you can access it directly through the KBI's website at ks.gov/KBI. Go to registered offender and then conduct a registered offender search. There are multiple ways to query the information on the public site. You can search by name, you can search by geographical location, and then you can also search by online identities. So email addresses, phone numbers, all of that is available. In each of those searches, there is the ability to filter your search. So if you want to know specifically compliant offenders, non-compliant offenders, if you'd like to know just sex offenders or just drug, sex and drug, etc., it does have the ability to do that. On the public website, there is also the ability for the public to sign up for community notifications. And this is where, excuse me, this is where you can enter an address and sign up to be notified anytime anyone moves in or out of a 1, 2, or a 3-mile radius of the address that you've registered for. I would like to note that the community notification is not specific to one offender. So if I am very concerned about John Smith and I would like to know, I'd like to track him, I'd like to know any time he changes his address, it does not have the ability to do that. This is a screenshot from our public website that shows a 1-mile radius of the KBI building. All of those marks there show the number of offenders. They are color-coded. So green is going to show drug offenders, pink will be sex offenders, blue will be violent offenders, purple is the multiple offenders we discussed, and then yellow will be general offender. So at this time, I would like to pull up the actual registry and give you a little bit of a demonstration as to what that looks like.
It's not funny, but you had a lot of offenders hanging around the KBI area.
Yes, wait until I show you the number around here, which is what we're going to do next.
She said around, not here.
Around here, yes.
Representative Resman.
Thank you, Madam Chair. On your graphic there where it showed non-compliance, is that for a year or is that, I mean, is that for current or is that, what's the date range on that?
That's current. So as of November 16th, when I ran the information, ran the data, that was the number of registered or non-compliant registered offenders at that time in that county.
And how far back does that go? Is that does people drop off of that list when they register and then you add?
Yes, it's a I'll say a rotating list, meaning that once they register, they would come off of the non-compliant list, yes. Okay, so this is what our public-facing website looks like. And again, I mentioned the two ways that you can access this website. The first search here is a name search, and I was hoping to be able to give them to show them actually what a record looks like. Can you type in the first name, A test? All one word. Yep, and then last name, A test. Okay, and then search. Okay, so this clearly is a test record. However, I searched first and last name. It pops up with an individual that is on the registry. If you wouldn't mind selecting their name so I can show them the information that's available. Thank you. On this main tab here, you'll see where it says test in big, that would typically be a picture, but for the sake of the test, there is no picture. We'll have first name, middle name, last name, also any aliases. So if they went by B test in the past, that would be an alias they would list there. We have gender, race, date of birth, their primary address, that at 300 Southwest 10th Street is the capital's address. So again, just a test record. We have a physical description, including hair color and eye color. And then scrolling down, we have the offense that they were convicted of. In this scenario, it was a breach of privacy. We have the offense date, statute, where it occurred, and then if there were to be victim information available, that would be listed here as well. If you wouldn't mind scrolling back to the top, please. If you go over to other addresses, this is where school information will be available. My test record isn't in school right now, so there is nothing there. However, you'll also see the employer address is not available. It's not visible to the public, but if they were to contact their local sheriff's office, that information is technically public access. If you could go to the next tab, please. SCARs, yep, just one to your right. Thank you. So nothing here, but we do list scars. If there was, ACL surgery that left a large scar and they report that to their sheriff's office, that would be listed here. And then going over to tattoos. This test record has a tattoo on her right ankle of a palm tree. If there's 50 different tattoos, those would all be listed here, visible to the public. Vehicle information, please. We can see that this test record drives a 2020 Honda Pilot. It is white. We have the vehicle license plate number and the state that it's registered in. And then we also have a tab where we would list any boat information, which would include jet skis and other type of watercraft. Can we go back to the front page, please? Go to, name search. Perfect. And then I'm actually going to have you go to geographical, I'm sorry. Perfect. So this is the geographical search that I talked about earlier. I am going to have have us enter the capital's address, 300 West 10th, and that's in Topeka and Shawnee County. And the zip code is 66612. 66612. My apologies. Perfect. So for the sake of this test, I'm simply going to do from a 1 mile radius, but you do have the ability to search a 1 mile, a 2 mile, a 3 mile radius. There is also the ability to search everyone in the zip code. So anyone in the zip code of 66612 would come available. And then there is also the ability to find all offenders in the county by doing this search. And we'll give it a quick moment here. What browser is this? Just out of curiosity. Okay. Okay, would you mind scrolling down? Oh, there we go. Okay. So again, here is this map that shows all of the different offenders within a 1 mile radius of the Capitol. Again, they're color coded. If you hover your mouse over one of those pieces and click on it, it will actually pop up who that is. And then you can, we won't do it now for time, sake of time. However, you can click on that and it will take you to their individual record. If you scroll down a ways, please. It also has everybody listed that has an address within that 1 mile radius. If we can go back to the top. Go to other search, please. This is where you have the ability to search by phone number or email or internet identity. So let's say, for example, this A-test individual that I have, he has a phone number associated with his registration account. If someone were to enter that phone number into the system, it would come up and say, yes, this phone number is associated with an offender. However, it would not provide the information of who that offender is, same as with the email address or Facebook identity, any of that stuff. Can we go over to community notifications, please? And this is where we would sign up for community notifications. Again, this is specific to a geographical location and not to one specific offender. You'll enter your email address, the address that you're wanting notifications on, and then you'll be able to specify whether or not you want notifications on a 1 to 3 mile radius. There is also the ability to remove the community notifications if you would like to. With that, that concludes my presentation portion of my testimony. However, I am happy to stand for any questions.
Committee, any questions? Senator Foscato.
Thank you, Madam Chair. So how efficient is this? So for an example, if you've got a Charlie E. Jones, and at one time, most people would just put the middle initial, the letter. So what if all of that is the same? And then the second part of the question is, so when you talked about typing in the telephone number, with the cell phones, and a lot of people nowadays, especially those with low income, you know, their telephone numbers change often, and you may, you know, someone else may have that new number now. So how do you make that true distinction? Does the individual's picture come up to allow me to know, okay, this is a match, I've got the right person before I proceed to do anything, and, you know, we may have the wrong person. So how do we handle that?
Right. So specifically to your first question about how accurate everything is, if someone has a different name, we do have, each offender has a registered offender number, and so it's not just by name, middle name, even date of birth. It doesn't even just go off of that. They're also on our end, social security numbers and that kind of thing, to make sure that the right information is uploaded and documented under the right offender. As for your question regarding phone numbers, and that could get transferred, it could be an offender's number at one point, however, it may not be any longer. When the offender goes in to update his registration, he or she would remove that phone number from their registration, in which it would no longer show up when you do that registered offender phone number search.
Any other questions? Senator Bowers.
Thank you, Madam Chair, and very nice presentation. We like pictures and graphs, too. Years ago, I had a constituent who owned an apartment building, and it was a violent registrant, if I remember right, and used a bogus address that lived in this apartment building. And if I remember right, and it's quite a number of years ago, the only way to remove his apartment house was to have that person go back in and correct the form, where he was helpless to do anything to get his apartment building off the registry. Is that the proper way of that to happen, or was there a step that he wasn't advised on what to do in this case?
Right.
Thank you very much. Thanks, Madam Chair.
We would typically leave that up to the local sheriff's office if they would accept something in writing from the offender making such a modification. But everything in the repository is offender reported, and therefore, you know, there is some discretion to the sheriff's office as to what, since they're the registering agency, as to what they're going to accept to get that removed from that offender's record.
Any other questions? Seeing none, thank you so much.
Thank you.
Committee, it is lunchtime. It is past lunchtime, but let's go ahead and let's take a quick break, get your lunch, and let's come back because we will be working on substance abuse treatment next. Committee, we are woefully behind schedule. So we're going to jump in because Mr. Scott Schultz, do I understand you're going someplace after us?
I do have a 2 o'clock, so I will be pithy.
So we appreciate that you are here today. Scott Schultz is our Executive Director of Kansas Sentencing Commission, and welcome to our committee.
Thank you, Madam Chair, and thank you, members of the committee. On behalf of the commission, very happy to be here. I am kind of getting hungry, looking at all this food, and if my stomach growls, I will blame Shirley, since she is closer. Well, she's actually our new analyst, KLRD analyst, so I guess I'll take the blame since I want to stay in good graces with her. So, thank you. We've been asked, and unfortunately my Senate Bill 123 director is not going to be able to be with us. She got caught up in the Northeast over Thanksgiving and got COVID, and they wouldn't let her fly home. So I'm going to be flying solo today and hopefully be able to do the presentation justice. So. I kind of wanted to talk a little bit about just there are a few of the committee members that are not normally on committees that we talk about Senate Bill 123, and so I thought it'd be a good opportunity to talk about it, as well as the raft diversion program that you all just passed back in 2021. As most of you know, the Sentencing Commission is essentially the gatekeepers of the Kansas sentencing guidelines. For all of those felonies, there are guidelines in which sentencing occurs throughout the state. We have a 17-member commission that provides guidance. I feel very fortunate that if you look over the 3 days of your committee meeting, I believe we have 5 of those individuals that are speaking or have spoken that are actually on the commission. And so we have very strong leadership inside and outside of the commission. Obviously, Representative Heiberger is also a commission member as one of the legislative representatives, but good to have our vice chair, Judge Sexton, with you. I think it kind of punctuates all of the, I wouldn't say wonderful, but the great cross-section that you've heard in the last couple days already of different criminal justice topics. And substance abuse will be yet another one of those for you to consider and look at. Regarding the 123 program, this is a program that the commission has administered. We are starting next year will be our 20th year for this particular program. It is a substance abuse treatment program for court-ordered individuals. These are felony only, and they are out of custody. So nobody in prison is going to actually receive treatment. You have to be on community corrections to actually receive this particular treatment. There are criteria in the statute that, based upon mostly possession offenses, that you would be eligible for these particular treatment options. We have in the past, last couple of years, have bumped that up to small sales of controlled substances that are eligible, and I'll talk about that in a little bit. And then the RAFT program itself was passed in 21. It is the Recovery from Addiction Funded Treatment. This allows prosecutors to actually provide state-paid substance abuse treatment for folks that are on diversion in those possession, if they're charged with possession. And so having that state-paid treatment encourages prosecutors, it's not required, but encourages them to actually have, develop those programs as well as supplement what they already have. So what I'm going to cover today, in the absence of Kira Johnson, my Senate Bill 123.
For a minute. We have a question from Senator Fausto.
Thank you, Madam Chair. I'll be brief. I just wanted to comment. As I looked at the screen there, it talked about Senate Bill 123 being enacted or passing in 2003, and that's the year that I came into the legislature. That was one of the first pieces of legislation I voted on, and at that time I was a House member, and my predecessor, Senator Donald Betts, was on the Senate floor debating. They were debating Senate Bill 123 and why it was so important, Madam Chair. And it talked about, and Senator Betts talked about, because I represent the same people that he represented, and you know, people of color in his inner city, low income, marginalized individuals. And so, Madam Chair, the debate was so grand that all the House members, you know, we walked over from the House chamber just to listen to the debate on Senate Bill 123. And I think that's one of the most important pieces of legislation that we've passed to help people in these situations. And so we dubbed it rehabilitation as opposed to incarceration. So I just wanted to share that of how important it's been for the Kansas legislature lawmakers. We've been working on this issue for a long time, and Madam Chair, I just wanted to say what you're doing today is a great catalyst of addressing all of these issues at once so that we can really help people here in the state of Kansas. So thank you. Just wanted to share. Thank you.
Senator, I think that's a great segue that we have often heard from previous Senate Bill 123 clients that Senate Bill 123 saved my life and my family. And so that's some of the things that kind of keep us going as far as administering the program. So I'm going to touch on four things. One of the things that the committee actually requested, and we have that at the end of the presentation, is a map of providers, and not only providers, but also what they're actually providing from a residential as well as an outpatient setting. So we'll talk a little bit about trends and expenditures to begin with. Certainly, COVID-19 has affected the last couple of years as far as treatment is concerned. I will mention about the continuum of care as well. In terms of maybe essentially that's getting the person on the right seat on the right bus in terms of that treatment that they have to have that is adequate but is not too much. And so during this time, we have implemented, during the pandemic specifically, as soon as it started, we actually went to telehealth options like many of the other agencies did. And that has been a great help for us. The court cases are being dealt with, and some of those, and I think it's, I was listening yesterday to the committee, and I think it depends on the jurisdiction that you're looking at. Some of those folks have actually, their backlog, they've resolved those. Others have not. Some that have resolved them, jury trials and everything else, that was what we were kind of waiting for as far as prison population is concerned. They've resolved those jury trials now. They still have a backlog now of the charging that happened during the pandemic that they now have to charge. So a lot of different dynamics going on within the system. So just to give you an idea of, as far as a comparison of 21 to 22 expenditures, our total expenditure last year was $6.5 million in the program. That slide kind of gives you a breakdown of what we look at as far as the spend that we're doing. Average cost is about $4,057 per offender per year. Keep in mind these offenders will actually serve up to 18 months, so they're actually going into the next year most likely. But from a yearly standpoint, about $4,000. Certainly keeping them in a community setting in a capacity such as that will pays dividends from a cost standpoint, since it's about $35,000 to keep somebody in prison per year. So we are, as the slides indicated here, we're actually seeing a return to the amount of treatment that's actually occurring, which is very helpful. We also have increased, to keep pace with the industry, we've actually increased the amount in which we pay for each of these treatment modalities. And we'll talk about that just a little bit. This next slide just gives you an idea of where we're at from last year, about how much we're paying on a monthly basis. For this year already, we're looking at somewhere just a little bit above $600,000 a month that we pay out to treatment providers. One of the things to remember as far as this program is concerned, we have been very successful with a kind of a four-legged stool, where you have those legs of the stool being certainly our agency that administers the program, the offender, who has to obviously play an important role in there, as well as community corrections, who supervises that offender, and then our providers, certainly, that play a very important role. And we have about, right now, about 108 of those throughout the state. This next slide gives you an idea of who those providers are and how much we're paying them. Mirror is by far our largest customer, followed by CKF, Seventh Direction, and New Chance, and DECA is after that. We have a vendor that actually pays the invoices for us. We have approximately, just to give you an idea, last year we had 2,240 offenders in the program. We paid out 38,725 invoices for that particular time. So as far as this diagnosis is concerned, what you'll see here in a comparative analysis of last year's, or 21 and 22, is that as time has gone on, opioids have overtaken cannabis. The meth has always been in the 70s as far as the drug of choice, not only for 123, but obviously for any of our drugs that we see as far as sentencing is concerned. But the opioid diagnosis has actually increased a little over 7% since 21. We also break that down by modality, or what treatment modality we're talking about. What that means is we provide payment for treatment from anything from a group outpatient type of setting all the way to inpatient treatment. And so we track that as far as where the funds are actually going based upon that, because certainly, obviously, some of those modalities pay more than others, and so those become more of an expense based upon the amount of treatment that the offenders are receiving. Moving on to the programs and certifications section. As I indicated before, last year, the legislature approved actually it was in 21, approved House Bill 2026. This was a treatment program for divertees that prosecutors could utilize. This was, unfortunately, at this point, we only have 2 offenders in that program. Both of them are cannabis related. And so some of the pain points that we're seeing with that certainly is this is a discretionary program with the prosecutor, and some of them don't have any drug diversions. Some do, but the individuals are not scoring high enough to be eligible for treatment. So one of the other things that we do handle in expanding Senate Bill 123 was Senate Bill 18, and I talked about that just a little bit ago. We have actually seen expansion in this area as far as the small sales being ordered to 123. growing from 1 to 50 in FY21. And I suspect that that will actually be higher once we get all the 22 data cleaned. So that will continue to grow. Again, if you're putting $4,000 for every offender, a couple $100,000 just for the small sales. One of the things, before I go farther, one of the things that, that you will be seeing from the Commission in further expansion of this program will be we are looking at trying to craft a proposal that will actually allow for non-drug offenders that are in the severity level 7 through 10, which is the lower, lower seriousness offenses, non-drug offenses be actually eligible for Senate Bill 123 treatment. That is something that we will probably be seeing in the bill introduction coming to you from the Commission this next session. We think it's very valuable in thinking about when you logically think about how people actually get money to pay for drugs. Normally there's thefts, there's burglaries, there's forgeries, there's those type of crimes that potentially could lend themselves to substance abuse treatment. And so that's something that we're going to explore with the Legislature this next session.
Representative Owens.
Thank you, Madam Chair, and thank you, Scott, for being here, for providing this important information. Could you go back to the raft agreement? So very disappointed that we've only seen 2 offenders utilize that program, which ultimately keeps people from having a felony conviction and still receiving treatment. Can you, or have you identified where the issue lies there as to why that's not being utilized, and if there's anything we can do legislatively to fix that problem as well?
Yeah, Representative, that's a great question. The part of the situation, as I indicated before, is this is a discretionary program, and so much like all diversion programs within the state, prosecutors can set those up any way they want to. That gives them obviously quite a bit of discretion, even in this circumstance, even though we are obviously trying to incentivize. This obviously was a bipartisan bill that was hardly accepted by all the parties, including ks.gov. And so what we're trying to do at this point is do some type of an educational effort. Kira and I have written a article for the Kansas Prosecutor magazine that will be out soon, talking about the RAF program to kind of give prosecutors a little bit better idea that maybe they don't have enough information at this point. Hopefully that will give them either that or they'll at least know who to go to get more information. Part of the things that we've wrestled with, because the Sentencing Commission actually sets those thresholds for the criteria of whether you're eligible or not, is setting them too low. Research basically tells us that if you try and treat low-risk offenders, in many cases you actually increase the recidivism rather than actually decreasing it. Sometimes all they need is drug education, those type of things, rather than outpatient, group or individual treatment, those type of things. So you can over-treat those type of folks. So, rather than having a fix of just lowering that criteria, we're wanting to try and maybe do a little bit more educational outreach right now. But yeah, we certainly are in the same situation. I think we've spent a couple $100 a month for this. Now, keep in mind that we've not had any appropriations from the Legislature for this, and we've been able to obviously with 2 people handle it at this particular time. So hopefully that will change, but right now we're looking at trying to do that educational effort first and see if that bears any fruit. So last year, one of the bills that you all approved was to take the certification process that was with DOC and bring that under the umbrella of the Sentencing Commission. And so the bill was actually introduced, passed, that we now have the KDOC individual who was certifying all of the treatment providers, and she is now in our office. The We are working currently to streamline some of those certification processes. One of the things, I talked about pain points before, that was one of the things from encouraging providers to be involved and actually become part of the SB 123 system. To try and make that easier for them to actually do that. Plus also be a little bit more, be transparent in what we're doing as far as what you need to do to actually be certified. And if you don't, here's what can happen. So there has to be consequences involved. So we also are looking at temporary certification. Part of the things that we've seen during COVID has been turnover in the ranks of treatment providers. And that obviously is not a good thing for our program. And so we are having to work on, again, more educational efforts in that regard as well to try and make sure that we're doing what we can to bring those folks on, perhaps that are already involved with folks that are agencies that are certified, and get those folks certified with temporary certifications. Some of the upcoming goals that we have, one of the things that is very important for us in the program is to make sure that we receive feedback from those treatment providers. That is in order to encourage them to continue to participate, but also, we have the obligation to be good stewards of taxpayer dollars and keep them accountable as far as the program is concerned. We're working on a certification policy that hopefully does both of those. We also have a statewide provider list that's actually on our website now that wasn't before, and so folks can go and actually look at those to see in their area who the providers are. Some of the goals that we have for this particular fiscal year talk about getting those policies for certification out. We have trainings for treatment providers as well as community corrections folks. We just had in early November the Senate Bill 123 conference. We had over 100 folks participate in that particular conference that was all day. We are looking to continue to encourage the continuum of care, and by that I mean that sometimes we have situations in which the courts want to order Senate Bill 123 and there's no actually statutory criteria for them to do so. And so letting them know they're no different than anybody else in this in the criminal justice system. There is turnover with the judges. One only needs to look as far as to see all of the appointments that the governor has made in the last couple of years. And so they're not immune. Community corrections is not immune. Treatment providers are not immune from turnover. And so it's our job that to make sure that we can continue to encourage best practices in this particular area. We have a research project that is coming to a close that my director is actually doing for her PhD thesis or dissertation, and so we are looking forward to getting her that perspective on that. As well as one of the things that we've talked about as well is adding incentives for those folks with BSRB that need CEUs to, again, incentivize them to actually attend trainings and those type of things. The provider maps themselves are somewhat hard to see, but hopefully you can see that. This slide just gives you an idea of we have about 114 that ebbs and flows depending on the circumstances or the year, but it kind of gives you an idea as far as a heat map is concerned of where those providers are in the state. As you might expect in the more metro areas, there are more treatment providers. This next slide is assessment providers. Some folks only do assessments. They don't provide treatment. You can see that most of them will actually provide treatment, though, but there are some that are only doing assessments for the program. The next slide deals with outpatient care providers, and that gives you an idea of where those are located. As you may expect on all of these, as you can tell, the western half of the state does not have the providers located there that the eastern half does. However, I would say that, for example, with the residential care facilities, those folks actually take folks from all over the state. It's just not, they don't have somebody in Saline County and they only take Saline County folks. They're taking folks from all over the state. So, as well as the fact that we have telehealth that I mentioned before, and that is available. And that's one of those things, especially in the western part of the state, where I'm originally from, when you have folks that have to drive 2 counties to actually seek treatment, telehealth becomes an unbelievable asset for that offender and for the treatment provider too. And so that becomes a win-win if they can actually do a treatment over lunch rather than having to take a day off to drive to a couple counties over. So, so we are working with our partners at Community Corrections as well as those treatment providers to make sure that Senate Bill 123 provides the treatment that's necessary. Our job is to make sure that it's done with fidelity and consistency and continuity so that we can make sure that those folks are being successful. And with that, I'd stand for questions.
Committee, what questions do you have? We'll start with Senator Fausto.
Thank you, Madam Chair. Thank you, Scott. I think the last time I saw you, we were over in Lansing, or Leavenworth area, and you gave us a wonderful presentation at that time. For those who might be listening in, could you just clarify the eligibility requirements that those individuals must have for a judge to allow them to go to the rehabilitation programs through Senate Bill 123?
Absolutely. So you're charged, you're convicted of a possession of controlled substances. Based upon your criminal history, you may or may not be eligible. If you have the small sales like I was talking about, you could be eligible. We also do assessments then as part of this to make sure that there's a threshold criteria that essentially we have two assessments that are done. One is the WRNA, which is done for women. One is the LSCMI that's done for men. They have to score certain thresholds with regard to those. There is also a SASE, is again a drug and alcohol assessment that they have to score high on. If they meet those criteria, if they have less severe offenses as far as priors, they can actually receive mandatory treatment. If they have higher criminal history, like they have person felonies on their record in some cases, it's discretionary with the court. They have to make a finding that public safety is not going to be jeopardized by sentencing this individual. So those two things, the mandatory goes based upon criminal history and crime, but also those with higher criminal histories, it's a discretionary call with the court.
And Madam Chair, may I follow up? So the reason I'm asking, and just to what I specifically want to know, so the court pays for it, correct?
We pay for it.
Okay.
Yes.
Because over the years, some people are thinking, oh, I can't do that because I can't afford to pay for it. I don't have health insurance or coverage. Okay, so, and then my next question is, so the city of Wichita, or they, not me, passed an ordinance regarding the possession of marijuana, the amount of whether or not to be charged, or so in this case that you just described, is that for sales, usage, and how will the ordinance passed in Sedgwick County affect what just affects Senate Bill 123 and how it benefits or not?
So keep in mind, this is a violation of state law. So any type of ordinance that would be there, that would not affect any type of eligibility as far as we are only paying for violations of that particular, the state possession of controlled substances or that small sale. So any ordinance issues would not be affected.
Committee, other questions? Scott, could you go back to, and I'm trying to look to see what the slide deck is, but it is the expenditures by diagnosis. There we go. So you indicated there that the opioid diagnosis has gone up 7%. So talk to us about, is the expense for the treatment for opioids different, more expensive, less expensive? What's the expense? When we're looking at these different types of diagnoses, the amphetamines and stimulants is obviously the largest group, but are there certain categories there that are much more expensive to provide the treatment than others?
Madam Chair, I know that there can be. Part of and I could get that information probably for you. Our limitation in terms of a treatment capacity is we don't have any medical assisted treatment authority or funding for that matter. And so where you would have potential opioid treatments available in that regard, that may be available, but we don't have the funding to actually to cover that. I can't answer the question of whether or not individuals are actually receiving, we could get that information for you certainly, as to whether somebody on meth versus somebody on oxy is, what kind of treatment on average they actually get, because we can break that down if the chair would like that.
Well, I just want us to recognize that when we look at this chart, it's just expenditures by diagnosis. It's not individuals by diagnosis.
Correct.
Okay.
Correct. What I can give you is, in the aggregate, was that average of $4,000 a year.
Yeah. Okay. Yes, Senator Fasquedel.
Madam Chair, I'm really on this wave with you of all the state agencies and funding and appropriations. So I'm just curious if staff could tell me. So yesterday, when the presentation was made that some of the grant funding couldn't go to our guards in prisons to hire them, and the money had to go back to, and when I heard that item, automatically thought that the money had to go back to the state general fund, to us or the governor, but then it was clarified that money went back to the Department of Corrections. Couldn't you or Jason, or Natalie, you're great too and smart, everybody, couldn't that money go to you to help these people? They're all the same people. We're all on this wave together. Thank you, Madam Chair.
Senator, we'd be happy to accept that. Thank you. Thank you so much. Keep us in mind. If you deem that necessary, we're happy to utilize the appropriations.
Right now, it's just not being appropriated that way. But he'll take any support we're willing to give him, correct?
That is correct, Madam
Okay.
Chair.
Committee, any other questions?
Jason have a response? No, okay.
One question I did have, and it really kind of springboards off of the question that Representative Owens had with regard to RAFT. So those two offenders, were those two offenders in one particular area? So when we look at your service area map,
I don't know about the one. I know one is from Johnson County.
Okay.
I, in fact, actually called the diversion coordinator and talked with them. One of the things that they were, and again, it's set up based upon what the DA finds. You know, they obviously have obligations that they need to make sure that they're protecting their community. But in that situation, they had, and I asked, what's your frequency or what's your numbers? They had about 20 individuals that were on diversion for possession. One of those was actually eligible.
okay. And when we look at the SB 18 on the small sales, so that's jumped up to 50 that are receiving that treatment. Again, is that kind of spattered throughout the state, or do we have pockets within the state where we have county or district attorneys that are pushing to make that happen?
I can get that information for you.
Okay.
That's a great question. Some, there are obviously philosophies from county to county.
Right.
But that's a great question. I'll get that for you.
I think it just, sometimes it gets to exactly what we saw a little bit earlier. When Judge Sexton was speaking to us, and it is the mindset of the judge, it's also what is the mindset of the county or district attorney or staff members and the counties that they represent, and which direction are they going to gravitate toward. And so we can continue to pass legislation, but it's up to them within the counties to put together the implementation. And so it isn't even necessarily, when you look at service areas of treatment provider maps, the locations of the providers, the assessment providers, and the outpatient care providers, as well as residential care. So you have to have those availabilities, but likewise, you've got to have that mindset of these opportunities being made available. And it takes a judge as well as a prosecutor willing to work together on that. Okay, thank you. I'm not seeing any other questions for you. You have 30 minutes to get to your next, which gives you an opportunity to, I don't know, is there a box left outside for you?
Well, Madam Chair, thank you so much. And I wanted to say, we have yet another commission member, Jermaine Wilson, Mayor, that will be talking with you soon. And I think you'll enjoy talking with him as well.
Thank you very much.
Thank you.
Committee, two things. I do want to give a special thank you to Kevin Barone, our lobbyist with Capital Lobby Group. He did provide our lunch today. He has appeared many times before this joint committee, so a thank you to him for that. Also want to call on Lindsay Archer. You have some information from us with regard to the question was asked about the PTRFs.
And I am actually going to defer to Shirley Morrow from Legislative Research to take that.
Okay. So Lindsay, thank you for introducing Shirley.
Thank you, Madam Chair. I conferred with my fiscal analyst, and let me see if I can find it now. There are currently 269 patients in the PRTF.
And that's based on available beds. Is that correct?
And I was given a plethora of data on beds that are staffed and beds that are licensed. And if the committee would like all that information per hospital or per unit, then we can provide that.
Okay, we do have Representative Carlin has requested, so if we can have more information tomorrow, that would be great.
Okay, will do.
Okay. So committee, yesterday we did 2 field trips, and today our field trip is here for us. So take your seats behind your name tags. Yeah. Ladies and gentlemen, we are so happy to have you with us today. We've been really looking forward to this because, quite frankly, you're going to give us some special insights that we haven't collectively as a group been able to hear for a while. So you are our workforce training panel, and I'm going to let each of you, let's start with Lee. And if you will we'll just kind of go from left to right. And if you'll just introduce yourself and give us, a couple sentences about what your background is.
My name is Lee Jost, and I am Executive Director for InCircle. We're a nonprofit located in Johnson County, Kansas. We serve folks that are currently justice involved, both adults and teens. And our primary focus is workforce development and education. We partner with Johnson County Community College as well as private industry to help skill people up for the workplace.
Randy Reinhardt. I'm a fifth generation Kansan. Grew up was born in Hayes, grew up in southeast Kansas, now live in Johnson County, have businesses in Leavenworth and Miami counties. Today I'm talking about Zephyr Products and our partnership with KDOC.
My name is Jason Miles. I work for Zephyr Products, formerly incarcerated, and I'm very excited to be here today. Oh, you got your own.
My name is Jermaine Wilson, and Can you hear me now? My name is Jermaine Wilson. I'm currently serving as the Mayor Pro Tem of Leavenworth, Kansas, and also the Regional Director of Prison Fellowship. I'm also a restored citizen. In my role as the Regional Director, we provide transformational programming to men and women that's incarcerated, and we do that through our program, which is called the Academy, that builds communities and create opportunities for men and women that are incarcerated to practice and develop values that transform them and others into good citizens.
Good afternoon, Madam Chair and committee members. I'm Margie Phelps. I'm the Executive Director of Programs and Risk Reduction for the Kansas Department of Corrections. I'm in my 32nd year with the department and have seen an array of initiatives, and hopefully the one we talk about today will be one that has been a success.
So there's our introductions. So who wants to start? Who wants to kick us off?
I volunteer Mr. Randy.
Okay, Randy. We'll start with Randy. Randy,
Can you
thank
hear
you.
me okay?
Yes.
First of all, thank you for allowing us to come and talk and explain what we do. We very much appreciate, and again, none of this would be possible without your support. People ask a lot of times, what can we do to help? And the most important thing is continue to offer your support we've been doing since 1979 at Zephyr Products. So today I'm talking about Zephyr. It's making sure everybody understands, it's a for-profit business. We do work with a lot of nonprofits along that journey, and Lee represents one of those nonprofits we work with. We've found that over the years that working with businesses along with nonprofits is one of the most efficient ways and best ways to work with returning citizens. Zephyr Products is a contract manufacturer. We're located in Leavenworth, Kansas. We produce steel fabricated product for other industrial manufacturing operations in our region. When the company was founded in 1979, one of the primary purposes was to provide jobs for residents of the minimum security of Lansing Correctional Facility. Today, Zephyr has over 125 total employees, of which 85 of those are residents of the Lansing Correctional. and we refer to those folks as returning citizens. When people hear about our operation in Leavenworth, they also think that maybe we stamp license plates. That could not be further from the truth. Our employees produce top quality products using state-of-the-art technology. Most of our customers are large OEMs, original equipment manufacturers, who design and assemble and sell all across the world. Companies like Husqvarna, Snorkel, DeLaValve, and Orange EV are a few customers that you might be familiar with. We hire returning citizens through private work, industry work release program through the KDOC. And we hire based on attitude, not skill, and then we train to develop the necessary skills that we need. The average length of employment for our returning citizens is about 18 months, not very long. Therefore, we have a lot of turnover and we spend a great deal of our resources in training. Upon their release, we help them find jobs, and then we track that recidivism rate of our successful alumni. We term the successful alumni of those folks that leave our program while they are still incarcerated. We lose about 75% of the people we hire over that 18 to 2-year period for lots of different reasons. One of the reasons why we're working with Lee to try to help improve that number. The good news, though, is during that time, we've hired approximately 1,500 inmate employees, of which over 400 are that successful alumni. We track those 400, consistent with most state and federal reporting recidivism rates. We look back 36 months. So the average recidivism rate in the United States is somewhere in the neighborhood of 65%. We in Kansas do a much better job, 30 to 35%. Margie might have updated numbers, but that's the last I understood. So 1 out of 3 return. As of September 30th, because we track this on a quarterly for Zephyr, if you look back 36 months, we had 45 returning citizens successfully leave our program, 0 reoffended, and we had 2 that actually returned back to prison for a parole violation. We view that's very successful in the overall numbers. Our program over the last several years has enjoyed near 0% recidivism, and we know it works because we give people the tools and the skills to re-enter society successfully. And we're very proud of our employees who come through the program, not only for their success, but also the impact that they have on their families and their community. And rather than having a negative impact on our community, our returning citizens are becoming tax-paying citizens and good role models in their community, providing positive influence. And it is our belief in today's competitive labor market that employers like ourselves will need to do more training and development to help stabilize our workforce. None of what I described today would have been possible without the visionaries at KDOC. Our partnership began 40 years ago with Fred Braun, partnered with KDOC to create one of the first private industries of its kind. And Kansas has continued over the years to be a leader in private industry partnerships in workforce development, something we're very proud of and be a part of. Without your support, our program would not be possible. Thank you for your service, your commitment to help Kansas be ready for the future through workforce development, particularly by supporting and training and developing the 10,000 citizens in Kansas who are currently incarcerated. Over 95% of those folks will be returning to Kansas communities, and let's equip them so that they can be a productive citizen and a productive worker for Kansas. Again, we very much appreciate your support, and Jason's going to talk more about specifically his perspective coming through the program.
All right, thank you. Yes, good job, Randy. I'm very grateful to be here today. I like to think that I'm one of hundreds, if not 1,000, people that have come through Zephyr. So my story, I came through the system when I was 18. I actually got in trouble when I was still in high school, so I didn't finish high school. Came into the system, I got my GED, I started attending some college classes. I had to get a trade, so I got a trade in welding. You know, I had no vision at that time, but I got a deal in welding. And little did I know where my future was going to lay with that. So eventually I progressed through the system, a couple more years. I had an opportunity to go to work at Zephyr Products. I came to work at Zephyr, and I had the knowledge from the Weld School, but I didn't have any practice of putting that in practical use at a, make air quotes, real-world job. So that was one of the great things that Zephyr gave me. And I welded for Zephyr for almost 2 years, and then I was paroled, and this was 1996. I was paroled out, left Zephyr, and Zephyr actually connected me with a job in Olathe with Webco Manufacturing, who actually is a competitor of ours. And Zephyr actually let Webco come into the plant and give me a weld test, and they hired me, and that's where I went for 2 years. And then Zephyr approached me after those 2 years and said, hey, would you be interested in coming back as a supervisor? And this was April of 1998. So I came back to work at Zephyr as a supervisor, as a welding supervisor in 1998. Since then, I've become a certified welding inspector with the American Welding Society, and I've also became a certified welding educator with the American Welding Society. So I spent 2 years on parole, got off of parole in December of 1998. In 2011, I got my record expunged, so I can legally say that I've never been convicted of a felony, which is a good thing. And one of the things I like to say, I like to call myself a grateful taxpayer, because I am grateful. I'm grateful for the new life that I've been given through many opportunities, Zephyr being one of the bigger ones, but there was a lot of opportunities that I was given and I took advantage of. But I call myself a grateful taxpayer because I look at it this way. So the taxpayers paid for me to go to that weld school, and I went to that weld school. And then because of that weld school, I had a foundation that I built. And on top of that foundation, I built things with Zephyr. I built things that I did on my own. And with that house, there's the amount of money that I'm making. That my employer is like, hey, you're doing great, but this is the amount of money we're going to pay you. Well, I continue to add upon that foundation, and my employer is like, wow, you're great, here's some more money. So they pay me more money. Well, obviously, you all know that the more money I make, the more taxes I pay. So I look at everything as starting from that foundation of the weld school that the taxpayers paid for me. So that's why I call myself a grateful taxpayer. So thank you for the opportunity to speak here today, and that's all I got.
So do we want to hear, Jermaine, do you want to speak next?
Yes, my name is Jermaine Wilson, and the first time I entered into the system, I was 12 years old. That was the first time I ever committed a robbery charge, broke into a house, just wanted to fit in. I was this short, hungry kid and broke into a house and made a bologna sandwich. But it cost me, and that was my entry into the criminal justice center system. At the age of 15 years old, committed a robbery charge and was sentenced to 2 years in juvenile corrections, tried to escape, failed in the attempt, and was sentenced to an additional 2 more years. So from 15 to 19, I spent my teenage years incarcerated because I wanted to be like everybody else. And in the midst of that, I lost myself. During my time, I was able to acquire my high school diploma. My mom said, get your education. That's something that no one can ever be able to take away from you. I acquired that high school diploma, but I didn't do it for myself. I did it for my mom. When the time came for me to go back home, I went back to my same neighborhood, my so-called friends who didn't write me, who didn't put money on my books. These were the individuals that I considered to be my friends. And when they welcomed me, embraced me, it wasn't with any job applications. The neighborhood I grew up with, it was a very impoverished community, and everyone during that time was selling crack cocaine. Because I had failed to plan, I ended up just doing what everyone else was doing. And I felt like that was the only way that I could survive, is by adapting to my environment, because I felt like no one would hire a felon. After serving 4 years, I was only out 18 months. And during that time, God blessed me with a son. He was trying to get my attention. I failed and neglected my responsibilities. I was more caught up in that street life. And so I'll never forget the day when my son's mother said, don't leave this house. I didn't listen. I didn't take heed. I left that house. And when I left that house, I got pulled over by law enforcement, and they searched my vehicle, found crack cocaine, marijuana, and ecstasy pills. I was only out 18 months. Now I'm sentenced to prison, serving 3 years. Now I'm inside of this prison cell. I begin to reflect over my life, and I begin to think, is this the life that I want for my son? My dad been to prison, brother been to prison, sister in prison, now I'm in prison. If I don't change my life, then my son's gonna end up walking in the same footsteps that I'm in. I heard of this program at the time, it was called Prison Fellowship. I decided to make a change in my life. I knew I needed to be involved in an organization and be surrounded by individuals who will push me forward and not pull me down. And during that time, when I joined the program, it was my introduction to Christ. I became a believer in Christ. And because of my faith, I realized that I am much more than a felon. I am not a mistake. As I was learning life skills through this program, it helped me to realize that I am created for a purpose, and it's much more than just being incarcerated. So I began to attend college classes. I enhanced my vocabulary. I began to write goals and prepare myself where I was going to go once I got released. After 3 years, I returned back to my community. I wasn't afraid, I wasn't worried. I learned something during my time of incarceration. Serve to make a difference, and God will bless you with the right position. So I began to serve my community, started giving back. Once I successfully completed parole, I signed up to become a mentor, went back inside of that same prison where I served my time in because I wanted to give back and I wanted to give hope. Fast forward, the year 2015, God blessed me with an opportunity to get my criminal record expunged. So I am no longer a felon either, so thank God for that. But at that same time, he also gave me a vision to create a nonprofit organization called the Unity in the Community, where we were working with law enforcement to bridge that gap, to bridge that divide, so we can become unified as one nation, starting our community. In the year 2019, so many people in my community asked me to get involved in politics. I said, no, that's the devil's playground. But I was just encouraged, and God gave me that voice, and just gave me that word, and just say, serve. Do it, and I'll make a way. I'll open doors that no man can close. I served, I campaigned. You all know what it's like. It was hard. I had some doors shut in front of my face, but because my community loved me, invested in me, and they loved the work that God was using me to be able to do, they allowed me the opportunity to serve as the mayor of Leavenworth, Kansas.
Lee, talk to us about how you help folks overcome the obstacles.
So in 2011, In Circle organized as a group of community members. I pastor a church, and a group of us wanted to support returning citizens. And that year, we began a welding program. And actually, one of the members of our church is Dennis Wright, who had just retired from Zephyr Products as one of their welders. And he's a certified welding educator and a certified welding inspector. We had no place to do it, so I reached out to the only connections I had in Johnson County government. We ended up connecting to the maintenance shop, and Todd Rue with the maintenance shop said, if you can get done training welders before around 8:30 when my guys show up and need the shop, we can do that. So we work with Johnson County Corrections, and in Johnson County at the Adult Residential Center, we started training welders, and we were really excited. Within a few years of starting that program, we began to see some of those same folks right back in the same beds at the residential centers that we had just trained them and gotten them jobs and helped them to get out of. Upon interviewing them, we found out that the hard skills were not the issue. The soft skills were. Showing up to work on time, showing up work ready, taking criticism in the workplace, not saying to your boss, you're not my mother, don't tell me how to keep my stuff. So those were things that we didn't really think about. And Dennis and I looked at each other, and we began to look at ways to address that. I became an offender workforce development specialist. I got some training myself so that we could better serve those coming out of incarceration. Subsequent interviews with employers, we found the same things were the challenges. Most employers, like Randy's company, will train the hard skills. They have plenty of ways to get people work ready and to learn how to become productive in their environment. The challenge is most employers don't have the time or necessarily the expertise to train all the soft skills. So In Circle recognized that and began developing a curriculum that would help address those soft skill deficits in men and women returning to the workforce. We partner with Johnson County Community College as well as Johnson County Corrections for our program at the Adult Residential Center. And today we offer not only 12 weeks and about 45 hours of workforce special training for those soft skills, we call it essential skills for the workplace, but we also do some skilled trade, basic skilled trade training through the Community College Continuing Ed, Microsoft Word, customer service. We also do construction basics, automotive, forklift, welding, blueprint reading, and OSHA 10. All of those are programs that we offer so that people can leave the program and leave the Adult Residential Center prepared for their first interviews and prepared for jobs. Most recently, we began to partner with private industry and to provide soft skill education and coaching in those environments with Zephyr products. These men are already working. We didn't need to get them the hard skill. What we needed was to figure out how to address the number of people turning over because they lack some of the work-ready soft skills in the workplace. In 2020, we began using a validated instrument to track work readiness for client improvement called the Employment Readiness Scale. It is an international validated instrument that helps us to assess where people's deficits are with both hard and soft skills. We use that, and in doing that, we found that those entering our program, about 50% of our clients when they come in, lack the sufficient skills to be work ready. Upon leaving a simple 12-week program that we do in the community, 75% of those clients report that they are now work ready and have sufficient soft skills and can demonstrate that they have sufficient soft skills for the workplace. In the past year, in working with Zephyr, we began also using Employment Readiness Scale to assess those employees pre and post 6 weeks of 1 day a week, those people coming to a soft skills or an essential skills for the workplace class. Randy does this as a part of their employment. They clock into onboarding and training, and they're actually paid for their time in the class. And for an hour and a half over 6 different weeks, we train them with some of the essential soft skills. LCF employees show a 15% improvement in their ability to determine a career pathway, an 11% improvement to understand and maintain their career, and a 13% improvement in identifying supports that will help them maintain their job, including those supports existing already at Zephyr Products. And Jason is one of those supports. Successful employment is also more than just the job skills or the soft skills. It also is the surrounding environment for those reentering. In Johnson County Corrections, we assess the risks and the challenges that are in front of the clients that release. 58% of those say that recovery is tentative for them, and they believe they will need additional support upon release for their recovery to stay stable. 50% say that they are concerned about how they will take care of their children while working. And 50% show that they are concerned for their family. Zephyr employees also indicate 61% believe that they lack sufficient resources to care for their family when they release. 41% believe legal problems will hinder them upon release, and 37% believe that those in their household, friends or relatives, when they return, who are already struggling with substance abuse, will become a hindrance for them to remain stably employed. There are so many other supports than just the hard skills that need to happen so that men and women who release from our facilities can go back and be stable in the workforce. And we know that stability in the workforce is a key indicator to keeping people from recidivating and coming back into the system. So what we want to do is find ways to support that. Part of what InCircle can do is flex and mold. When private industry says it needs something, we can come in and flex and mold between what corrections will and won't offer. And we can provide resources right there on the workplace. We figure out ways as nonprofits how to flex and help people build successful lives upon reentry. Thank you for the opportunity to share.
Representative Heiberger.
Thank you, Madam Chair, and thank you all for being here. I really appreciate the presentation. I just have a question for Lee. It seems like a lot of people in our business system are there because of mental health issues, and it seems like that would also make it difficult for a lot of people to complete your programs. Do you see that, or are the people? Do you get a cross section of people who are completing your program, including people who have underlying mental health issues or not?
We do a lot of work with folks coming in Johnson County Corrections, with folks that are at the Adult Residential Center and Therapeutic Community in Johnson County, which is a 6-month residential program. They all have underlying health or mental health, as well as co-occurring disorders with substance abuse. What we're finding is those folks that are in treatment and are able to access that treatment are more stable in our program. When they leave and go out into the community, one of the things that we do is we know those service providers that were mentioned in the previous slides. We're aware of who they are. We know how to help them get into an intensive outpatient or other supportive services. So one of the things we do as a nonprofit is we don't just focus on just the education. We are an agency then that helps to bridge the gap and get people connected to other services in the community so that they can remain stable. Mental health and substance abuse are one of the biggest challenges, and I believe it's one of the first things we need to address. Without sobriety, you can't have stability.
Thank you, Madam Chair. I've told these people they're probably tired of hearing it. Back in the day, I taught at an alternative high school, about 100 kids. Probably 80 of them didn't want to be there. They had to be there because their probation officer, when they were gone, went and got them. You know, and we talked over and over and over again about breaking the chain, just like you were stating. You know, who's going to be the first one in your family to graduate from high school? You know, who's the first one you're going to go? You know, and they says, Coach Stahl, you have no idea what you're talking about because you haven't been there. And I said, you're absolutely right, but I've been on this other side, and I think it's a hell of a lot better than your side, you know. But what I'm saying is, if you had the opportunity, please go. I'm sure you have alternative schools in your area, and they have to hear from you know, us white guys, old men. You know, dime a dozen. They hear it all the time. They need to hear from somebody who's been there and done that, you know. And I would just encourage that.
Representative Owens and then Senator Corson.
Thank you, Madam Chair. Randy, question for you. I've had the opportunity to visit with you before, presented a symposium in Johnson County during last session, and we talked a little bit about the issues around workforce and getting people back to work. As a business owner, what do you feel is the biggest challenge that other businesses have in doing some of the things that you're doing by hiring people that have a past record of a felony?
So make sure I understand the question. What challenges do other folks like us have?
Yeah, let me explain maybe a little bit better. So we talk about things like ban the box, which only gets people in the door the first time. What is it about hiring somebody that has a history, a felon record? What is the mindset difference? What do we need to do differently to encourage incentivized businesses? I mean, where is that barrier? Or is it literally just a mindset that because they're a felon, they shouldn't come to work for me?
Well, I think it's a lot of different things. I think it used to be, and I think we're away from that today, just because of the shortage in the labor force. People are willing to do a lot of things that they wouldn't do before. But I think there was this thing that they thought was a liability associated with bringing in somebody who was a convicted felon into their place of work, and bad things happen, and then the employer is going to be responsible for that. I think over the years, I think there's been less and less, but I think originally that was a lot of the mindset, was the concern of the unknowns and the concern of, well, why, and then also what will my other employees think, right? The coworkers. And how does that work, and how does that look? So I think and so at the end of the day, if there's other candidates available, they're probably going to get the first choice just because of all those question marks. Today is totally changed. You know, today people are willing to look the other direction. They're willing to take some chances. But I think at the end of the day, as the employer, you have to. Too many employers look at that as cheap labor, and in our case, if you look at that way, that's exactly what you'll get. If you treat them as human beings, as you treat them as co-workers, team members, it's amazing how people will step up and reach a challenge. So that's been our experience, is that when you give people a chance, They're loyal, they're consistent, they do it because they want to. And I think there's a lot of folks out there that you still have to be smart about it. You know, there are, you know, we have right now 25% success rate of the folks that we hire. So you have that's the other negative of that is a lot of turnover. But even on other companies out there that are hiring somebody that's been incarcerated or out, I think they tend to be less stable compared to somebody that's not. So there's more turnover and things. So that's where you need to provide more coaching opportunities, more, and I think what we find our guys leaving, they get the job because of their skill set. They lose the job because of all the skills, the soft skills they don't have, because they don't know how to deal with conflict. They don't know how to advocate appropriately for themselves. And so that gets them in all kind of trouble and they lose their job. So I think that's the things that Lee is providing for our folks now, we hope will help them when they reach that issue, that they're able to work through it. But I don't know that today, to answer your question, that there's more people willing to hire folks with a criminal background, but not everybody has decided to change their life either. So that's where you have to be smart and ask questions and make sure that they've taken the right steps. You can't put everybody in the same category.
Thank you. Thank you for that, and thank you for everything that you're doing.
Thank you.
Senator Corson.
Thank you, Madam Chair, and thank you for being here. I had sort of a related question to Representative Owens for Randy. So you mentioned that your turnover is about 18 months. And so a couple part question of one is, why is that? And the second part is where are those folks going? And the final part is, it strikes me that that would be potentially a deterrent for other employers from hiring similar to you of folks who have a criminal background, because if it has to do with that, because they're hoping to have employees for a longer tenure because it's just hard on a lot of businesses. Obviously, you found a way to successfully navigate through that, but I think most businesses, it's hard to have that rapid of a turnover within their workforce. When they bring somebody on, they're hoping that they will be there for a longer period. So I know that's kind of a three-part question, but I was curious about that when you were talking. And again, thank you all for being here. Thank you, Madam Chair.
Well, let me start with the 18 months. To clarify, that is the average tenure of our Lansing correctional folks that we hire. And part of that is that the KDOC has made a decision, I'm not sure exactly what that number is, but somewhere between 18 months and 5 years maybe, as far as before their release. So the idea is that to qualify for our program, they got to be towards the end of their time. So somebody with 10 or 15 years of life are not going to be eligible for our program. So we're already starting with somebody with the less tenure. And so generally, and Jason, you have a better idea, recently the people we're hiring probably somewhere between 18 months and 3 years is the average. Yeah. Left on their sentence, left before they leave. So we already know going in, we only have them for a short while. So we're a little unique in the fact that we're hiring knowing we're going to have that turnover. The part that even is worse for us is 25% of those guys actually make it to that 18 months or 2 years. So we have a constant churn within that. So that's the huge part of just a ton of turnover, which is what we're looking to other folks like Lee and his organizations to help us to do that. I think that is a big problem on the outside, but if people are coming out of prison with some of those soft skills, I think there's a lot less likelihood that they're going to have that turnover, and employers were probably going to see some longer tenured folks. And what we find is that if somebody takes a chance on somebody on a second, the employee tends to be a little bit more loyal. Does that answer the question?
It does, and I very much appreciate your answer. Thank you very much.
Okay, next we have Representative Smith. And Margie, I promise you, as soon as he's done asking his question, we get the response, then you're going to talk, because I bet you have several things you want to share. Okay. Representative Smith.
Thank you, Madam Chair. Well, first of all, I want to apologize, Mr. Miles, while he's telling his story, I chuckled. I wasn't chuckling at your story so much as the the nature of what you went through there and actually what your company went through is kind of the nature of what we deal with in law enforcement. That is, somebody saw your skills, came and got you, and we said, okay, we'll let you go get trained some more and then come on back. You know, and that's what happens even in law enforcement. So, but my question for Mr. Wilson, Mayor Wilson, you spoke a bit to mentoring. Do you still do the mentoring?
Yes, sir. With my position, I currently travel throughout the nation and share my story, just providing hope and second chances and letting individuals know, regardless of the mistakes that you made, your past mistakes doesn't define who you are. You know, this is just the beginning. Like, you have an opportunity when you have this time, invest this time wisely, because when those prison doors open up, it's time to utilize those things that you learned during your time of incarceration. So yes, sir, I still mentor.
And I would say to you that, first of all, thank you for continuing to do that. You're a subject matter expert, right? That's where you're at now. And your skills are so valuable now because of your experience that we need folks like you to stay on that trail, right? We got to have that. Continue to do that. And then, you know, the young folks that we deal with today and the different mindset of how to keep a job as compared to the way it was back in my day. You try to get in a career and stay there, right? And now it seems like it's the jump, 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 which compounds, I think, the problem you might have with those folks that are dealing with a past incarceration or a conviction status on top of that. So anyway, thank you.
Thank you. Marjorie, so you're the Executive Director of Programs and Risk Reduction with the Department of Corrections. So share a little bit with us as far as, first of all, share with us why it is that we do kind of wait until it's within that 2-year time period, 2 to 3 year time period before release for them to start that training process.
Right. Yeah, thank you, Madam Chair, committee members. So a couple of things about the timing. First you have to look at the average time we have people, and unfortunately they tend to clump up in 2 buckets, either not very much time or a whole bunch of time. So we've struggled with that for the 22 years I've been doing risk reduction work, trying to figure out where is the right spot to plug in any intervention. So as to private industry jobs, if the private industry job is off-site, like Zephyr, of course, they have to be minimum custody. And then we prefer that we've gotten them into some of the program options that we've talked about to address cognitive distortions. That's the research term that is at play when they speak of soft skills. And then we've tried to balance with private industry jobs the need of the employer to get their training investment back and the need to run as many of our residents as we can through those industry jobs. Because, you know, we have 9,000 some residents, and if my memory is right on this handout I gave you, not nearly that many jobs, but we've made great strides in the number of jobs. I think we have about 1,400 of those jobs. So those are the kind of factors, and a little bit of it is how well the case manager is watching the progress of that resident to prepare them to go out into that job. So those are the factors I see. One thing that Secretary Zamuda and Deputy Secretary Raby did in the last year was retool the policy about timing, and they've had ongoing dialogue with our private industry partners to try to get them to help us find that time period where you get your return on your investment. So those are the kind of factors that are dictating when someone goes into a private industry job. Some of those jobs now are in our max units, so that gives you more opportunity as well. For example, at Hutchinson, we have a couple of strong partners there who are inside the max wall, so that helps too. Same at El Dorado.
With regard to cognitive distortions, so what type of services or therapy is provided for all of those that are incarcerated? Because when we're talking about those soft skills, it's getting along with others, being responsible, owning the issue. So is there ongoing cognitive distortion training that occurs regardless of how long their sentence is?
Right. Yeah, that is, as they say, the million-dollar question. So if I could frame this up, you hear people speak like Mr. Schultz was speaking of the WARNA and the LSCMI, the assessments that get done. If a person ends up in the criminal justice system, and the deeper in they go, the more this is true, they've got thinking patterns, and a lot of people have a lot of ideas about what causes crime, but there really is a science to it. There's now almost 40 years of research from which we know what drives crime is criminal thinking. And it has attributes, and when you're around it, you learn to recognize it. And it is closely associated, they call it the Big Four. It's closely associated with extensive criminal history. You started young, you did it a lot, and you kept getting worse. Criminal companions, they call it, and criminal use of your leisure time. So if you find someone who's scoring high on those assessments, that's what you're going to see. One of the byproducts of that way of life is substance misuse. I heard a leading light years ago at a workshop say substance abuse is barely criminogenic or crime producing. And it's because it's the mindset behind the use more than the addiction that flows from use. Another byproduct of that way of life is high rates of weak education and employment history. So you hear these gentlemen, I didn't finish high school because they got diverted, unfortunately, down a trail of criminal behavior that brings you into a system that, if I may speak plainly, since I'm going to retire a week from Friday, honestly, every once in a while gets in the way of itself. So the work we've done for these 20-some years to bring recidivism in this state from almost 60% to 32% has been wrestling with that reality that I just described. So here's the story about cognitive work. We call it cognitive behavioral interventions. The literature speaks of CBI. Every program that we roll out, we have made sure is built on CBI principles. And it's not voodoo, it's this simple. It's social learning 101. It's teaching social skills. So you know how to make an ask properly. You know how to address conflict properly. You know how to be empathetic to the person you're listening to. You know how to balance your needs with another person's needs. I could list you literally 50 social skills that are at the core of this work. We all do it like we breathe because that's how our life course went. If you watch a child who will throw a fit when they don't get their way, if that gets stunted, that's what becomes the adult. So the behaviors, the attributes are risk-taking, impulsivity, negativity, victim blaming. I mean, there's a thinking pattern that leads to behavior that is rested on a lack of social skills. So if you went into any of our programs in any of our sites and watched for months, they practice the social skills around the real life situations that they're dealing with day in and day out, and they do it over and over, just the way you would parent a child, until it becomes a new way of thinking. It's really that simple. So we started with Thinking for a Change. That was the emerging. We've evaluated it in Kansas. It gets great results. We built it into our substance abuse program. We built it into our sex offender program. We built it into our job readiness program. We built it into our family problem solving program. I don't let anybody bring a group of residents into a room to work on anything without that being at the core of it. So that's the answer to your question. Do we reach everybody? No. There's 3 reasons. We don't get them long enough. They're not ready. It's just a waste. We teach motivational interviewing. We require it of all our staff. We've got folks like these folks sitting here who are walking examples of it, but some people are not ready. They're just not ready. And third, there's just not enough of it. There's not enough space, and there's not enough people doing it day in and day out. So, but we reach a lot of people.
Sarah Foscato.
Thank you, Madam Chair. Thank you, Margie.
Thank you.
Phelps, we met your brother yesterday.
Oh, yeah. Yeah, that's my baby brother. Yeah, he's a character.
Thank you. So, 3 questions so my first one is for Randy. Randy, how much do you pay those inmates who are coming out and working at your company?
So the short answer is we start at minimum wage and we work up based on performance. So we have a performance-based pay that managers come together every 2 weeks and talk about their direct reports. And because it's not like a traditional job that you have a 20-year career, we got them for 18 months, everything happens very condensed. So every 2 weeks, we're having those discussions based on what they're performing with their
And then they save that money and they have it when they leave.
25% of it comes back to the state of Kansas.
Okay, okay.
They pay their taxes.
Okay.
Like everybody
That's
else.
good. We're teaching them how to, it is in the real world to pay
And
their
some of
bills.
these guys come out with, $5, $6, $7, $8,000 in their checking account. The better part is they got all their restoration, all their child support all paid.
Sure,
So,
okay.
I mean, somebody just told me today, he said, if I had to come out today, I had all this back child support, all these past debts, didn't have a job, couldn't find a place to live, and I had $100, what am I going to do? So we get them a skill, I mean, but they have to make that change.
Right, and Madam Chair, then, so Margie, so in talking to, and maybe even the other gentleman, Lee, but when you're talking to them, the inmates, when you're talking to them, what was their main reason? Because I'm just so poverty. We can think of the criminal mind later down the road, but from my knowledge and people that I know and have known and still know, so it starts out that they're just poor.
Right.
So they go and they got to eat. Senator Dahl said they've got to eat. And then it just kind of starts like that. So I think that's a real issue, poverty, Madam Chair. You're an educator. So my daughters went to school miles away from where we lived. And they rode the bus. And so we don't have enough funding for after-school programs and all of that. And I was a working single mom myself. And so I know that children want to belong to something. Yeah. And if they're going to belong to a gang or they're going to belong to controlled activities in school. So I made sure that I would leave my work during my lunch break and I would make sure, and I'd go, my daughters wanted to do patrol, where you stand with the stop sign. But none of the black kids in my neighborhood, their friends could do that because their parents either didn't have a car to go drive out there and pick them up after school. So they had to go ahead and get on the bus and come home if they wanted to get home. But I made sure that my daughters, whatever they wanted to do, brownies, Girl Scout, everything, I made sure that they were there. And I was fortunate to be able to drive them here and there, but others don't have that up. They just don't. And these people, after 30 years later, I know some people that still don't have a car. They've never had a vehicle in their entire lives. And so I guess that's my question. And then Mr. Wait a minute, James Wilson, Mayor Pro Tem. Wow, I hope to read your book someday. A fascinating story. But Margie, if you could tell me, so what's the main reason that they tell you that they, why did you do the robbery in the first place at 12? Why did you start drinking in the first place? COVID left a lot of people depressed, lonely, sad. You start to go to other vices. So you start to drink, you start to do drugs. I just had a meeting with the best sheriff in town, Jeff Easter, about fentanyl. That's another issue we've got to deal with our young people. But what was the root of your situation, Jermaine Wilson and Margie? What did they tell you? And Jermaine, why did you do it in the first place?
I know for me, we did grow up in the government system, poverty, and when you grow up in poverty, that's all you know. And so you get exposed to those things, which is the criminal lifestyle. You don't know that they're wrong until law enforcement comes in, because everybody is doing it. And so it was just one of those idle times that we had. And, someone started off pulling out marijuana, and because we want to fit in, we're young, we don't have anything else to do. We're in the ghetto, and we don't go outside of the ghetto simply because this is our community. And so we just begin to indulge off into those things, and they're illegal, but it becomes our norm. And once we begin to practice those everyday normal behaviors, we become accustomed to that lifestyle. And when those things are taken away from us, well, we're going to do those things to get those things back. And, and then seeing on TV the fancy cars and, all of those things is luring to a child, and it's enticing. And so we think the only way that we can get those things is by committing illegal activities.
Well, if I could, Senator and Madam Chair, committee members, I think there's a lot of paths. I think there's two things I'd like to say about that question. First, these circumstances people find themselves in, I think that's how they derail. That's how they end up in an environment without the skills, without the education. What you described that you did is known in the research as pro-social influence, which is what our mentors do. The need for every human to have pro-social influences is so fundamental, and if you don't get it, you end up antisocial. The other thing, when you say, what do people say when we ask, if I could segue to the employment off that question, years ago, we were struggling, parole was struggling. The short period of a revocation was seen as not useful. And I kept hearing from people, the people under supervision don't care, they can do 90 days standing on their head. That was the common mantra. And I questioned that. So we surveyed hundreds and hundreds of people who had been revoked multiple times. It was a simple, straightforward survey. There was one thing, there was a lot of things you could learn, but there was one thing that was loud and clear coming off those responses, and it was this: we need help getting a job. We don't want to do 90 days at all, let alone standing on our head. We need help getting a job, which led us to, by the way, everything in this handout. I hope you all got this handout, because here's the takeaway for the committee today. Of all the things that you struggle with when you're in the criminal justice system, the biggest mitigator is not being placed in a job, and you hear this a little bit from Randy Reinhardt's data. It's sustained livable wage. Sustained livable wage. We've done 4 Kansas evaluations now. The private industry job increases the chance that if you hold it just 6 months, that you'll get that sustained livable wage job by 20%. One college course by 25%, and so on. And when you put all that in a pot through 4 different studies, recidivism goes down by 1/3. And here's the most compelling thing that I saw in all of it: the higher your risk, the bigger the impact. So the mitigation value, weak education and employment is its own risk factor, but it mitigates substance use. It mitigates the family issue that Lee was speaking of. How am I going to take care of my family? Of course, that strains the family. It mitigates mental health issues, stabilizes you in your recovery from mental health. It mitigates financial issues. So if there's anything for the state to invest in with people who are in the criminal justice system, it is effective strategies to get to sustained livable wage employment. It's incredible. We saw on our high-risk folks They went from 42% recidivism if they didn't get one to 17% if they did. So it's just highly impactful, and we could not do it without all these partners. We have great partners. We have great education partners, too, so it's going well.
Senator Dahl and then Representative Hoffman.
Thank you, Madam Chair. Ms. Phillips, with your studies, what's livable wage?
That is a very good question, and there's a range. It depends on where you are. That's the short of it. But it's more than, it's more than minimum wage, and it generally tends to be in the $11 to $13 an hour range in those studies. And I would tell you, if I could, sir, in that respect, the work going on from fiscal 20 to fiscal 21, the average starting wage for people who worked with our job specialists went from 11-something an hour to 15-something an hour. That's moving us towards a good livable wage, but it's in that range in Kansas.
Follow up.
But along with that, your studies, we're going to have to probably throw the inflation's going out of control, so that, well, as they're going up to $13, $15, so your livable wage will have to go up too. Thank you.
Exactly.
Representative Hoffman.
Thank you, Madam Chair. Randy, you mentioned that part of that they come out with some money in their checking. Now, I'd heard, and I think this was the Legislative Budget Committee and the Committee on Buildings toured, I believe it was Hutchinson Community College, and in their program, I thought they said that 10% of what they earn goes into a savings account that they get after they've been released. Is that what you do, or is that's?
So we're part of the same state program. 25% of the gross, not the net, gross goes to the state. Is it 10% goes to a mandatory savings?
Right.
5% goes to the victims fund.
Right.
So there's a total of 40% that comes out of the gross, out of the net. We don't do that, right? Huh? No, we don't do that. So we basically set our guys up as a normal employee. The only thing that's different is we have 85 guys with the same direct deposit account, which kind of freaks out our payroll folks. But going to the state, and the state then takes out the 10% and the 5% and the 25%. We take out the federal, the state, and take out the child support, take all those other garnishments before the money actually gets to the state, which the state then takes out the 25, the 10, and the 5.
Okay, so that's good. I wanted to clarify that so that 25% that's coming out to the state, 10% of it is actually going back to.
No, 25% goes to the state. Another 10%.
Oh, okay.
Goes to them. Another 5% to victims. So a total of 40% of their pay, of their gross, is already allocated in those three places.
Okay. All right. Okay.
And I would say that for the most, and then our guys are eligible for 401K. They put the money away, and they've done a really nice job of putting money away in a 401K. So when they get out, they have that as well.
Okay, great. So they could potentially have a fairly good size in that savings account that the department has.
Yes,
what is the average then? Do you know? Is there an average of how much they probably have?
The people who get into industry jobs, they're leaving with between $5,000 and $8,000, and that's after the 25%. By the way, that actually goes to Kansas Correctional Industries and is used to finance new startup, like build space for private industry, make partnerships with new private industry partners. They've even experimented with embedding a staff at Russell Stover's, where the women now have over 200 jobs, market pay, to do this case management problem solving that we've been discussing. So various things, that's how that 25% is used. But even after that, and paying the victims fund and any child support, by policy, we require they pay restitution and child support. And for savings, it's called 10%. They usually save a lot more than that. We just require at least that much. But after all that, they're leaving with some thousands.
That's great. That's great. Okay. Thank you, Madam Chair.
Thank you. I do have a question for Lee. Lee, could you talk to us a little bit more about, I don't know if you guys picked up on it, but you spoke to the employment readiness scale.
Yes.
And you indicated that that's an international instrument used?
Yes, it's a validated instrument. It is, the organization is in Canada. We looked for, Johnson County Corrections asked us to run data so that we could kind of show our program and its effect on folks as we worked. And so we started doing the research. We use employment readiness scale. I can get you more information about that and send that to whoever you want to so that you can look them up. You can see kind of some of the research behind the tool. It's used in the UK, Australia, the United States, Canada, and I'll be going up to speak at a conference on workforce in Canada because they have very few programs like what we have here in Kansas, in Canada, to work for around returning citizens.
So first of all, if you can get that information to Lindsay Archer, that would be great, and she'll make sure that we get it. And the reason I asked about it, so do I understand correctly, so you start and they take that and they go through that assessment initially?
Yes.
And then as they continue with that training, you continue to assess?
Yes, that's correct.
So you get a baseline.
We do a pre-post, so we do a baseline. For our program that we run at the Adult Residential Center in Johnson County, it's a 12-week program. We do a post at the end of the 12 weeks. And then we're working with the county to figure out how we can do one maybe pre-release, maybe work with probation to do it. We've only been doing it since 2020, so we're trying to learn how to better implement it and use it to gather more data, even post-release. With Randy's folks, we have it scheduled to start with the pre, and then after the 6 weeks, and then we will start doing those at 90 days, and then we'll start doing those kind of towards release. There's a certain number of times we can do it within the license for each individual. So what we'll do is start looking at release dates and start doing employment readiness scale. One of the things the tool allows us is to build an action plan based on what their assessment shows areas of improvement.
That's excellent. So you shared with us quite a bit of data, more than 50%. This was a primary concern and so forth. So was that as a result of information that you got using the employment readiness scale?
Yes, the employment readiness scale measures 7 different domains of either hard skills or soft skills. I can send all of that to you. And then it also measures on what those individuals feel like are their challenges ahead of them, and it kind of puts them into buckets. There's challenges related to social challenges, systemic challenges, personal challenges. Some of the things that I shared are things that are indicators or personal challenges, and what happens is the whole group, and this doesn't, this kind of lets us assess this as a whole group, but we can also get their personal challenges. But as a group, then we can get the top 5 challenges that group of ERS folks that we administer, that group has. Randy's challenges for his staff are different than those in Johnson County, because those in Johnson County are facing release, they're in substance abuse, or currently on probation. Randy's folks still are looking at time. Their challenges are a little different. So it does help us to see their individual challenges and challenges as a group.
I appreciate that. I think it's, and the reason I asked, with it being an international instrument, that means it's widely used, widely dispersed, and it has tremendous validity. So that ability to measure also over passage of time and passage of training and intervention becomes really valuable. I appreciate that.
Yes.
Committee, are there any additional questions? I'm not seeing any. I can't thank the panel enough for being just brutally honest with us. We, as legislators, can only guide and direct funding and services to an extent. But it's wonderful to see what's being done internally. And Margie, your expertise is going to be missed. I think we all were able to very quickly glean. You're all over what it is that you do. You've got it. and it's going to be missed. But for those of you that are working on the outside in your different ways, what a wonderful job you're doing in helping Kansans. And so thank you so much for that. Thank you for being here. Committee, we don't do this so much with our others, but I want us to end this session with our panel the way that we did when we were at the drug court, because they do deserve a round of applause. Thank you so much. Committee, we are going to take a brief break. We're going to come back and we're going to have, to the extent that you want to, we'll have a discussion about our statutory duties and obligations.
That out. Yep. Okay, thank you very much. Yes. Cool. I appreciate it. Thank you. Thank you.
Yes, yes, I do. Yes. As they get really full. Hey, where'd you get that shirt
We've had a break, but we're going to, let's just have a little bit of discussion about, you have your choice. Committee statutory duties, committee obligations, or we can have some discussion about topics that we've heard so far. I know that Representative Owens is going to have to be gone tomorrow.
I'll be online for the second half, hopefully.
So if we want to talk about some of the things that we have heard so far, if we want to make any preliminary recommendations, or if there is additional information that we think that we are going to need to get from the revisers or from legislative research. Senator Dahl.
Thank you, Madam Chair. I would like, and you guys can put it so much more eloquent than I can, but the money that goes back, the millions has been going back, we need to put it in programs such as this. If it's been allotted, as if it's been budgeted, I would like to see that money goes to some type of rehabilitation because we saw how much it saved money in the end game. So I would like to see that. Put it however you want to do it, Senator.
Okay, let's be specific of which money we're talking about.
I was talking about, what was it?
Each
The guy from
county.
Hutchinson had to send so much money
Oh, okay.
because that's, they're rehabbing there in Hutchinson. So wasn't that like 2.3 million or something like that? I don't have the.
Okay, we're going to, Representative
I like the
Owens.
look Jason's giving me, so.
Thank you. If I remember right, and correct me if I'm wrong, we were talking about the money that community corrections was put in a place to give back. But one of my recommendations was to fix that so they didn't have to give it back. Because the only reason they were giving it back was because of interpretation from Kansas Department of Corrections or the executive branch on what it could be used for.
And I could go for just so it went back to what it's designed to take care of.
Absolutely. Yeah.
Okay.
So that would be my recommendation whenever you're ready for it.
Okay. Well, look. We have requested that the Department of Corrections is going to talk to us about that tomorrow. But I think it's fine if we are in agreement prior to that conversation that we intend that money that was designed for community corrections in each county to go to them, that they use it, not this notion of lose it and sending it back. Is that what you're talking about?
In a sense, I am. I'm not wild about them, each county keeping their own. I'm more concerned with, because each county has its own thing going on. But like what they're doing in Leavenworth is going to be more expensive than what they're doing in Coffee County, for example. And I'm just picking on it, Representative Smith. But it's, so
That's two different
but I would do whatever
programs.
you all want.
No, I thought you were talking because you mentioned the panel that spoke just a few minutes ago. So I thought you were talking about there is a breakout of funding when they said that we take out the 25%. So if the employee earns $1,000 in that paycheck, $250 of that goes to pay taxes, 10%, so $100 goes into their savings account for the individual, but the additional money goes into corrections.
I think it goes into to establish companies to employ them.
The victims fund.
Yes. But I think what we referred to on the Reno County one was that Reno leftover money from Reno County would stay in Reno County. And and I'm fine with it as long as it stayed there, but I think it could be better used if it would go into the criminal system itself to help programs like that they have all over. Hutchinson's going to need more, and Leavenworth obviously going to need more than what Gray County would need. But there again, I'm not going to fight that as long as that money goes to criminal justice somehow, or rehabilitation.
Well, part of what we saw today isn't necessarily community corrections. So community corrections is funded differently from what they're doing, from what was presented today. So part of community corrections and the concern about that was they were told it could only be for the pay increases. It couldn't be to hire additional staff, even though they needed additional staff. And so rather than being able to use, they were having to send it back to the Department of Corrections. Now, you could argue, well, when it gets to the Department of Corrections, then it needs to go into something like this, which is workforce training, but that is paid in a completely, we're talking about two very different pies, if you will.
And I agree with that. And the two pies, though, I think if it goes into the criminal system, is going into rehabilitation in my mind, and I'm probably seeing that wrong because how much of repeat offenders that we have. So I see where you're coming from, and I'm not disagreeing with you at all. They're two piles, but they're one pile in my mind.
Okay. Okay, so I've got, I think Representative Resman, and then we'll go to Representative Carlin. I thought I saw your hand up.
I was wondering, before we move on to what we've heard in the last 2 days, should we talk about what we've done in the past and think about what we should, if you were to try to advance those again? We've discussed, what's happened in the last 2 days here. Should we go back and look at what we recommended like last year and the year before, and try to do something with those
That
also?
hasn't happened.
Yeah.
We will get to that. Let's hear Representative Carlin, and then we will circle back.
I just want to make a comment. We were talking about how the money can be used, and I think I believe, Madam Chair, you said they couldn't hire new people. I think that was because it was pay raises. Help me out here. It was pay raises, and we want to be able to sustain that in the future. And so if we hire new people, we may, that was a request by the administration, I believe. So
Didn't they cap out? They tapped out. They got to the top of their chart. That's why they couldn't get any more raises.
is that, and then on top of that, the governor's office, I believe, asked not to hire new people with that money, with that raise money, because then that would create the next year's increases as well.
I think what we're confusing is there were some guardrails that the governor proposed in her budget. So that was at the beginning of session. But then the legislature had a proviso that did not have those guardrails that the governor had put in, even though then, once the money went to corrections from the proviso, those guardrails were put back in. So unintended. Depends on which lens you're looking at.
Exactly, but as when a proviso comes through the committee, the whole committee of appropriations, we've discussed it all, and sometimes all the words don't get in, and I'm not sure what happened in that case, but sometimes the intent may be there but not spoken, and then it's not in the bill, it's not in the proviso, and I don't know. Kyle, did you make that proviso? I don't remember. So anyway, it seems like it was a very difficult situation, and there's still issues there, and I'm just trying to muddy it up, I guess. But
I think we'll have more opportunity to address this tomorrow when Secretary Zamoda is here. So we will do that. So, Representative Resman, you have the lavender packet before you. Is there something in particular from the packet you would like to speak to? And somehow...
Thanks. Yeah. One of the things I've noticed here, it's on the first page, and
Isman, you have the floor.
Thank you, Madam Chair. One of the things I noticed, because you just heard a presentation about one of the programs on welding and everything, and last year we recommended, it was $6.7 million for Pathways for Success.
Yep.
Which includes some of the programs that they were talking about today. I wonder if we should try to resubmit that, since we heard a presentation and apparently it's working out very well. It's on the first page.
Right, so we added that, so you're wanting to add a recommendation to add more for next year?
Well, same amount, but I don't think it passed, did it?
Yeah, it said legislator action 6.7 on the side.
Okay, okay. Okay, yeah, I would say the 6.7 again, since the successful program.
And I think one of the things that we were wanting them to do is make sure that that counted toward that maintenance of effort, because the equipment, those that are incarcerated can earn certification with it, so that not only did we want the funds to go for the capital expense, but also to make sure that it would count toward our maintenance of effort funds for higher education. Does that make sense to you? Representative Smith.
So my question is, I haven't kept track of that. Did we end up going with ARPA funds, or did we end up doing the maintenance of effort?
It says that it went SGF, so, but it still should be able to count toward maintenance of effort. It's on page 1 of the lavender packet. It would be that third section where it says the committee recommended strong support for 6.6 million proposed to use maintenance of effort funds for information technology upgrades. Yes.
If I remember rightly, that maintenance of effort was from industry, and so they were needing some money to help to do a maintenance of, to buy the equipment, and that was like their part of it, and then to get the industry to bring in more. And I mean, I guess my thought on that would be, do they need more? Or did this satisfy what they needed? So I'm not sure. Do you think they needed more? Or they need more? Or?
Well, it sounds like it's a successful program, and I think we should continue to build.
But it wasn't a program. It was to buy equipment.
It was a one-time money.
It was a one-time
less.
money, basically. Yeah,
Okay.
to buy equipment. So.
Well, I think that one of the things that perhaps we should explore, it's my understanding that this equipment was for those that are incarcerated in the male facilities. And one of the things that we know that we have been significantly lacking in is capital equipment and training programs for the female facility. Now, we did learn today that the job opportunities are now available for the female inmates here in Topeka through Russell Stover. We also learned, I think it was Representative Owens and I learned, that there is an embroidery business here in Topeka, and they approached the Lansing facilities, but they kicked that back, and so now it's the women inmates, and
It was 50 or 60.
50 or 60 positions
That are now inside.
that are now inside. But I think it's appropriate for us to ask, so you got the 6.7 million, is there an ongoing need for equipment and technology within? Okay? So I have that marked down, is to ask if additional funds are needed. Representative Carlin.
Thank you, Madam Chair, and I agree with you, and we did see that the women were really lacking in opportunity. It broke my heart. I wonder And I don't want to shortchange any program that's going on, but why are the women not given the opportunities to become welders or something that pays substantially higher wages? I'm happy if they're going to do tasting at Russell Stover's. It gives them experience and some soft skills and some wonderful opportunities, but what's the outcome after they get out of prison?
They're working in the factory. It's factory work.
Factory, okay. Well, and so I just, I don't want it to stop with the male population. And as far as our investment in equipment goes, whatever other things they might need.
I would agree with you on that. I do know that one of the issues that really is not frequently talked about, but they are at capacity, if not beyond capacity, for the female inmates. And welding does require a separate facility that they do not have. Can it be done? Yes. Are there female welders? Absolutely. Are there welding jobs? There are. Burlington Northern hires a whole lot of them. So I think.
And with the welding, it does take a lot of space. And I don't know if the space is available to enlarge that or not, but those units took quite a, a little bit of space.
Yeah.
So thank you, Madam Chair.
Okay, Senator Dahl.
I was talking to Representative Smith, and this back home is a big deal, but mental health aspect is we're hurting really bad. And on the bottom of page 3 of the lavender, it was money that would repurpose to build 3 smaller units because we're out of beds. Osawatomie's out of beds, and I don't think those would all be in Larned the way I read it. I could read it wrong, but I think we need to establish something for mental health because that's leading to, and it's getting worse.
Okay, I'm looking at the bottom of page 3. Read it to me.
The committee recommended an expedited study of the potential of repurposing Kansas KJCC and Topeka, perhaps Ada dot use, and creating 3 smaller regional dispersed juvenile faculties in South Central, Northeast, and Western Kansas, to possibly including you see where I'm at now?
I do.
Okay.
Okay.
And then that other side is where that money would come from, and it's I was telling Representative Smith, last Christmas I had a sheriff call me. Had a kid, he had a guy who was going to blow himself away, had him in jail, couldn't hold him, and he didn't create no crime, so they couldn't hold him. And they called Larned, they called Osawatomie, and that's just one story. That we lack these facilities. Larned's lacking. Osawatomie, we've been hearing that for years, so I think that would be.
Okay, and I think rather than this section, this was that we were going to close the juvenile facility that we toured last year in northern Topeka, and that we would repurpose that perhaps for the women's, and that we would open up regional juvenile corrections facilities. Now, what you're talking about, I think, is our mental health
misread it altogether,
crisis.
Molly. Mr. Senator, I'm sorry.
No, but you're talking about our crisis centers, crisis intervention centers.
I am. And
Okay.
I'm sorry, I read the wrong thing.
No,
I just.
that's okay. I think our crisis intervention centers is going to be a major talking point tomorrow.
Okay.
I think it will be. We have a facility, in fact, if you've looked ahead for tomorrow, there's a facility in Olathe that's got beds. It's not opened yet. It's been waiting for funding, but jumping through the KDAD's hoops has made it impossible. And by golly, if we have a facility, let's open it up, get those beds where kids can receive treatment, period. Likewise, over lunch tomorrow, working lunch, Arista Recovery. They provide recovery for alcohol and drug addiction. private. They spent their money to come into the state. If there are beds, the state needs to start renting them, paying for them, and getting Kansans in to get the services that they need.
I don't think that system's working though right now, do you?
Okay, so
That's what we're talking about.
Senator Dole, don't think the system's working. Then we'll go to Representative Owens. So we'll all speak, but not at once. Representative Owens.
Thank you. I'll try to touch on all of those things. One, I'm curious to hear what Arista Recovery has to say because it's not a lack of bed space, it is a lack of funding. So I interact with MIR on a regular basis. They're headquartered out of Newton. They're the largest provider of substance use addiction services, as evidenced by SB 123 presentation earlier. Long story short, they have seen funding cut, and then actually some of the funding actually spread out on a state level that is hindering their ability to provide services. So it's not a bed space issue. So I'm curious what that is tomorrow. Juvenile crisis intervention centers.
We know there's money out there.
Yeah.
As to whether the state's willing to pay for it.
Therein lies the question.
There's the issue.
That's right. So yes, absolutely right. And more recovery options are certainly better. Juvenile crisis intervention centers, I won't be here, but I just want to let you know that I spoke with Robert Sullivan and his team about a month ago about changes they need statutorily to make that work. For example, one of the things he will talk about is changing it from any juvenile who has experienced a mental health crisis to a juvenile behavioral health crisis. So not just mental health crisis, because right now we have it very limited what that bed can be used for, and opening that up. So that'll be a topic of conversation.
Is it and/or? Will it be and/or?
Sure, because juvenile behavioral health crisis opens it up to more than just mental health.
Okay.
And right now, I guess that statute is very restrictive, but I know that he'll talk about that tomorrow.
Okay. Representative Hoffman.
No, I think that Representative Owens probably pretty well clarified. The deal with the youth intervention facilities is not that they're not working, it's that we don't have any of them. And it's been, I don't know how many years now on this committee that we have said, get them open. And I'm a little frustrated that now finally the DOC is finally coming to us and say, oh, we can't open them because of this. I mean, we need to get it fixed, but this is something we've talked about every year for probably, I don't know how long. It's been a long time. And so I'm glad hopefully we can finally get it moving. As far as on the mental health, yesterday we did make the recommendation in the other committee I was in to build a new mental health, a 50-bed mental health facility in Wichita, which will help tremendously Larned and Osawatomie. So thank you, Madam Chair.
Senator Fascadell.
Madam Chair, our discussion, is it about any topic we've heard thus far, or just?
It is.
Okay, thank you. Madam Chair, as I prepare to come to Topeka, I have got a host of things on my calendar, but I have this bag that I just kind of, when I come across things, I throw in and bring here. And so, actually, I have with me a program here for Representative Gail Alexandria Finney, and and the Representative Hoy mentioned Representatives Finney's legislation. I think that the Assistant Cedric County Manager mentioned in the 58 recommendations to support Representative Finney's bills, House Bill 2468 and House Bill 2469, and I believe Representative Joella mentioned that. And I know that our own representative, she's my friend, how can I forget her name? She's on our Child Welfare Committee, Christy. Williams, yes. I know that we're addressing these pieces of legislation in the Child Welfare Oversight Committee. I think you mentioned that.
Right.
However, and we know there's issues with DCF, but Madam Chair, where I live and the constituents I represent, the situation at the Cedric County Correctional or Detention Center, Juvenile Detention Center, and Cedric Lofton, some of his family members lived in my district, and all of these issues all of this, as the representative was going to say, we've dealt with a lot of these issues year after year after year, but this particular issue of stand your ground, and with the new information, Madam Chair, that you, and you're right, no one, even in the media, I think I heard it talked about one time, that prone position. And with COVID and all of those other things surrounding the situation, I don't think was really investigated. I don't think we really had all those facts before the district attorney made his decision. And I just, and then we heard from the, the gentleman from Cedric County Detention Center, what's his name? Stephen? Yes, talked about one of the recommendations I know that my district wants, and a lot of those people that are on the list, was that there be audio inside of the Juvenile Detention Center, and we heard now that that's even way out there somewhere. They're looking for the best technology for that, and so that's not even going to come. So when I go home, people are going to ask me, well, what did they decide? Because I was even at our Cedric County Commission meeting where, Madam Chair, it was hurtful to me that the chairman, and we discussed it the other night when we were at the chamber dinner, Representative Owens and I, it was hurtful. They mentioned my name 3 times in their meeting, and of what they were going to do about Stand Your Ground and Cedric Lofton. And one of the commissioners made a recommendation for the Cedric County commissioners to put the Stand Your Ground issue on their legislative agenda and have lobbyists advocate for it just to get a post audit. I see here, and my recommendation to the committee will be that we at least look at the request of a legislative post audit to be conducted to examine the implementations of the Stand Your Ground laws, particularly as it relates to incidents involving law enforcement, to just get the original intent. I believe in 2010 is when we first voted for the Stand Your Ground law. I voted for it. A lot of us did. I believe that the original intent, we talked about protecting our homes, ourselves, and so forth and so on. And, maybe, legislation might come down the line just to, clarify that up, what the original intent was. But my recommendation will be that at least we look at a post-audit request of what I just read. But, Madam Chair, just in closing here, and I wanted to say this before my dear colleague, Representative Owens, since he's not going to be here tomorrow, to just kind of get input from the other members of the committee of what they're thinking about this, because as I said, my name was mentioned. I watched the program again, Madam Chair, a total of four or five times. I know 4 for sure. And the chairman, so the commissioner said that they wanted it on their agenda, and then it's 7 of them, however many, and they voted against that commissioner. And they voted against her because the chairman kept saying, well, this is not a county issue. This is a state issue, and we're going to wait and see what Senator Faust-Coudeau is going to do about it. I'm just sitting at home. I'm like just watching the county commission. I'm like, Well, what did I say I was going to do? I hadn't decided anything for sure, but they just kept mentioning my name. And then the Leeds, who was here yesterday, you know, they sent me an email and called me and had lobbyists calling me and asking me what I was going to do, and I hadn't decided that I was doing anything yet. And but needless to say, my constituents are like wondering. I'm almost scared to go back to Wichita now without being able to say something's going to happen. So that will be my recommendation, that we at least the post audit to get the data and information that we need and whatever else. And I just wanted to put that out there in case my dear your vice chairman had any comment. Thank you, Madam Chair.
Thank you. So we have written down the request of a legislative post audit with regard to stand your ground. One of the things that we'll have to come up with is the questions that we are wanting them to explore. So between now and tomorrow, it would be helpful if some of you would put a little attention into questions that need to be addressed through the legislative post audit. I have Representative Heiberger, and then I have Representative Owens.
Thank you, Madam Chair. Is it appropriate to go back to items from the previous year?
It is.
All right. On page 1, third from the bottom, I would like us to adopt again the recommendation to allow KDOC employees to be included in the same plan as the police and firemen's retirement plan. I think that's something that we've heard over the years has been really important to our corrections officers.
Okay. Is that the committee recommends KDOC employees be included in CAPERS?
In the corrections, well, my understanding is that they would be moved to the same plan as firefighters and police and firemen's retirement fund, but I'm not sure it states it quite that way here.
It is a different one.
Okay. So, this is the one that would move all the KDOC employees
To the corrections
okay, yeah.
plan.
Well, yeah, well, I would support that too. So I would ask that we adopt the third recommendation from the first page, on the bottom from the first page as stated there.
Well, why don't you talk some more about it then, Representative Owens?
Thank you, Madam Chair. Great minds think alike, Representative Heiberger, because that was exactly going to be what I wanted to talk about. Okay. I think that there were bills introduced, they just didn't go anywhere, and I don't think that that is a reason to forget about those folks. I remember we visited with them at KJCC, and we talked about this very issue. And so they were one of the big groups that wasn't part of that plan. So I would second that recommendation from Representative Heiberger that be reintroduced and a recommendation of this committee.
Okay. As a point of clarification, perhaps you can address this, Representative, but it does say that the legislature deleted $10 million SGF from the State Finance Council for conversion of certain KDOC employees.
Thank you, Madam Chair. That was because those two bills did not go forward. So it will take, a bill to do it. So money was, and I don't remember if money was put in the governor's budget or we put it in, or it may have been put in, through our budgetary process, that we put $10 million in there if those bills passed. Neither one of them passed, so we just deleted it because.
Okay.
So,
okay.
yeah, I mean, but that tells us kind of, I think, how much it would cost.
I was going to say, that gives us that
Yeah.
fiscal note. Okay. Now, I'm going to simply say this. So we have this motion. We have a second coming from both members of the House. We, as a group, are going to have to really work to make sure that we find a way to have a hearing on this, that we get this up and out of committee, we are going to have to work diligently with our leadership to let them know that this is coming and it needs to get up and out, not only of committee, but it needs to get on the floor. This is an entire group of employees. And for us to not be able to make that movement, we can't do it in a proviso. But also, we're going to need to make sure that we get Alan over here from Capers and that he has that background information and can share as well. This is what the cost is going to be. This is how it's going to help these employees. And the Department of Corrections is going to have to help with some heavy lifting as well. Representative Smith.
I'm sorry to interrupt, and I don't want to sound like a naysayer, but the motion made was for column 1, and the second sounded like column 2. And the importance here is the definition between the two groups of employees that we're talking about. Column 2 talks about certain employees. Column 1 says all KDOC employees, which is going to include office help and janitorial, et cetera. So you need to make sure that if we're going to make this recommendation, we're specific about who we're talking about.
I thought we were talking about column 1. That's what he's talking about.
So all KDOC employees.
Yes, because the question was, my question was simply, sorry, my county commissioner. Column 2 is what the outcome was, and it was simply the 10 million, but it didn't do anything
Right.
because the bills didn't pass.
But that's an important distinction. If we're going to go after this, do we go after it from column 1, or do we recognize that there were certain groups identified in column 2? And how did we get to that? You know, I know that there's a reasoning behind it, why they went from all employees over here to certain employees, and it's because of defined individuals under that plan. So by changing this, we changed that definition.
Correct.
Of who's.
Representative Owens.
Yeah, I see what you're referring to. So it sounds like what our recommendation was, which is the recommendation that I am supporting, is column 1, which is allowing all KDOC employees to be included in the Kansas Public Employees Retirement System Corrections Plan, with first priority given to juvenile correction officers. I think what happened, what the quote-unquote outcome of that recommendation was, that looking up these bills, for example, in the House Bill 2713 was introduced by Representative Probst, that may have expanded on that and tried to include Kansas Department of Wildlife and Parks law enforcement officers into KP&F. So I'm not necessarily saying we need to reintroduce that specific legislation, but I definitely want to support this first recommendation.
Because what you see in column 2 isn't something that came out of this committee.
Right, I understand.
Yeah. Yes, Representative Heiberger, you were talking about column 1.
I was slightly confused, and I support both, actually, but for the purposes of this discussion, we'll go to column 1.
Okay. Representative Hoffman, did you have?
Right, and that would change that would actually change that $10 million, because that, I see what you're saying now. I wasn't reading all through it,
Okay.
because that did include wildlife and parks law enforcement. And
So it would be less than.
Is there just a corrections plan, or the corrections plan that we're referring to in column 1, is it KP&F? Or is there a separate corrections plan? There is? So yeah, that's totally different than what, you're right, so. But, and I kind of have, I mean, I'll go with it's fine, but I do kind of think that if we're going to move them over, it ought to be the corrections, it ought to be the certain employees that are actually working in the corrections facility, not all staff who are maybe working in the office and things like that. But that's a point I think that can be talked about in when the bill is being discussed, but,
I think we need to have some of this buttoned down
okay, I mean,
prior
that would
to
be,
session.
I think it is totally different, because what,
The original ask was from the juvenile corrections folks.
right,
That was their ask when we write before and at the conclusion of the tour of the juvenile corrections.
I think an important distinction between the two plans, people should understand why there are two different plans and what they look like, why they were set up the way they were. Because when you start getting into the solvency of the plan, and when you're adding more people at KPNF, you're creating, anyway, it becomes very volatile. And as an administrator in law enforcement, I can tell you, there are often discussions. We're currently in our department trying to move from CAPERS to KPNF for officers and everybody. But we can only move jail staff, those actually in the dealing with the inmates, and law enforcement officers. We can't include dispatch. We can't include our office help. We can't include those because they don't qualify under KPNF. So there are distinctions in there that are set up specifically to keep the plan solvent. So,
Representative Resman.
Thank you, Madam Chair. Having worked in the federal system, if you work at an institution, doesn't matter what your job is, you fall under a 20-year retirement. If you work like at one of the regional offices or in the national office in Washington, D.C., because you're not directly working at an institution, you fall under a 30-year retirement system. So it depends if you're at an institution, because of the danger that anybody can be in, they kind of compensate by the better retirement. So that might be something to think about.
So I think it would be appropriate to make sure that we have the questions ready tomorrow for Secretary Zamuda about this. Representative Heiberger.
Well, I've got several more, but I don't want to take up all the time, so the next one's easy.
Before we move to the easy, I think that we're in agreement that we haven't fully decided where we are on this one with regard to moving, whether it's all Department of Corrections employees or if it's just the juvenile corrections folks. Can I have a nod or a head shake on that? We're agreed that we, yeah, I do. We don't have total agreement on this yet. Are we good on that? We don't know what that ask is going to be yet. Okay. So now we will go back to Representative Heiberger on the easy one.
Well, we hope so. Second,
We'll vote on if it's easier.
second from the bottom on page 1, allowing the time period for terminal medical release of an inmate to for 120 days from 30 days as it is now. The policy we have now, this has been on our agenda for several years. I think it's going to be on the Sentencing Commission agenda also, but we have a terminal medical release policy right now that's completely ineffective because one must wait until one has been diagnosed with 30 days to live before one applies, and the processing time for the application is longer than that. Most states that have a plan like this have 6 months or more for their application period. This would just extend it to 120 days, and every application has to go through the Prison Review Board. It's vetted extensively. People have to have a plan for care, and there has to be a finding that there's no danger to society. I think this is pretty straightforward. It's passed the House a couple of times already, so I'd just like to hope that the third time is the charm.
I will simply share with you one of the reasons, and I was just double checking with Senator Corson on this, and I think that Senator Bowers will recall as well, where it really got hung up in Senate Judiciary is it's essentially the responsibility of the state, I believe as the language reads, to figure out where this person is going to go. And that's where it got stuck. We understand that a healthcare worker is going to try and make some determination on how much time the inmate has to live. But what really got the committee stuck as far as kicking it out of Senate Judiciary was essentially the state has to figure out where this person is going to go. And they weren't willing to go that far.
Well, the petition's initiated by the Department of Corrections. And so I assume that they would select inmates for whom they had a likelihood of finding a placement, whether it was through family care or some other support. So, I mean,
Again, that was the problem. It doesn't spell out specifically, but it puts the burden on the state, not only to find a place for the individual, but to potentially fund a place for the individual. And there was a feeling, well, the individual already has a place, it's called prison, and we're already funding that. But to release and to have the Department of Corrections then be responsible for finding a placement, it seemed that that was a bit far.
well, I mean, this bill would impose no burden on the state at all, no requirement at all to provide any out of facility medical care. And by failing to act on this, it would take away this option for people who do have potential outside resources for out-of-facility care.
Okay. Senator Corson.
Yeah, I do remember that we did have that discussion in Judicial. I would think, though, that we could work on refining the language, that's not like necessarily an insurmountable obstacle to this being a recommendation, because I do think we could refine it to, put some guardrails on it. So it's, the person has to have a safe place to go, or a place to go either with a family member or close friend, something like that. So I do remember that discussion in Judiciary, but I at least for me, I don't consider it an insurmountable obstacle for us. I think that we could work on that specific language and still accomplish our goal.
Representative Smith.
My curiosity comes from the idea that we're extending from 30 to 120. What did we change in that obligation, other than it's a longer time period? In other words, it's the same obligation.
No,
it's just we're giving it 120 days instead of 30.
Yeah, the bill strikes the number 30 and adds the number 120. It's one of the toughest assignments I've ever asked Natalie to do.
And I'm not saying that to be argumentative. I mean, to me, it seems that same obligation is currently there, if it exists when we change that time frame. Obviously, it would be a longer time that they would be.
Agreed, and part of the discussion was, quite frankly, so if you're going to go out 120 days, what do you do at day 121?
Yeah.
And they're still alive?
Or day 31.
Well, I know it says they go back. It's just that aspect of what are we really doing if we're going back and forth? I'm just telling, you guys know how committees work.
Thank you, Madam Chair.
Hoy.
And I did, I wasn't familiar with this, so I just looked up the supplemental note, and it does say after 120 days that they, if they do not pass away within that 120 days, then the release can be revoked. But it also provided information on the fiscal note that said KDOC indicates approximately 10 people per year could be eligible for consideration if the period is extended to 120 days. Currently, they receive approximately 1 application per year under the 30-day period. So it does seem like a limited number of people that this does impact, and we could maybe be impacting a few more with that extension.
Yes, Representative Hoffman.
Thank you, Madam Chair. If I'm remembering rightly, the 120 days is the start of when they can make the petition, I think. And is that right, yeah. Representative Heiberger? Yes. And that's part of the issue, is that 30 days is, that's such a short time period that usually it's not. So I'm not sure they'd be out 120 days. It would probably be somewhere less than, but I do understand how committees go too, I understand.
Right, and also from a healthcare standpoint, you're going to have a better idea 30 days out. You are not necessarily going to know that 120 days out. That is going to be a very difficult call.
Well, I would point out that most states have a period of 6 months or longer for policies like this. But so much for these.
Yes, Senator Foscato.
Thank you, Madam Chair. So, Representative, in this legislation, is it the release for the medical reason? Is it terminal?
Yeah, a physician must certify that the inmate is likely to die within.
But my question is it for only inmates who were lifers, sentenced to life, or could it be anyone, and their only eligibility requirement would be that the illness is terminal?
Actually, for a lot of lifers, they're not eligible because it's limited. It doesn't apply to off-grid felons and a few other categories. So, no. Again, there's a category, a revisor might be able to answer this for me. That I believe it's people convicted of off-grid felonies who are not eligible, and it may be a little broader than that. So those would be people with life sentences and who do not qualify. Well, so much for the easy one. I would withdraw this and save it for tomorrow, and I've taken too much time already, and I'll wait for tomorrow.
Now let's go ahead and go to the next one.
Well, my next one would have been the bottom one on page 3, but we're having a presentation on that tomorrow, so I'll skip that. But
The bottom of page 3?
yeah, but I think we should wait until after we hear the presentation tomorrow for that one. That's
Okay.
And then from our agenda today, I think I was impressed by both of our morning presentations. I'd like to have us reiterate our support for 2575 regarding criminal record expungements.
Could you say that again?
Yeah, I would like us to have us renew our support. I'm not sure where it is in the pink sheet, in the purple sheet, but I believe we did express some support for at least the concept behind 2575 regarding criminal record expungements, which we heard about in our first presentation. Right, this would be for applying to not guilty findings and dismissals. I believe our first presentation this morning addressed HB 2575, and I believe it passed the House.
Judicial Council.
Yeah, it was a Judicial Council bill, and I believe it passed the House. Is that correct or not? House committee, passed out of House committee and didn't go anywhere.
It passed out of the House committee, but it wasn't ever voted on. Is that correct?
Okay, right.
Okay. Do we have any comments, discussion? Representative Hoffman? No? Representative Smith, were you about to say something on that? Okay. Yes, Representative Carlin.
Yes, and there were other, I don't know what 2575 actually said, but my notes, we were talking about the word conviction in there needing to be cleared up. But didn't we talk about a lot of things to do with expungement? Are we going to write our own new bill, or do we have, is this bill it?
That is just a bill that was mentioned by Representative Heiberger, that was mentioned this morning in the presentation.
It was mentioned this morning.
Now, are there other things with regard to expungement that this committee might want to recommend? That would be appropriate. Did you have something that you wanted to mention?
I would have to really think that through, but I thought the conversation included a lot of ideas that we were interested in, so we maybe need to take a broad look at that from our notes, what things. I will talk about that tomorrow.
Okay.
That's okay.
Senator Corson.
I don't need to speak on it, but if you are looking for a second for Representative Heiberger, I would second that. I am supportive of it.
Of 2575?
Yes. If that's a motion that you're looking for a second on, I would be glad to second it.
Okay. Is there any opposition to 2575? I'm seeing none. So we have that on the list. To support that bill. Senator Bowers.
Thank you, Madam Chair, and that was on my list too, so thank you. I also heard with this list also, House Bill 2226, the automated system, which it sounded very expensive. I think we should be putting that on our wish list of things down the line that we'd like to look at. So maybe a refresher or post-audit request somehow to look at the Utah plan she had mentioned. That was the automated system of in and off, and I thought that was a really good idea. Where she had mentioned Utah was one to look at. Pennsylvania also used it too, and then in that conversation was clean slate or set aside that Colorado, Nebraska did. So somehow if we can research and review those ideas, it certainly could be something further down the line with funding too that we can be building up to that, because it sounded like a very positive plan. And I will be WebExing in tomorrow, so those are my two ideas I had wrote down as well.
So are you thinking of a legislative post-audit to explore what the IS requirements might be for an automated system, as well as, or are you asking legislative research to come up with some type of a spreadsheet that compares the Utah to Nebraska and a couple of the other systems that are in place?
Knowing that post audits are kind of hard to get and rather expensive, we could even have a topic in judiciary, but a starting point could be 2226. I'm not sure what happened to it in the House. The idea is out there, and perhaps we can dive down into the details if we have a hearing on that topic in our judiciary committees.
Okay.
I don't think it's an idea we should let go, because I think it's very positive, but it could be very futuristic also.
Okay. Yes, Representative Hoffman.
Thank you, Madam Chair. I don't know if on page 2 and Representative Owens might have some more insight on some of this, but there are several bills that I think, we talked about the sentencing grids last year, and there were several bills, and it looks like they died. Was there reasonings for that, or they just didn't get to them? Do you remember?
You may.
Thank you. Yeah, great question. So if you'll recall, I became chairman of this committee last year, and these were introduced the year before. So we didn't get back to them. Now, I do know that the Sentencing Commission will be making additional recommendations again this year. I was a bit surprised that we didn't see any of his recommendations in his presentation today, because normally he presents those here. So
Normally he does.
yeah, so this was a little bit different.
I will own that. I did not think, because I think if you will think back to the times that he has presented annually to this committee, it's been an hour-and-a-half presentation where we go through all of these bills, and that's part of the reason we have this summary, because every year they get introduced and they go nowhere. So part of what I wanted us to focus on was what things do we think we can truly control and work toward accomplishing this upcoming legislative session. I'm less interested in us going to our separate committees and having hearings on a bill that go nowhere, that are going to just die in committee. And I really think if we could be very strategic and goal-oriented on what are things that we think we can implement that will truly impact juvenile justice and truly impact what's happening in corrections. And I guess you'll notice that there was a little bit of a leaning toward, it's not just they go to prison, but most all of the Kansans that go to prison are released from prison? And what are we doing to make sure that they're ready for that release time and to be an active part of our community? So that, that's part of the reason that we talked about substance abuse treatment. That's part of the reason we had the workforce training panel. It's a heavy lift, but we saw examples of how that heavy lift has been so successful and important. And that's what we have to focus on, is how do we assure that we're going to have outcomes? And we did see yesterday in the drug court, it's not a quick, easy fix. It's going to be sometimes a slow, painful process. But as long as we have folks like the judge that we saw yesterday, and all of, the other side of the courtroom was filled with all those support folks, and that's not all of them that are involved, just those that were involved on the one individual that spoke to us. It takes a whole lot of heavy lifting from a lot of folks for us to get to that point. One person, and it's one person at a time. But we did hear from parents and how important it was to be with their children at Thanksgiving, or I've got the bed so that next week my kids can stay with me. That's how they take one step at a time to move forward and get those kids back. And they seemed supportive. I appreciated the commendation that the one individual received from the judge because he was helping someone else in the program that was injured. And so a total stranger, but through the program, now they're not strangers, but trying to support. So when we look on page 2 of all of those recommendations from the Sentencing Commission, are there 1, 2, or 3 that jump out at you that we really should be working to address?
Well,
Representative Owens?
I would just say that.
You can't say all of them.
No, don't worry. I won't, because that's a whole different conversation. But I think that without knowing what the Sentencing Commission is going to recommend, because they realize some of the same things. I sat in on their meetings for a couple days, even though I'm not on that committee, because they realize that they introduce them every year and they don't go anywhere. So they were trying to be much more targeted themselves with their recommendations. And so I'm hesitant to just accept any of these without knowing what specifically they want to recommend.
Okay. Then perhaps we do need some language that we will be watching for the recommendations, the cold, narrowed recommendations coming from the Sentencing Commission, and that their recommendations will be informed on those that in the past have not received hearings or come out of committee. Representative Carlin.
Madam Chair, yes. Jason, I believe, didn't we discuss the offender registry passing or not passing? And I thought it passed, but it didn't. The registration modification that we offered this year, I believe it passed the House, but it didn't go anywhere in the Senate. Is that what you told me? I don't know. Pardon me? Died in committee? Okay. Well, I thought we voted. It's 2092 apparently. Oh, I'm sorry, Natalie.
That's okay. Thank you, Madam Chair. There were a couple different proposed changes to the offender registry this last year. So Senate Bill 366 did pass.
Okay.
And the portions, there were kind of 2 big pieces on that. One of them was the off-ramp for the drug offender registry, which we talked about this morning. And then the other piece of that was adding breach of privacy, internet trading, and child pornography, and aggravated internet trading and child pornography to the registry. So all of that passed in one bill last year. But the Judicial Council did introduce their big offender registration reform recommendation piece of legislation, and that did not pass.
Just too much to swallow, I think. So I do think that that's an area we should look at.
Okay.
Thank you, Madam Chair.
Is there a particular area with that recommendation on the on the,
Actually, I was concerned about the juveniles, and I think the emphasis today was from the testimonies were on juvenile registrations that follow them for life, and it just seems really unfair. I thought we had a really good explanation from the psychiatrist about why it should be considered. I would like that to be on our list.
okay, so Representative Owens, are you going to speak to that?
Yes.
Okay, Representative Owens, then Representative Hoy, then Representative Heiberger.
Trying to keep it all together. Thank you, Madam Chairman. Woman, I agree. I think that I would like to see two separate things as it relates to registries. One is addressing the juvenile part, and that being a lifetime registration. Second to that, I would like to see us try to take another step on the registry. And what I mean by that is last year, so these recommendations have been around for quite a while, but very similarly, they get introduced and they go nowhere because they're trying to take such a big bite at the apple. So I pared that down and said, let's just create an exit mechanism for drug offenders. And we were able to push that through, even though it was kind of like pulling teeth. I thought maybe if this committee would like to kind of help with that, we can't take a step this next session to create an exit mechanism off of the violent offender registry that is similar to the drug offender registry. Now, you will see that I'm not trying to jump on creating an exit mechanism for the sex offender registry, because I think if we try to take too big a bite of the apple, it'll never go anywhere. But I thought maybe if we could just take that next step on the violent offender registry and say that, okay, if people have been rehabilitated for 5 years and they meet these kind of same criteria and they haven't been getting in any more trouble, so forth and so on, that we could create an exit mechanism for that. I'm open to thoughts on that.
Committee, any thoughts on that? Representative Smith.
I'm absolutely for that idea, if we have to do it one step at a time or the other. But you're right, it's hard for folks to get their head around that idea because they immediately go to the SVP, they go to the murderer, they go to these things. So we have to be very clear about what it is we're going to support and put that out front, right? So it's a single, maybe it's a person whose history is a single charge. Maybe it's a person who has 12 years on their clean record before they can apply. Things like that need to be out front, I think, if we're going to get anywhere. So do we define that out front, or how do we do that?
Well, I think that that's a great idea, if I may, and maybe we could have Natalie take a look at that, more specifically the violent offender registry for tomorrow, and just come back to us with the specifics. This is who goes on it. And maybe we as a committee can identify who we want to create a mechanism for, because maybe it doesn't apply to all. Maybe we just need a little more information on that.
And if we could also find out how many folks do we have that are maybe in the last 5 years been incarcerated for something like that? Is that possible? Can we find violent offenders? Yeah, how many registered?
Yeah, so Madam Chair, I can definitely walk you through the who goes on the violent offender registry and how that works. We would have to either, maybe someone from research could ask the KBI more about how many people have been added to the registry who are violent offenders.
Okay. All right. So are we okay that we will hold tight and get some more information tomorrow on that? All right, so next up I have Representative Hoy.
Thank you, Madam Chair.
He did have a
Oh,
juvenile
I
piece.
lost my little
No
thing
lifetime.
again. This thing does not want to stay on there. Sorry, everyone. We'll just wait on that because it's not. I wanted to circle back on the juvenile registry issue, and sorry, this is cracking me up. I really appreciate the intention to put things forward that we can accomplish and get done, but there also is some value to having hearings and getting more information out. This platform isn't going to be as big as like during session, and I think we all, at least I did, learned a lot, and helping to educate our constituents about problems that can occur and try to prevent juveniles from ending up on the registry anyway. If maybe they don't understand this process and what their actions mean. But I did find it disturbing that we have this public list of children, and think that we should. I don't know what the bill number was on the overall reform that was suggested. I'm not sure if the juvenile registry is included in that. Is there an existing bill anywhere, or is that something that we would have to have drafted? Well, we would reintroduce, obviously, but there may be existing language out there, or is this going to be something new that hasn't been brought before a committee before?
So we do have existing language. I guess I'm going to circle back. So Representative Owens, you had from the juvenile no lifetime registry. So how do you feel that squares up to what she's speaking to, where there would be no public registry on sex offenders?
Juvenile, only, I'm
Juvenile
referring,
sex
yeah.
offenders.
Yeah, I think that I want to think on that just a little bit more, because I was thinking we want to make sure that there's no lifetime inclusion. I understand the public registry piece. I want to think on that a little bit more before I issue an opinion.
Okay. Representative Smith.
That's going to touch on the controversial subject of foster care and kids going from home to home that came up last time. And so that's going to muddy the waters on that as well. So it's just something to consider how we approach that as well.
So, Representative Hoy, did you have a response?
No, I'm just open to, well, I guess, yes, I'm open to exploring this further and think that additional hearings, and maybe we can find some sort of legislation that prevents it in the first place. But that is a very valid point. But if people can come together and give us that information, I would be interested in having more conversations about it during session.
I think part of the issue when we're talking about foster care kids, so if they haven't had a behavioral or mental health evaluation, and we know kids are going up to 3 to 6 months without that evaluation after they been put in the system, which means they're not receiving any support services. We are creating an environment to, the term recidivate isn't even appropriate, but to react out. That's the muddy water that we're talking about. So was there a question over here that, no?
No, I'm good.
Okay, no questions. So yes, Senator Dahl, and then
Just towards the, go ahead. I'm
no,
sorry.
Senator Dahl, and then we're going to go back to
Okay, I
Representative
thought we were
Heiberger.
kind of concluding. I just wanted to make a point that I don't think it's fair to the committee that I'm on this committee, because I'm not on the committee during session. And so, you're talking about this thing to bring it home. It's got to get through committee during session.
You can always come and testify, but we also,
I'm just trying to be fair to you
your
guys.
voice matters.
Okay,
There
well,
are many layers. It's talking to folks that are on the committee. It's making sure that we have a hearing in the committee. It's coming and testifying. It's also talking to your colleagues. So I don't discredit the fact that you're not on judiciary, because when I was first on this committee, I wasn't on judiciary either.
Well, I think me and Sydney both need to go.
Yeah, you don't get a pass out, sorry. from one teacher to another. I know what you're trying to do. It's Representative Heiberger, and then we'll come back to you, Representative Carlin.
Well, one critical part of last year's offender registry bill was the penalties for noncompliance. I think we heard this morning that you could have a misdemeanor sexual offense and put you on the registry, and you could not, if you don't pay your registration fee on time for a couple times, pretty soon you're looking at a level 3 person felony. And and it was also pointed out that 5% of our prison population is offender registry violators. I really think that's a critical piece that we need to take a look at. So I would encourage us to take the pieces regarding penalties for failure to register from the bill that didn't make it last year, that the committee members addressed this morning.
Well, the judge did address that, and one of the things that he spoke to was that notion of that universal. So to go into 3 different jurisdictions, I like the idea of the one-stop shopping, but I want to hear from someone else that has an opposing view to that. To me, it's like we're creating hoops almost with the intention that we know we're going to get you. And then the penalty, I forget which of you asked the question. One of you did ask the question, is it possible that the penalty is going to be more severe than the actual crime ever committed? And now we're getting into something that's very illogical. I'd like to say crazy, but that seems hurtful, so I won't use that word. So I think we're in agreement to that. I think we need to, between now and tomorrow, figure out how far we want to go with that. Are we willing to say, is it one universal, and is that still quarterly, or is that annually, or what is that? Senator Corson.
On this, I almost think that we can either bundle them together or break them into separate recommendations, but they seem sort of separate. I mean, I'm hearing there's one piece about just reducing penalties. So that's like a reducing the penalty piece, and that's sort of one issue. And then a second issue is single point of registration, and that's entirely separate from penalties. And then you have the single point of registration. And then we talked about, could you create a process for an offender to essentially like a hardship process to be able to get that $20 fee waived? And that's sort of a third bucket. So I mean, I view it as 3 separate items that we could make one recommendation because they all deal with registration violations, but I think that they're separate ideas. And the Judicial Council had them broken out into separate points. So I don't know if that's an easier way to think about it, or if it's easier to separate them, or easier to just chunk them all together as registration. But there's the penalties, there's single point, and then there's like a hardship waiver.
Representative Heiberger.
It seems like it would be easier to deal with them as one bill. I mean, whether we make it 3 recommendations or not, but I'm not sure what the revisor would prefer, but.
I sense it's going to get bundled no matter what.
Well, I think we put them together. I'm fine with that. I just think we mentally, they're sort of separate.
They are.
But I think we should put them all together in one recommendation.
Representative Carlin, and then Senator Fascadell.
Well, I think I agree with Senator Corson's thinking on that, because, and what we've done today is we've had such an excellent discussion, both from our committee and the presentations. And as Representative Hoy said, this has been so educational that we do need to present these items to our committees, whether they fail or not. The public is then aware that we know these things exist, and we can make political hay of something that doesn't get a hearing. If we think it's valuable, that's part of our job. And I do think that whenever we have any of these recommendations are in a committee, if we could get a notice if there's going to be a hearing, or if we need to go individually to that chairman and say, we need a hearing on this bill, and here's why. We could be more active if we were kind of better informed about timing of the issues. We all have all-day work. I've all day, every day, I'm full, but I can skip.
And I think I'm going to say thank you for what you just shared. Because one of the things that we were really supposed to talk about, and we're gonna kind of wrap this up for today, but that committee, the statutory duties and obligations. And we already know, because our revisor shared with us the 3 components that are obsolete. But there is a component that we could put in there. And that is the component, you know, all kinds of other groups are mandated to present to different committees. But we don't have that formal process where representatives from this committee will go and share, these are our recommendations and why. So if we had folks from the House come to Senate Judiciary and share, we serve on this joint committee, and this is what are our recommendations. And then vice versa, if we had folks from the Senate go to the House, again, it is sharing with the rest of the individuals, we spent time. And let's be clear, all of you made sacrifices to be here yesterday, today, tomorrow. One, not so much for tomorrow. But think of the folks that, I'm just kidding. Our support team that's before us. Meredith is sick, so she's listening from afar. But Meredith and Lindsay have spent months coordinating for this to happen for us. You don't get a panel discussion. You don't get to go to drug court and do the things that we've done so far without all of that teamwork to figure out, and it's been puzzle pieces to get people arranged to come and speak to us. But we have to likewise, if the LCC is going to give us 3 days of work, they expect us to do the due diligence. By the end of tomorrow, we will have done that. But it takes it a step further, and we must share that with our colleagues. And so perhaps we need to work on some language as far as what our responsibilities are when session starts, to share that message to them so that it becomes abundantly clear with a chair. It isn't always going to be a chair that's sitting on this committee, but that expectation, you're going to hear this information, and there's a reason that we're going to ask Judiciary, House and Senate to be looking at what we have with regard to violent offenders or for juvenile sex offenders, is because we've already done the preliminary vetting. Now we have legislation before us. More eyes are looking on it. Join us in this process. But corrections, I mean, one of the most interesting things I learned was early on. The largest organization that provides mental health services in this state is Department of Corrections. So when we talk about mental health, even as wanting as we feel perhaps that mental health treatment is in the state, they're the largest provider. So they're going to need more assistance with that. But I think we do need to focus on what perhaps might we add to the obligations of this committee, because we're not all going to be here. I mean, who knows what next year and the year after will bring. But we need to make sure that this standing joint committee really has the oomph to get a bill passed. Not just funding passed, but actual legislation that's going to help move us forward. Everyone has come forward. You know, this is one of those rare committees where not everyone said, well, if you just gave us more money, but they're talking about what they're doing, and they just want to do more of it. And all of them have come and have thanked us. How rare is that? Usually that's not what we get in a legislative committee, is a thank you. But they are thanking us and sharing what it is that they're trying to do, and it's pretty amazing what they're doing. Yep, Representative Hoffman.
Thank you, Madam Chair. With that in mind, and maybe research can give us, I know we're giving you all kinds of stuff to do, but before tomorrow, but so like the Bob Bethel Oversight Committee, the Welfare Oversight Committee, some of those, is there a mechanism in the law that says that they are to, I guess, verbally give a report to certain committees in the legislative session? And you might know that offhand, I'm not sure, but.
I don't think so.
Okay.
Doesn't mean we can't.
No, that doesn't mean we can't. I was wondering if there was something we could take off of one of those other ones, so.
Yeah. Mm-hmm. Committee, any other discussion? It's been a long day. It's been a good day. We've heard lots of good information. Rest up for tomorrow. We do work pretty much through the breaking point. We're not going to have tons of time tomorrow. But after our break, we will jump right in to our discussion as far as making recommendations. So, you know, with daylight savings time, it certainly gets dark early, and we want everyone to be able to drive home safely tomorrow. So committee, we're adjourned for today, and we'll see you at 9 tomorrow.